Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy
They
there.
got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their court.
The fireworks are not done.
Now we're getting commentary on the case. Dahil mihianggagan po rin, verbal
That is literally not true.
Oh, for Trump's sake. I didn't ask you to interrupt me.
Is that correct?
Good morning, welcome. Welcome to the Court of Public Opinion. I am the Recovery Addict. Happy Monday to you. It is Monday. Hope you had a fantastic 4th of July weekend, if that was where you live and what you do. Let's see, is everything working today? It is. Schmoopy, congratulations. Schmoopy first in chat this morning. Congratulations. No flash photography. It's still a little early. No flash photography, please. Oh, yeah. Oh, welcome. The mic is just hot today. I don't know what I've done here. It's smoking. All right. This is a busy week. Lots of things happening. Amanda, thank you for this. As we kick off this week, know that there has been just heavy news out of Texas for the last several days, as the whole weekend, due to catastrophic flooding, and I have not seen the updated death toll, but I know it's climbed just so high, and so many of those are children. But understanding what happened there it's mind blowing. Imagine living in a very dry place like Texas, and having a river which is normally, low that you can walk over, rise 27 feet in 45 minutes. You just can't wrap your head around it, and unfortunately, it was not expected and just devastating. Death toll 83 now. Oh my goodness, 83 is the death toll. Do keep Texas. Curring, that whole area, campers, the whole community in your thoughts and prayers. That would be much appreciated. Where are we this morning? I thought my weekend was interesting. Got to go down to celebrate the 4th of July down in Wilmington, North Carolina, which is on the coast. And got to check off a bucket list item. Got to be on the beach when a named storm came in. And so we enjoyed about an hour on the beach watching a wall of wind and water come at us from way off, spinning in. And then when the wind finally hit us, it was just like a cold blast of air. And we're like, okay, that's our signal, go. And we packed up everything just as quick as we could, and running through the sand, dragging metal detectors and kids and shovels and all that stuff, and made it to the car about 15 seconds too late, when that wind just slammed us and just the sky opened and just drenched us. In 15 seconds we were soaking wet. It was but it was impressive. It was the most amazing, beautiful sight. It's bad when the lifeguards abandon the beach. They left before we did, and that was just a crazy experience. All right, a couple things to go over this morning before we begin court, because it starts in about 10 minutes. Let's see. First of all, Britta Aller, thank you for your wonderful support during this difficult time. It's a great community to be part of. Please keep the prayers coming. Britta, thank you for sharing. Let us lift the load a little bit if we can. Appreciate your support. Another OG, 26 months. Thank you very much, Britta. Hopefully, brighter days ahead. Kelly H. gifted a membership. Thank you, Kelly, for the way to kick off the live stream. Indy Cindy, member for 25 months. Recovery Addict's #1 YouTube membership to keep and enjoy the most. Indy Cindy, thank you. Congratulations. 25 months, over the 2-year mark. Also at 25 months, Kim R. Kim, with the Dolphin. Back with the Dolphins. Yay, 25 months. Continued prayers for Texas. Thank you, Kim. Katsy, member for 18 months. Prayers for Texas. Yes, and not just prayers. There is an official fundraising option if that is something that you're in a situation where you're able to contribute. There's I wish I could remember it off the top of my head. There's one specifically that's been mentioned in the press releases, and that's the one I wanted to talk about. But there's one, I pulled it up on Facebook and now it's gone. Where did I put it? The Community Foundation, I think it's called. The Community Foundation is the one I heard about. I believe the mayor of Curran was talking about, but it's on Facebook, called the Community Foundation. Katsy, prayers for Texas. Thank you. Thank you very much. Those are much appreciated. I'll join with you on that. And 18 months, Katsy. Thank you. Thank you. Shelly Kelly, one of my besties, lives in Kerrville. So scary. Oh, my goodness. Unbelievable. The level of damage, it's right up there with hurricane, with major natural disasters. I mean, this is, equivalent to a dam bursting. Just unbelievable. Rick Groover, member for 19 months. My best membership since my record club days. Oh, back in the day when they'd send you an album you didn't want every month. Fanny Pack member for 18 months. Welcome to the gallery, Fanny Pack. Thank you much. Also, Stephanie, member for 16 months. It's been a blast. Thank you, Stephanie. Appreciate that. This is going to be a wild week. A wild week for me because this is my week that I go up to Virginia Thursday morning. So Thursday and Friday, no live stream. I'm going to Virginia to film, and it's going to be raining the whole time. And I have all this gear that we need to take up there to use and make it work. And most of it, especially on the audio front, cannot get wet. So how we're going to make a movie in 3 days in the rain with no audio, I don't know. I don't know how we're going to do that. I can switch cameras. I can switch to waterproof cameras. I've got plenty of those. But it's going to be a challenge. So anyway, let's check and see if there are any birthdays to celebrate this morning, so we can get that underway, get the party started. My 4th of July, it was great. We were going to watch the fireworks in Wilmington at the stadium, and Jen got a headache, and we thought, let's just check into the hotel. We were staying at, I realize it's only 2 hours away, but we were staying at a hotel because we had to pick up our son from a camp down there like 7 o'clock in the morning. So we got a little hotel at the Holiday Inn, and we got the 3rd floor facing what is known as the battleship direction, but we're a few miles back. We're literally looking. We have planned this. I'm like, we will have a perfect view of the fireworks from right here. Our hotel window is going to be like the picture frame, the fireworks. There's a tree that I just about cut down Friday night, right outside the hotel, because all the fireworks, every single one of them, happened just behind the tree. We could not see a single thing from the window. It was so bad. Oh my goodness. Oh my goodness. All right, let's see. It's been a week and a half for sure. Like the shrubs, but I was going to cut it right at the bottom. Right at the bottom. We were far enough away that the finale happened. It was like a 30-second finale, and as soon as it stopped, then all the explosions for the finale hit us, and it's like 30 seconds of just boom, 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 because we were miles away. It wasn't 30 seconds, but it was like the finale ended, and then it was pretty cool. Sidebar and Chill, member for 12 months. 1 year ago today, my wife and I made a great decision. Best place to watch court on the tubes. Thank you. Sidebar and Chill, thank you. Thank you very much. We're gonna be going to court here in just a second. Trust me, we're watching. We're keeping an eye on it, but nothing yet. So let's see. Any birthdays? Oh, and Cash App, thanks for the messages. I have not responded yet, but I need to. Let's see if we have any birthdays. Turn that clicky off. There we go. coming to my neck of the woods next weekend. The weather's going to be awful. Stay safe. Melody, thank you. Thank you. The last time this type of, it's a church group, a youth group reenactment, happened up there that I'm aware of. It made the news, and the first night everybody had to be rescued in four-wheel drive vehicles and hauled down off the mountain. And yeah, I'm looking forward to it. It's going to be great. It's going to be fun. What could go wrong? Heather from Texas, let me see what your message is. Hang on just one second. Are we going to get Verdict music on my birthday today? Heather from Texas, maybe. I'm just hoping we get to deliberations. These instructions have taken forever. All right. Thank you, Samantha, for the birthday message. We have Screaming Grass and Heather, if there's anyone else that needs to be added. Let's see. It's mine, my twin sister, and my best friend Laura's B-Day. Kate Tastrophe. Can we add Kate Tastrophe to this list? My twin sister Brona and my best friend Laura. So we'll add Kate Tastrophe, Brona, and Laura to Screaming Grass and Heather. Okay, let's see if I can do this. This is hard work. Grab this one. Copy. Paste. Because I'm all about copy and paste. And then grab this one. Catastrophe. I probably should add the apostrophe too. I'm the world's slowest typer. Catastrophe, Brona, Laura, and Heather. There we go. I got it. Look at this. I did it. Somebody probably beat me to it. Oh, and add Kemp. Okay, we need to get the birthday song going here, or else we're going to be late. We're going to put Kemp right here on the end. Okay, now we're good. All right, here we go. Everyone take a deep breath, shoulders back. Oh, thank you, Samantha. Got it as well. Screaming Grass, Laura, Heather, Kate, Hemp. Yeah, okay, we got it. I think I've got everybody. Take a deep breath, shoulders back. Project your voice to the back of the room. Blend your voice with your neighbor. Warm up with me, if you will. La 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 la. There we go. We're gonna sing Happy Birthday to Screaming Grass, Kate Tastrophe, Brona, Laura, Kemp, and Heather. Happy birthday to you. Happy birthday to you. Happy birthday, dear Screaming Grass, Kate Tastrophe, Brona, Laura, Kemp, and Heather. Happy birthday to you. Holy cow, that was close. Screaming Grass. Screaming Grass. That was terrible. Catastrophe, Brona, Laura, Kemp, and Heather. Happy birthday. Realize this is your special day. Of all the places we could be, the million people you could have chosen to be with, the million places you could have been, you chose to be here with us. The privilege, the pleasure, the honor is ours. Hopefully we can make your day a little more better. Make it specialer. By returning that joy back to you, begin by helping yourself to free pancakes at Denny's, IHOP, Village Inn, Waffle House, McDonald's, Tammy Dunlap's house, Andy's Grill, Bob Evans, and guess what? I think Cracker Barrel has them as well. So there you go. Happy birthday. We're going to let the dancers do their thing here just for a minute while we get ready for court. Uh-oh. We've got to fade it out. No drum solo today. The judge preempted our celebration. There we go.
Today to continue on with the trial of the state of Connecticut versus Raul, Valle. I would ask counsel to please place our appearance on the record for purposes of today's proceedings.
Good morning, Your Honor. Mark Dershall for the state of Connecticut.
Good morning, Your Honor. Tatiana Messina for the state of Connecticut. Good morning.
Good morning, Your Honor. Kevin Smith for Mr. Valle, who's at my side.
Good morning. Is everyone all set to call the jury and to continue with the charge?
Yes, Your Honor.
Yes, Your Honor.
Thank you. Good morning, Your Honor. Tatiana Messina for the state of Connecticut.
We're going to back up just a
Good morning, Your Honor. Kevin Smith for Mr. Valle, who's at my side.
Good morning. Is everyone all set to call the jury and to continue with the charge?
Yes, Your Honor.
Yes, Your Honor.
Thank you.
We're syncing audio here. Hold on. And stand. 2, 1.
Welcome back, ladies and gentlemen of the jury. Thank you. Counsel, please stipulate to the return of our juror.
State will stipulate, Your Honor.
Defense stipulates, Your Honor.
All right, so before I continue with the jury charge, I just want to thank all of you for your continued attention to the proceedings, as well as your continued attention to arrive here timely each and every day. So I know it's been quite some time. You've been very diligent about getting here and being attentive to the proceedings. So I appreciate that very much. So I wanted to thank you for that. At this time, when we adjourned on Thursday, we were going through the court's instructions as to the law that you are to apply to this case. I am going to pick up where the court left off, and that is at count 4, assault in the second degree intentional, Connecticut General Statute, Section 53A, 68-2. The state charges the defendant at count 4 with assault in the second degree, charging that in the county of Fairfield in the city of Shelton on or about the 14th day of May, 2022, at or near 43 Laurel Glen Drive in said city, the defendant, with intent to cause physical injury to one Faison Teal, did cause physical injury to the said Faison Teal with a dangerous instrument, to wit, a knife, in violation of Section 53A 68-2 of the Connecticut General Statutes. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when, with intent to cause physical injury to another person, he causes such injury to such person by means of a dangerous instrument other than by means of the discharge of a firearm. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, intent to cause physical injury. First element is that the defendant specifically intended to cause physical injury to another person. A person acts intentionally with respect to a result when his conscious objective is to cause such result. We'll refer to the court's previous instruction on specific intent at 15. Physical injury is defined as an impairment of physical condition or pain. It is a reduced ability to act as one would otherwise have acted. The law does not require that the injury be serious, it may be minor. Element 2, caused physical injury. The second element is that the defendant caused physical injury to another person. This means that the defendant's conduct was the proximate cause of the person's injuries. We refer to the court's previous instruction on proximate cause at 14. You must find it proved, beyond a reasonable doubt, that Faison Teal was injured as a result of the actions of the defendant. It does not matter whether it was the person upon whom the defendant intended to inflict physical injury. It is sufficient if you find that the defendant intended to cause physical injury to another person and that he in fact caused physical injury to that person or some other person. Element 3, with a dangerous instrument. The third element is that the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. Dangerous instrument means any instrument which, under the circumstances in which it is used or attempted or threatened to be used, is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article is capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation and even though harmless under normal use may be found by you to be a dangerous instrument if, under the circumstances of its use or threatened or attempted use, it is capable of producing serious physical injury or death. The state need not prove that in fact death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant had the specific intent to cause physical injury to another person, 2, the defendant did cause physical injury to Faison Teal. And 3, the defendant caused the injury by means of a dangerous instrument other than by means of the discharge of a firearm. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree intentional, you shall find the defendant not guilty of the crime of assault in the second degree intentional at count 4, and you shall then next consider the lesser included offense of assault in the second degree reckless. You'll proceed to the court's instruction on lesser included offenses to assault in the second degree intentional below. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, then you shall next consider the defendant's claims of self-defense and defense of others. Refer to the court's instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree intentional in violation of Connecticut General Statute, Section 53A 68-2 at count 4. This will end your deliberations at count 4. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree intentional at count 4, even though you have found the elements of that crime proven beyond a reasonable doubt. This will end your deliberations at count 4. Lesser included offenses to assault in the second degree intentional. In accordance with the court's previous instructions, you will consider lesser included offenses to assault in the second degree. If and only if you have unanimously found the state has not proved beyond a reasonable doubt all of the elements of the crime of assault in the second degree intentional, and therefore that the defendant is not guilty of assault in the second degree intentional at count 4. The defendant at count 4, the substitute information, is specifically charged with the crime of assault in the second degree intentional. The offense of assault in the second degree intentional under under our penal code is such that it may include the elements of the crime of assault in the second degree reckless. Similar to my previous instructions on lesser included offenses, this brings into play the rule of law known as lesser included offenses. You will consider lesser included offenses to assault in the second degree intentional in the order and under the circumstances as provided herein. The fact that I am instructing you on a lesser included offense to assault in the second degree intentional as to count 4 should not be interpreted by you that I believe the evidence proves the accused guilty of any lesser included offense. You, the jury, are the sole judges of the facts in this case. You must determine whether the defendant is guilty beyond a reasonable doubt of assault in the second degree intentional or is guilty of the lesser included offense. If and only if you unanimously found that the state did not prove beyond a reasonable doubt all the elements of the crime of assault in the second degree intentional, and that the defendant therefore is not guilty of assault in the second degree intentional at count 4, shall you consider the lesser included offense of assault in the second degree reckless directly below at subsection A. A, assault in the second degree reckless, section 53A 68-3. The statute defining this offense reads in pertinent part as follows. A person is guilty of assault in the second degree when he recklessly causes serious physical injury to another person by means of a deadly weapon or a dangerous instrument. For you to find the defendant guilty of this charge, the state must prove the following 3 elements beyond a reasonable doubt. Element 1, recklessness. The first element is that the defendant acted recklessly. A person acts recklessly with respect to a result or circumstances when he is aware of and consciously disregards a substantial and unjustifiable risk.
We are getting near the end of the instructions here as far as the charges go. There are going to be some general instructions afterwards, but we're getting close to the end.
Element 2, cause serious physical injury. The second element is that the defendant caused serious physical injury. This means that the defendant's conduct was the proximate cause of the person's injuries. Refer to the court's previous instruction of proximate cause at 14. You must find it proved beyond a reasonable doubt that Faison Teal was seriously physically injured as a result of the actions of the defendant. Serious physical injury is something more serious than mere physical injury, which is defined as impairment of physical condition or pain. It is more than a minor or superficial injury. It is defined by statute as physical injury which creates a substantial risk of death or which creates serious disfigurement, serious impairment of health, or a serious loss of impairment of the function of any bodily organ. Element 3, dangerous instrument. The third element is that the defendant used a dangerous instrument in causing serious physical injury to another. Dangerous instrument means any instrument, article, or substance which under the circumstances in which it is used or attempted or threatened to be used is capable of causing death or serious physical injury. Serious physical injury means physical injury which creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. It is important to note that the article need not be inherently dangerous. All that is required is that the article was capable of causing death or serious physical injury under the circumstances in which it was used. Any article or substance without limitation and even though harmless under normal use may be found by you to be a dangerous instrument if under the circumstances of its use or threatened or attempted use it is capable of producing serious physical injury or death. The state need not prove that, in fact, death or serious physical injury resulted, only that the instrument had the potential under the circumstances. In summary, the state must prove beyond a reasonable doubt that 1, the defendant acted recklessly, 2, the defendant caused serious physical injury, 2, faisant teal, and 3, the defendant caused the injury by means of a dangerous instrument. If you unanimously find that the state has failed to prove beyond a reasonable doubt all the elements of assault in the second degree reckless, you shall find the defendant not guilty of assault in the second degree reckless at count 4. This will end your deliberations on count 4. If, however, you unanimously find that the state has proved beyond a reasonable doubt all the elements of the crime of assault in the second degree reckless, you shall next consider the defendant's claims of self-defense and defense of others. Refer to my instruction on self-defense, defense of others below at 22. If you unanimously find that the state has proved beyond a reasonable doubt that the defendant did not act in self-defense or in defense of others, or that the state has proved one of the statutory disqualifications beyond a reasonable doubt, you shall reject the defenses and find the defendant guilty of assault in the second degree reckless in violation of Connecticut General Statutes, Section 53A, 68.3 at count 4. This will end your deliberations on count 4. If, however, you unanimously find that the state has failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or in the defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then, on the strength of the defenses alone, you must find the defendant not guilty of assault in the second degree reckless at count 4, even though you have found the elements of the crime proven beyond a reasonable doubt. This will end your deliberations on count 4. 22, self-defense, defense of others.
Here we go. This is new.
The defendant has offered evidence in this case that he acted in self-defense and or the defense of others. Self-defense and defense of others are two separate but related defenses. Although the court is instructing you on both defenses under this section, the defendant is entitled to and must be given by you a separate and independent determination as to each defense under each count. After you have considered all the evidence in this case, if you find that the state has proved beyond a reasonable doubt each and every element of a crime to which self-defense, defense of others may apply, you must go on to consider whether or not the defendant acted in self-defense. In this case, self-defense and the defense of others applies to all crimes charged in the substitute information under each of the 4 counts, along with the lesser included offenses to each of those crimes at each count. In other words, self-defense and the defense of others applies to all offenses submitted to you for deliberations. The statute defining self-defense, defense of others reads in pertinent part as follows. A person is justified in using reasonable physical force upon another person to defend himself, a third person, from what he reasonably believes to be the use or imminent use of physical force. And he may use such degree of force which he reasonably believes to be necessary for such purpose, except that deadly physical force may not be used unless the actor reasonably believes that such other person is using or about to use deadly physical force or inflicting or about to inflict great bodily harm. The determination of whether a defendant reasonably believes physical force to be necessary to defend himself, someone else, from what he reasonably believes to be the use or imminent use of physical force by another individual is one, whether the defendant actually believed that the other person was using or about to use physical force or deadly physical force against him, a third person, and two, whether a reasonable person in the defendant's position, knowing what the defendant knew and being in the same circumstances, would have had those same beliefs. Whether the defendant's belief was reasonable is a question of fact for you to determine based on all the evidence presented. The acts of the other individual, James McGrath at count 1, Ryan Hines at count 2, Thomas Connery Jr. at count 3, and Faison Teal at count 4, leading to the defendant's use of defensive physical force, need not be an actual threat or assault. The test is not what the other person actually intended, but what the other person's acts reasonably caused the defendant to believe was the other person's intention. The state's burden. When evidence of self-defense, the defense of others, is introduced at trial, the state, in order to obtain a conviction, must prove beyond a reasonable doubt both the elements of the crimes charged and that the defendant did not act in self-defense or defense of others. If the state fails to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, unless the state proves beyond a reasonable doubt a statutory disqualification, as discussed further below in this section 22 at statutory disqualifications to self-defense, defense of others, and statutory disqualification to the use of deadly physical force, you must find the defendant not guilty, despite the fact that you have found the elements of the charged crime proved beyond a reasonable doubt. The defendant has no burden of proof whatsoever with respect to this defense. Deadly and non-deadly physical force. The law distinguishes non-deadly physical force from deadly physical force. Deadly physical force is justified only when a person reasonably believes that such force is necessary for the defense of oneself or others against the use of imminent use of deadly physical force or infliction or imminent infliction of great bodily harm. Deadly physical force is physical force which can reasonably be expected to cause death or serious physical injury. Physical injury is an impairment of physical condition or pain. Serious physical injury is a physical injury that creates a substantial risk of death or which causes serious disfigurement, serious impairment of health, or serious loss or impairment of the function of any bodily organ. Imminent means that the person is about to use physical force or deadly physical force at that time and not at some unspecified future time. The physical force used by the defendant need not actually have caused a death or a serious physical injury in order to be considered deadly physical force, nor need it have been expected or intended by the defendant to result in such serious consequences. Instead, what determines whether the defendant used deadly physical force is whether the force actually used by the defendant could reasonably have been expected to cause death or serious physical injury. It is up to you to determine, after considering all the evidence, whether the defendant used deadly physical force or non-deadly physical force against James McGrath at count 1, Ryan Hines at count 2, Thomas Connery Jr. at count 3, and Faison Teal at count 4. If the state claims that the defendant used deadly physical force, the state must prove that beyond a reasonable doubt. In addition, the state may prove that the defendant's use of force was not justified if it can prove beyond a reasonable doubt that while the defendant may have believed that he needed to use such force, his belief was unreasonable in light of all the circumstances known to him at the moment. Whether the defendant's belief in the need to use such force was reasonable is a question of fact for you to determine. However, a person must use no more force than he reasonably believes is necessary for such purpose. Statutory disqualifications to self-defense and defense of others. In addition, the state can defeat the defendant's claim of self-defense or defense of others by proving beyond a reasonable doubt one of the statutory disqualifications to self-defense, defense of others. The statute defining self-defense, defense of others describes certain circumstances in which a person is not justified in using any degree of physical force in self-defense, defense of others against another. These circumstances include provocation and initial aggressor, as more fully instructed below at subsections A and B below. A, provocation in accordance with Connecticut General Statute Section 53A-19C1. Provocation is one such circumstance under which a person is not justified in using any degree of physical force in self-defense, defense of others against another, when he provokes the other person to use physical force against him. In order to provoke the use of physical force by another, it is not enough that the defendant, by his conduct, elicited the use of physical force by another. Rather, the defendant must have embarked upon such conduct with the specific intent to provoke the other into using physical force and intending to cause the other physical injury or death. The defendant must have specifically intended to provoke another into using physical force and then used force to defend himself from the ensuing use of force by the person provoked. It is important to remember that the defendant has no burden whatsoever to prove that he did not provoke James McGrath, Ryan Hines, Thomas Connery Jr., or Faison Teal with respect to their respective count into using physical force against him. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that the defendant provoked the use of physical force by James McGrath, Ryan Hines, Thomas Connery Jr., and/or Faison Teal with respect to their respective count against him. B, initial aggressor in accordance with Connecticut General Statute Section 53A-19CB. Another circumstance under which a person is not justified in using any degree of physical force in self-defense, defense of others against another, is when he is the initial aggressor in the encounter with the other person and does not both withdraw from the encounter and effectively communicate his intent to do so before using the physical force at issue in the case. Under this provision, the state can prove that the defendant was not justified in using physical force in self-defense, defense of others, by proving beyond a reasonable doubt that he was the initial aggressor in his encounter with James McGrath, Ryan Hines, Thomas Connery Jr., and/or Faison Teal relative to each of their respective counts, and that he neither withdrew from that encounter nor effectively communicated his intent to do so before using physical force against them. To prove that the defendant was the initial aggressor in his encounter with James McGrath, Ryan Hines, Thomas Connery Jr., and/or Faison Teal relative to each of their respective counts, the state need not prove that the defendant was the first person to use physical force in that encounter. The initial aggressor can be the first person who threatened to use physical force, or even the first person who appeared to threaten the imminent use of physical force under the circumstances. To prove that the defendant did not withdraw and communicate his intent to do so, the state must prove that he did not abandon the conflict in such a way that the fact of his withdrawal was perceived by James McGrath, Ryan Hines, Thomas Connery Jr., and/or Faison Teal relative to each of their respective counts, so that they were aware that there was no longer any danger from the original aggression. It is important to remember that the defendant has no burden whatsoever to prove that he was not the initial aggressor or that he withdrew from the encounter and communicated his intent to do so before he used physical force against James McGrath, Ryan Hines, Thomas Connery Jr., and/or Faison Teal relative to each of their respective counts. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that he was the initial aggressor, did not withdraw from the encounter, and did not communicate his intent to withdraw before using physical force. Statutory disqualification to the use of deadly physical force. In addition, the state can defeat the defendant's claim of self-defense by proving a statutory disqualification to the use of deadly physical force. The statute defining self-defense, defense of others, describes certain circumstances in which a person is not justified in using deadly physical force in self-defense, defense of others against another. The exception applies only to the use of deadly force. So if you have found that the defendant used deadly physical force, you must consider this the exception of duty to retreat at A below. A, duty to retreat Section 53A 19B1. A person is not justified in using deadly physical force upon another person if he knows that he can avoid the necessity of using such force with complete safety by retreating. This disqualification requires a defendant to retreat instead of using deadly physical force whenever two conditions are met. 1, a completely safe retreat is in fact available to him, and 2, he knows that he can avoid the necessity of using deadly physical force by making that completely safe retreat. The law stresses that self-defense, defense of others, cannot be retaliatory. It must be defensive and not punitive. The term complete safety, as used in the statute, means without any injury to the defendant whatsoever. A person acts knowingly with respect to a circumstance described in a statute when he is aware that such circumstance exists. It is important to remember that the defendant has no burden whatsoever to prove that he could not have retreated with complete safety or that he didn't know that a safe retreat was possible before he used physical force. To the contrary, you may only reject his defense on the basis of this statutory disqualification if you find that the state has proved beyond a reasonable doubt that he did know that he could retreat with complete safety. In summary, if you unanimously find that the state has failed to prove beyond a reasonable doubt any of the elements of a crime to which self-defense, defense of others may apply, you shall find the defendant not guilty and not consider self-defense, defense of others. If you unanimously find all the elements of a crime to which self-defense, defense of others applies have been proven beyond a reasonable doubt, you shall then consider the defense of self-defense, defense of others. If you unanimously find that the state has proven beyond a reasonable doubt that the defendant did not act in self-defense, defense of others, or has proved one of the statutory disqualifications beyond a reasonable doubt, you must reject the defenses and find the defendant guilty. If, on the other hand, you unanimously find that the state failed to prove beyond a reasonable doubt that the defendant did not act in self-defense or defense of others, or has not proved one of the statutory disqualifications beyond a reasonable doubt, then on the strength of the defense alone, you must find the defendant not guilty, despite the fact that you may have found the elements of the crime proved beyond a reasonable doubt. Sympathy. In deciding whether the defendant is guilty or not guilty, you should not concern yourselves with the punishment or potential consequence in the event of a conviction. This is a matter exclusively within the court's function under the limitations and restrictions imposed by statute. You are to find the defendant guilty or not guilty, uninfluenced by the possible punishment or consequence that may follow a conviction. You should not allow any display of emotion by counsel during the trial to draw upon your sympathy. There is no place for sympathy in your deliberations. You should not be influenced by any sympathy for the defendant, the defendant's family, the decedent's family, the complainants, or for any other person who might in any way be affected by your decision. Implicit bias. As I indicated earlier, your verdict must be based on the evidence introduced in court and my instructions on the law. Our system of justice depends on judges like me and jurors like you making careful, unbiased, and fair decisions. During our interactions with other people, it is not unusual for us to group or categorize people. Sometimes these categorizations involve negative or positive biases or prejudices, which may be conscious or unconscious. Such preferences or biases, whether they are conscious or unconscious, have no place in a courtroom or your deliberations, where our goal is to treat all parties equally and to arrive at a just, fair, and unbiased verdict. All people deserve fair treatment in our system of justice, regardless of their race, national origin, religion, age, disability, gender, gender identity, sexual orientation, education, income level, or any other personal characteristic. Techniques that you can use as jurors to check whether any unconscious biases are influencing you include slowing down and examining your thought processes thoroughly to identify where you may be relying on reflexive gut reactions, and to consider whether you are making assumptions that have no basis in the evidence. Ask yourself whether you would view the evidence differently if the parties, witnesses, or attorneys had different personal characteristics. In sum, your task is to render a verdict based on facts drawn only from the evidence introduced in the courtroom and from the law as stated in my instructions to you, and not based on prejudice or bias or against any party or person involved in the trial. Duties upon retiring.
Here we go.
In conclusion, I press upon you that you are duty-bound as jurors to determine the facts based on the evidence as it has been presented, to apply the law as I have outlined it, and then to render a verdict of guilty or not guilty as to each count. When you reach a verdict, it must be unanimous. That is, all 12 of you must agree on the verdict. As a check that your verdict is in fact unanimous, the clerk may ask each of you to individually announce your verdict in court. It is the duty of each juror to discuss and consider the opinions of the other jurors. Each of you takes into the jury room your individual experience and wisdom. Your task is to pull that experience and wisdom. You do that by giving your views and listening to the views of others. There must necessarily be discussion and give and take within the scope of your oath. That is the way in which a unanimous verdict is reached. Despite that, in the last analysis, it is your individual duty to make up your own mind and to decide this case based on the basis of your individual judgment and conscience. Note-taking. If you took notes during the evidence, you may use them during deliberations, and you may discuss your notes with your fellow jurors. Remember that notes are merely aids to your memory and should not be given precedence over your independent recollection of the evidence. If there is a conflict between your recollection and your notes or the notes of any other juror, it is your recollection of the evidence that must prevail. Your notes or the notes of any other juror are not evidence. You will recall my earlier definition of what constitutes evidence. Your verdict must be based exclusively on evidence presented at trial and the principles of law given to you in these final instructions. A juror who has not taken notes should rely on his or her recollection of the evidence and should not be influenced by the fact that other jurors have taken notes. Notes are only a tool and not always accurate. Do not assume that a voluminous note-taker has taken notes that are necessarily more accurate than your memory. You may discuss your notes with your fellow jurors during the deliberation phase. The decision to do so is yours and yours alone. After the trial is concluded, all notes will be collected by court staff and destroyed. In closing, I remind you that you have the right to request portions of the testimony to be read back to you if you deem it essential during your deliberations. You will have all the admitted exhibits with you during deliberations. You may only deliberate when all 12 of you are present in the jury room. Inform the judicial marshal or court officer when you have reached a verdict, but do not tell him or her the verdict. You will be asked to return to the courtroom where your foreperson will announce the verdict orally in response to questions from the courtroom clerk. The rest of the panel will be asked whether they concur with the verdict. If you have any questions, please send them out as a note signed by the foreperson marked with the time, and please be as specific as possible. You will have the exhibits with you during your deliberations. We will also send in with you a computer on which you will be able to view or hear digital evidence with instructions on how to use the computer, which will be marked as a court exhibit. You will also have with you in the jury room a copy of these instructions entitled Jury Charge, which will be marked as a court exhibit. I remind you, however, that you should follow all the court's instructions and not single out some and ignore others. They are all equally important. Do not begin deliberations until you have selected one of your members to be the foreperson of the jury and you have received the jury charge, the substitute information, the device, instructions on how to access the device, and all fully admitted exhibits. So at this point in time, I am going to ask the jurors to please step out and go into the jury room for a brief moment. I do have to make some comments on the record. Do not begin your deliberations just yet, as the alternate jurors will be in that room with regular jurors. So please remain silent just for a few moments as a jury panel, and I will be bringing you right back into the courtroom. Thank you.
So Connecticut already has probably one of the longest jury instruction, just by how verbose they are. They're repetitive. They use detailed explanations. Add to that lesser includeds, and it just exponentially multiplies the length of jury instructions. But the jury is not quite ready. She has to put something on the record, probably about some fixes to the instructions. If everyone's happy with how they were read.
Counsel, any questions, comments, or exceptions to the court's charge?
Nothing from the state, Your Honor.
Not from the defense, Your Honor.
Okay,
All
they're good
right,
with it.
and it's a good thing we told them just a brief moment. We'll bring the jury back in, please.
They're back.
Thank you.
I don't know why she couldn't have asked them that question and then excused the jury if there was an exception, but, you know, Connecticut. The jury is about to start deliberating. First, they find out who was an alternate. So,
Wait out one more, Your Honor.
Thank you.
jury didn't even get to sit down.
All right. Ladies and gentlemen of the jury, at this time I am going to ask all regular jurors to please stand. If you're a regular juror, please stand. Alternate jurors, please remain seated.
Well, they knew they were
Regular jurors,
alternates.
I'm going to direct you to the deliberations room. You're going to go into the room. You will be deliberating shortly. I will ask you to hold off until such time as you have all the exhibits. You've selected a foreperson, you have the substitute information, and you have my jury charge as well as the device and the instructions, okay? So I would ask all regular jurors to please go into the jury room. Once you have all of those documents and the device, and you've selected a foreperson, you can begin your deliberations on this case.
So we're going to start our timer as soon as they leave and shut the door because we don't know when they're going to get their laptop. It could be seconds after they arrive. It could be waiting for them. It could be half an hour.
The alternate jurors, please just be patient with the court for just a moment. Thank you. Madam Clerk is going to state your name and ask you to stand just to be confirmed.
We're going to turn that off. We don't want to hear the names of the alternate jurors, so we'll keep the audio off just for a little bit. We'll keep that down there. All right, so jury finally gets to deliberate, and the first thing they're going to say is, what the heck is wrong with those jury instructions? That
trial. I know
could have been an
it
email.
can be somewhat frustrating to hear the evidence and not participate in the actual deliberations, but you do perform a very important function by being here, and we appreciate that. Now, while it is unusual, alternate jurors are sometimes called upon to take the place of a juror during deliberations. For that reason, I am going to ask you to go back to the jury assembly room and report back to that room and remain there every day until such time as there is a verdict. The same instructions are going to apply to you as I've repeated them throughout the trial. Do not read, listen to, or watch anything about this case. Do not speak to anyone or let anyone speak to you, not even the other alternates or one of the primary jurors. Do not make any private investigations or do any research. When there is a verdict, we will bring you into the courtroom so that you can hear what the verdict is. So I apologize for this, but it has happened. So I am going to ask you to please abide by your oath. I do continue to appreciate the service that you are giving us. It is an extremely important one. The marshal is going to escort you to the jury deliberations room, and I will ask you to continue to report here daily back to the jury deliberations room. The clerk will update you throughout the day. And once there is a verdict, you'll be brought back in to hear the verdict. Thank you so much. Thank you. Okay. Counsel, at this time, I am going to ask you, please, to meet with Madam Clerk and make sure that all full exhibits are going to the jury and that only full exhibits are going to the jury. Please make sure that the latest substitute information is going to the jury. Also, please check the instructions for the device. Please make sure that you are okay with those instructions. I did ask you to look at the exhibit list to make sure that you're okay with the description of each exhibit. If you are, then we'll mark that and we'll have that go in as well. And then I will just state for the record that there were two things in my charge that I caught while reading the charge. I intend to make that change. I believe they were both under self-defense. Yes, they were. Under initial aggressor, B was before using physical force against, and it was them. I had to add them. And then there was also at the end, in describing statutory disqualifications, just added, and I did do it on the record, beyond a reasonable doubt. All right, so I will make those two changes, and I will submit that to the clerk as an exhibit, our final exhibit, to go into the celebration. Was there something else?
Nothing from the state, Your Honor.
Nothing from the defense, Your Honor.
All right, so then we're going to take a brief recess, and I'll come back on the bench just to confirm that you've gone through the exhibits, and I'll hear any issues, and then I'll have Madam Clerk deliver all of the exhibits and the device.
So technically, we should not start.
Take a 10-minute recess. Thank you.
Maybe the jury is going to go select a foreman right now. That might be what they're doing right now. Chris Dias missed you. Happy birthday to you. Happy birthday to you. Happy birthday, Chris Dias. 43. Happy birthday to you. There you go. Didn't miss you anymore. Happy birthday. With that, I think we're gonna hold tight because we know they're coming back in 10 minutes to discuss the paperwork to make sure everything's right that the jury has received. But the jury cannot deliberate yet, which is just, it's wild. It's absolutely crazy that they're still here. The jury instructions took longer than the defense case, and almost as long as prosecutor's case. This was a long one. No, it was only 2 days. Yes, it felt like much longer. But a lot of jury instructions. I do think that the length of the jury instructions is a disservice to the jury. While I do think that jury instructions need to be detailed enough that they have clear instructions, these are so detailed and so complicated and so repetitive that it is very easy to get lost in them. And I'm worried that those complicated instructions would end up in having an all or nothing result, as opposed to a lesser included of some sort. I think they would just be like, I don't want to go through the mental gymnastics it would take to figure that out. But all right, we're going to do some court hopping while we wait. And so that's going to be over here. Let's see. How are we going to do that? Run on 7? I think we're going to run on 7. Let's see. Hang on. I think we're going to go over to Judge Middleton. need him on 2. Let's bring this on. Sorry, technical difficulties. Got to rear audio here.
Thanks for joining us tonight for the news at 11.
Okay, we've got audio on that one. All right, there we go. Fixed it, sort of. Selena K, thank you very much for gifting a membership. Love it. Kim, you're the lucky recipient. We do have a poll up right now. How long is the jury going to deliberate? So feel free to answer that one if you have not already. We've got options from between 2 hours to sometime tomorrow or beyond. There's Judge Middleton. All right, let's see if we can jump in on Judge Middleton really quickly. Good morning, Judge. How are you doing? We caught him surfing the web. Keep the timer up here. Supposed to be doing misdemeanor sentencing today. Mr. Magoo has new charges. Is he in front of Judge Simpson still? He's back from vacation already. It was a short one. He's a busy judge. Doesn't get much time off. This is one judge, just 2 different cameras. But usually when he's doing this quiet computer Minecraft, whatever, is a Minesweeper? Usually during these low moments, he talks to us as well. Well, this is a different judge from the case that we've been watching for sure. Fix the timer.
We're just waiting for you guys.
Oh, okay. I'm here. Fine's here.
Okay. Now,
Tim's here. And see Tim in the corner.
Kimber's,
you guys all come over here.
Oh,
Kimber's 26 months. Thank you, Kimber's.
All right, I'm gonna shut this off. Thank you.
What? Judge, we were waiting.
everybody.
We sat here for nothing. He's going to kill our live
You know,
stream.
my favorite tiger was Dick McCall. I think I run for a long time because I didn't. Everybody was 20 minutes late, but we're all here now. Is anyone going to come from your office?
I think Sashi was coming.
All right. Okay, I want to unlock the screen, turn on the record. All right, this is the time and date for sentencing
Oh, he's
in
not
two
leaving us.
matters.
That's good. That's good.
I'll do them one by one, but everybody is here at the council table. Jalen Earl Hodgins is here with his lawyer, Timothy George. Good morning, Mr. Hodges.
Good morning.
And Darren Earl Hodges is here with his lawyer, James Mequio. We've also got several people here who have interest in the case. In the gallery, prosecuting attorneys, victim staff is here. I was given a letter from Destiny Church, which I shared with the parties, and I was just given 4 or 5 character letters on behalf of Darren Hodges, which I laid on the prosecutor's bench. Anyway, this is unpleasant. Every time I look at this, it made me cringe. Saw one down at a children's baseball game, and as bad as that sounds, that happens all the time. Every summer we get parents fighting at football games or baseball games or soccer games, or and every time it makes me cringe. Anyway, Jalen Hodges was originally charged with assault with a dangerous weapon, assault and battery, disturbing the peace, and domestic assault. He entered a plea to domestic assault, and the prosecutor's recommendation was that he be deferred under the domestic violence deferral statute. And so we're here. The prosecutor's staff had been very good at trying to keep me up to speed on what was going on. And then late this morning, I saw the victim impact letter that was written. I provided a copy to Mr. Mequio. Did you see it, Mr.?
I have not seen it.
Mr. Mequio, could you share that with him?
Sounds like a terrible situation.
All right.
Someone died in a
Having
fight at
said
a kid's
all that,
baseball
let's
game.
start with you, Mr. George. What would you like me to know?
Well, thank you, Your Honor. I think that the court, squeeze over here. The court's right. I mean, this is a situation that unfortunately does happen often. As the court knows, my client does have 3 children in common with Ms. Swartz. So I think that the prosecutor's recommendation would be a good benefit for my client. This is I think the best way to put it, it is a tumultuous situation between my client and the mother of his children. He advises that there's been a lot of this back and forth. He hasn't seen the kids since this happened, even though there is a parenting time order that is in place. I know that that is an issue that is currently going through the front of the court process, but he's going to have to be able to have some communication with Ms. Swartz until the children are at the age of majority. And I think that the ability for him to access the resources through an anger management and a probation would be beneficial. I know that through his employment at Fiber Converters, he's talked about some of the services that are available and meeting with a counselor. And I know that I don't think anything is set in stone yet, but that is something that he's working towards. So I think he is taking this really seriously, and I think he would benefit from that probation. My client doesn't have any type of criminal history. That's what's, a little bit kind of frustrated about this whole process. It looks like this was just something that had been boiling up over time. Unfortunately, these things happen, but again, I think that the benefit for him would be to be able to access those resources on a probation. I do think that if the court were to think that any type of jail time would be appropriate, we'd ask that it be deferred over the course of the probation to see how he does. Again, he does have full-time employment that will be 2 years of employment this coming September. So we'd ask the court to sentence my client to probation and defer any jail time over the course of that probation. Thank you.
Thank you.
I think it was a fight. I think
you
the
didn't
judge
get a
said somebody
chance to
died.
see that
It's just a fight.
victim impact statement. I got it. I don't know when I saw it, maybe 9:30 or so when I came in on a break. But you can review it there, and the complainant is here. Ms. Davis has joined us now. Ms. Davis, we started with Jalen's and then we'll go to Darren's. I laid several letters of recommendation that were handed to me about 2 seconds ago on behalf of Darren Hodges. This is Jalen's. As I indicated, the plea was to domestic violence with prosecutors, no objection to a deferral. I think I mentioned this at the time of the plea. In a domestic violence case, I can't do a deferral unless the prosecutor accepts it. In a drug case, I can. In some other cases, I can, whether the prosecutor agrees or not. But in a domestic violence case, I can only do it if the prosecutor concurs. And for the most part, they do because they know what it entails. It entails a probation and a domestic violence treatment class, and no drugs and no alcohol and no assaultive behavior. Your father went through one of these when he was young, and he successfully completed it. So the charge becomes at that point non-public. You don't have much of a record. You had some sort of a false pretense a few years ago and maybe a traffic ticket, but no assaultive stuff that I was able to discern. Ms. Davis, you wish to speak to that at all?
As my understanding, is scheduled for 11 a.m. So
I thought they were both for 10:30.
Yeah, I think mine said 10:30, but
they were on our calendar for 11, so I apologize.
We started 20 minutes late, and so I didn't know what happened. I just thought you were caught up in something else.
Well, we were with our new APA being sworn in. So, this case from the beginning has been difficult. Anytime there's children that are involved and right in the mix, and children that are there at a ball field, and other parents and grandparents and people, it certainly elevates the factors where you want to make sure that there's some sort of punishment and that this doesn't happen again.
Evidence they're sending back there.
Both the women are here, and would you like to speak, either of you?
When reading the statement,
if you'd like to.
I'll read mine.
Okay. This has been very difficult for them. It's been very difficult on the kids. I'm sure, as Your Honor is aware from the statements that were sent in. And certainly, the letters on behalf of Mr. Hodges, Darren Hodges specifically, stating that he's a good friend, he's a good person. The choices that were made on this day were terrible. And it's something that, our goal is to rehabilitate the relationship between the children and their grandparent and father, and the co-parenting relationship. And that's where the probation part of this is going to be key. After meeting with the victims, I'm not certain that this is going to, quote unquote, stick with Jalen. Your Honor said Darren Hodges did this years ago. Maybe a refresher course on that, because this type of behavior is not acceptable ever, let alone in front of dozens of small children. So
yeah, this was horrifying for everybody that was there. And I mentioned this before you got. This happens all the time. Several times a year, parents are fighting over their children at a sporting event. Shame on all of them. And so we've seen this over the years, and I'm sure everybody was there didn't like it. All right, good morning. Would you state your name for the record, please?
Carly Danielle Schwartz-Friesen.
All right, and you're the mother of the children involved here?
Yeah, stepmom.
Stepmom?
Yep.
All right, so you're not their mother, you're their mother's wife?
Yep.
Okay, go ahead.
This is Jalen. Victim's personal reaction. I am scared to go to bed at night. My anxiety is so high. I don't ever feel safe. I'm always checking my doors to make sure they are locked. I am so worried for myself and my children, and I'm very traumatized by all of this. Jalen threw rocks at my head and back. I had a headache for a few days. And then says victim's property loss. I lost time coaching my boys' baseball game as I'm banned from all Centerville parks. My children lost time playing in baseball, softball, and I'm not sure what I wrote there. To be repaid. Oh, I'm asking for that to be repaid. And then I would like $270 refunded due to all the time lost. And then it says sentencing, and this has been a reoccurring issue, and I believe Jalen Hodges should serve some time so it can show him the seriousness of his actions. And I have one for Darren. Do you want me to read that one now, or do you want me to wait?
Yes. No, you can go ahead. You're not the named complainant in the charges that they pled to. You may have been one of the charges, but I believe the charges.
Yeah, she was one of the charges.
Which one?
Darren Hodges choked me and threw me to the ground.
Just a minute. Let me go to Darren's thing.
Count 2, Your Honor. It's the domestic violence allegation.
Lena, thank you very much. OG, 21 months.
Now, I got a lengthy one. No, that's not that.
So just trying to see what specific charge she's speaking to. And it sounds like she was definitely involved, but the charge might have been dropped. Sounds like everybody's banned from the baseball field.
Pled no contest to count 2. Assault and battery on Kaylee Swartz. So it's not a domestic violence, it's an A and B, but that is correct, Ms. Davis. Carly Swartz Friesen is the complainant in Darren's case, but not in Jalen's case. I'm sorry, so go ahead.
For Darren.
Yes.
I am extremely affected. I can't sleep very well. I have horrible dreams. I keep replaying the crime in my head. It terrifies me daily. My children are having night terrors. My daughter has been sleeping in my wife and I room since this crime happened because she is so scared. I am so scared that I'm constantly locking my doors during the middle of the day. My body is strained from the assault and adrenaline. I also got a cut on my right elbow and a scraped and bruised knee. I'm having discomfort in my hip on my right side after being thrown to the ground.
Nobody died in this incident.
Then,
it was just a fight.
Property loss. My phone was damaged after I got thrown to the ground. The value of my phone is about $529.99. I lost my coaching position and the ability to attend my children's baseball and softball games. I have lost $273 that I have invested in my children's sport. And then, yeah, the total loss, I just said $273 is for Little League and $529.99 for the damage of my phone. And then I believe the sentence should have the same impact as the impact on myself and my family.
All right. Thank you.
I think he pled guilty. The mom, I believe, is present, but not sharing.
I did get the victim impact statement from the other complainant, which is the mother of the children. And hers is quite lengthy, and it goes into some details. That's from Courtney Friesen.
Yeah. Courtney would like her wife to read it because she doesn't feel comfortable.
All right. They've got it. All right, go ahead.
He's like, sorry to
may concern. On May 3rd, 2025, I was assaulted by my ex-boyfriend at Adams Park, Centerville, Michigan. Jalen Hodges is the father of my 3 children. Jaden Swartz, 8, Cameron Swartz, 8, Kylie Swartz, 6. Our daughter Kylie was being held in her father's arms as I was attacked by him. I was at Adams Park at 10:30 a.m. where my twins boys were playing a game. I dropped my wife Carly Friesen off because she was a voluntary assistant coach for the boys team and to drop off the boys baseball equipment. I approached Jalen, who was standing by the dugout, asking him where Kylie was because I offered to Jalen that I would take her to her game, which was being held at Wheaton Swanwick Park, Centerville, Michigan. Jalen told me she was already at her field. I asked who took her, and he told me it was none of my business. I left Adams Park and headed to Wheaton Swanwick Park, 1.2 miles away from Adams Park. I arrived at Kylie's game with her equipment. I saw Darren Hodges sitting in a camp chair watching Kylie warm up for her game. I did not talk to Darren the entirety of Kylie's game. After her game ended, Darren went to take Kylie to his truck. I was walking beside them calmly. We were splitting off to go to our own vehicles when Kylie told me she wanted me to take her to her brother's game because she wanted to watch them play. Darren persisted on trying to grab Kylie and telling her they were going to pick up Darren's wife from work. Kylie became uncomfortable and said she did not want to go with Darren, and she grabbed my hand and said she wanted to go with me. I told Darren I would take her straight to Jalen. I also voiced that in 2017, Jalen Hodges and I had a verbal contract stating that Jalen's parents were never allowed to be around our kids unless he or I were present. That agreement has been held all these years until the mid-year 2024. Before I could contact Jalen directly, Darren had already called him, but I did text Jalen as I was heading to Adams Park. As I pulled away from Wheaton Swanwick Park, Darren was following behind me in his truck. He sped through a stop sign into oncoming traffic, almost causing an accident to stay behind me. I arrived at Adams Park in 2-3 minutes and parked my car. Jalen looked visibly upset. I turned my car off as Jalen walked up to me. I got out of my car and turned to open my left passenger door to unbuckle Kylie. As I tried reaching for her car seat, Jalen started yelling and screaming at me to give him his kid. I tried to ask him to lower his voice and to calm down, and I was about to get her out of the car. Jalen continued to yell regarding my request, so I closed the car door so Kylie would not hear her dad yelling at me. I continued to ask him to please stop yelling and cussing. He refused. At this time, Darren walked around the front of my car with his phone up recording. As Darren arrived, Jalen seemed to be more agitated and angry. Darren started to join in with Jalen and began arguing and fighting with myself and Carly. The agreement gets more and more heated, and Jalen forced himself into my car, and that's when Kylie started screaming with terror. I then began pulling on Jalen's shirt, yelling, and begging him to stop because he was scaring Kylie and hurting her. Jalen yanked and pulled at her. Kylie was in a 5-point harness. Darren then grabs me and puts his hand around my throat, slamming me against the side of my car, squeezing my throat so I could not breathe. As Jalen was exiting my car with Kylie, who was still screaming in terror, Jalen then began hitting and punching me with his left arm while his right arm was holding Kylie. Jalen ran around Darren, who was still choking me, and tried running behind my car. I managed to pry Darren's hand off my throat and then went over to Jalen, begging him to just hand me Kylie. because she was terrified. I was terrified. I had blood dripping from my right arm above my elbow, and very visible red mark from Darren choking me. I tried grabbing Kylie's hand just to let her know that I was okay. But then Jalen yanked her away, causing me to pull Kylie's arm, so I released my grip on her to not cause any pain or injury to her. Jalen then moved to the front of my vehicle where people from the park and parents from the baseball game started gathering towards us. Cops were called and on their way. All three of mine and Jalen's kids have been intense nightmares about their death. Kylie is scared of the dark now and has to sleep in my room to feel safe. Kylie was waking up all hours of the night having nightmares for weeks. Luckily, the boys did not witness Jalen's attack nor Darren's attack on myself, but they saw arguing, me crying in fear for my daughter, their sister begging for her mom. Kylie stated, "I just want to give mommy a hug." The boys saw all the parents surrounding their dad and Darren. The boys ended up coming over to me after their game was shut down. They were concerned for their moms and their sister. The boys saw their dad get put in handcuffs, as did Kylie, who was released to come to me as Jalen was being cuffed. Kylie ran to me screaming and crying into my arms across the field. Cameron has had a reoccurring nightmare almost every night since the incident. I have experienced high anxiety, deep depression, and uneasiness. Any sound or thud makes me jump. I wake up startled and scared that Jalen will break into my home. This has affected my whole family and still does. All three kids are in therapy to help them cope with the incident. This is a horrible event, should never have happened. We can say that this was just an argument about parenting time, but it was not. It was a tragic, horrific day that has scared myself, my children, and my wife. I tried giving Jalen our daughter calmly. She was in my possession no longer than a couple minutes, but regardless, there were children all around us. My child, my baby girl, was in the middle of this and witnessed her father and grandfather hurt her mother and stepmother. I was with Jalen for almost 8 years, and I unfortunately cannot say this was a new experience with him, or the first time our kids have witnessed his intense anger. I feared that as the time went on, Jalen's aggression and lack of control would worsen, and I believe it has. I believe if this case is not handled correctly, Jalen will be heading down a very dark, aggressive, immature road, just like his father has. Jalen and Darren Hodges should both be convicted with a serious sentence. Hurting a woman and a child should not be brushed off. This is a very serious offense, and it has a huge effect on the physical and mental health of the victims.
Thank you. All right. Then I'm going to do Jalen's sentence, then we're going to go to Darren's. One thing I wasn't completely clear on, the parties were never married. They had 3 children together. The mother is married now, but she was not married to Jalen. Is there a custody and visitation order in place?
Yes, sir.
Through the court here in Centerville?
Yes.
And that particular day was your parenting time?
Yes, sir.
And so you had parenting time from when to when?
I had it from Friday at 6 till Sundays till 6.
And that's how it's been working for several years?
For 2 years now, yes.
All right, when I say parenting time, the kids actually stay at your house?
Yes.
And you're married now and in a...
No.
All right.
I live with my father and
your
mother.
All right. So grandma and grandpa are part of the kids' lives?
Yes.
All right, so this is a baseball game during his parenting time. And as such, they get to make paramount decisions about what happens to the kids. Nobody will give an inch. She wanted to ride with her grandma to where her dad was. And you're like, no, we have parenting time. So you can't ride with your grandma. Grandma won't give an inch. Stop.
It's the mom.
Mom. Mom won't give an inch. I want to take my baby daughter to where her dad is. You're not supposed to be in contact with your grandpa. Apparently that's not in the order. So everybody's hard-headed and it turns into this ugly fiasco in front of everybody at the baseball game. And It's embarrassing. Now, you haven't seen your kids since May. Ms. Davis hit this point, so did Mr. George. At some point, we got to have at least some situation where you guys can deal with each other, because you're stuck with each other until these kids reach the age of majority. Now, I was told Children's Protective Services was called. Did anything come of that?
CPS has been at our place, yeah.
It's an ongoing investigation. We are supposed to meet with Josh
Ferris.
And he has yet to contact me with a meeting date for that.
All right. So your custody order is still in effect?
Yes, sir.
But there's no contact provisions in here, so that's affected that. So I don't know the circumstances of their home or your home, but Judge Pattison or somebody did a visitation and custody order. And they aren't possessions, excuse me, or pets. They're children. And this was terrible for the children. Your granddaughter's getting yanked out of a child seat. The boys said this looked like WWE. They're embarrassed. And now you got no visitation, and as the time passes, you'll just grow farther apart. Their preference, I suppose, would be you would just disappear. Do you not have contact with your children and not be a part of their life? It sounds like things were not the greatest while you were together, but you were together long enough to have 3 children, and you're stuck with each other. So the prosecutors recommend, and this was also a no contest plea. So when you plead no contest, you don't admit what happened, but you don't deny it. So you allow or accept that a conviction will enter. So the facts are the facts that we use for the plea, which is the bond information report.
Your Honor, I believe my client pled guilty.
All right. And all right. So Jalen pled guilty. All right. So the domestics. All right. Thank you, Tim. All right. So I got to figure out what to do with Jalen. They would both like you to go to jail for a long time and go away. But I can't do that because family court's still going to be involved and protective service is going to be involved. You don't have much of a criminal record, a minor property matter. But everybody's in agreement that you could use the domestic violence treatment class.
Maybe a parenting class too. Those are always good.
Mr. George suggested deferring some days during the term of the probation. That's fairly common. I believe you have 2 days jail credit.
3.
You got arrested on the 3rd.
Yes.
You bonded on the 6th. You have 3 days credit. I'm gonna do a 12-month probation. Or 33 days jail credit for 3.
To serve some month.
Of the 33, 30 are deferred for your participation and cooperation with this. The fine is 0. You got enough to pay.
Doesn't serve any
There's a
time.
$75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, $480 probation oversight fee, and you pay for the class. DV class. It's beneficial. It has to do with anger, parenting, fatherhood, partnerhood, anger. One factor here, I didn't get any impression that anybody was drinking. So I don't think drugs or alcohol were a factor in this, just difficult family dynamics. No assaultive or threatening behavior. no drugs and no alcohol, and test as directed. Comply with all CPS. And parenting time orders. Gee whiz. Got another PPO. You're still at Fiber Converters?
Yes, sir.
If you complete this probation, this charge is removed from your record. And there's, right now, you can't use or possess a firearm. I don't know if you hunt, but you can't do that while this. If you complete the probation, the charge is removed as a public record of conviction.
Growing it out for the trip this week. Thanks, Melissa. Congratulations on 8 months.
As of right now, the no contact provision is going to be lifted.
There's a PPO now.
And there's a PPO that prohibits contact with the children.
And not with the children.
Not with the children, just with my wife. And then the bond conditions for both of them were
They're going to be lifted. So
Okay.
you're going to be legally entitled to contact with your children. That's going to be very difficult because you got to reestablish this. You're not going to get X'd out of the rest of your children's life because of this incident, but you're going to be on probation. You're not on a bond condition. There's a PPO that prohibits you from having contact with them.
Except for when we have pick up or drop off. It's stated in the PPO.
Yeah, all right.
Serious.
And I do have plans for someone to accompany me to pick up and drop off, so there's no more incidents happening.
That's probably all for the best. Right now, I take them at their word. Your kids are afraid of you. They didn't like this. Yeah, yes. And you're going to have to rebuild some trust with them. I'm not sure about the boys so much, but your daughter, this was frightening for kids. Let's talk about Darren Hodges.
This is Grandpa.
They've requested restitution for the fees for the kids for baseball.
That's a no. I might consider restitution for a broken phone. Tell me about that.
When Darren Hodges pushed me,
Well, I haven't done Darren yet.
That's I just.
No, I'm not going to do restitution for. They all got kicked off the thing, and they were all part of this thing. I may consider your phone, so we'll take that up.
Totally
on the next one. All right. All right. Darren Earl Hodges, the complainant in that case, read her statement. That's Carly Swartz Friesen. And we got a number of letters on behalf of Mr. Hodges, one from Pastor Jerry Solis of Destiny Church and some other letters from people that he worked with, and character references. One thing is I probably know Mr. Hodges better than the character references. When he was young, he was a frequent visitor here at the courthouse. He has at least 4 domestic violence charges in his past. Couple of malicious destruction of property charges and some other assorted things I won't get into. which are old. Pastor Solis told me that, and in the letter, he got connected with the Destiny Church about a dozen years ago or so. And I don't know that there's anything newer than that. So these people know him in the last 12 years, but he did have several assault offenses. One was deferred, one was turned into a disturbing the peace, one was some sort of other deferral. And, but he grew up, he had kids, got a job. Did you lose your job as a result of this at XL Machine?
Yes, sir.
All right, you went to jail and they just terminated you for not showing up?
Well, it escalated through other things that they said I violated a policy at work.
All right.
But I am employed now.
At where?
Cooper Damp and Waterproofing out of Middlebury.
Okay. Well, Mr. Mecrio, you know your client and this circumstance. Again, it was, nobody was willing to budge. It sounds innocuous enough. He's there with his granddaughter watching her game. She lives at his house. He's grandpa. Then everything went haywire. What would you like me to know?
Judge, I think you have a good grasp of everything that went on, and I think the fact that everybody was banned indicates that this was not an out-and-out attack or some sort of assault where somebody was totally victimized and run over with some sort of a criminal activity and had to be helped. This was a argument, this was yelling, this was screaming on both parties' ends, this was physical contact by both parties. But my client realizes what he did was inappropriate. And I think that's why he sought out the Pastor Solis, who is present in the courtroom here, showing his support, which I think is important and very telltale as to what kind of person Mr. Hodges is. He took responsibility, Your Honor. He entered his plea. He realizes that there was probably much better ways to handle an incident where his grandchildren and his son were involved in an altercation with a couple of women. He should not have touched anybody. He should not have put his hands on anybody. He realizes that. He's embarrassed as to how the community may have observed him that day and observed everybody that was involved in this case that day. I don't think it spoke very well for the way he wants his family portrayed. And I think that's why, Your Honor, he continues to work hard. He continues to seek employment. He now is in counseling. He's working with his pastor. He is stepping back, waiting to see what the family court does. It's my understanding the parties have a hearing in family court the 15th. So maybe something will happen in the next week or so that'll get the parenting time back on track and get everybody involved in a situation where they can communicate with each other without really upsetting anyone, realizing that the communication is for the children only and not for them. My client is prepared to do whatever the court wishes. I think incarceration at this point, Your Honor, would be unjust given what he's done. The 3 days he's already spent in jail. The court did make reference to his criminal history. I think that was approximately 20 years ago.
Well, the most recent thing he has on there, other than this, is 2014.
Yeah,
so I haven't seen him in 10 years. Yeah. I've seen him, but not here as a litigant in court.
And Your Honor would realize that someone doesn't avoid that type of contact unless he's made some change in his life that are very positive. He loves his grandchildren. He loves his son. I'm hoping something will work out where he'll be able to continue his relationship with his grandchildren. But other than that, Your Honor, if the court feels probation is necessary, we would ask the court to consider probation and defer or not impose any jail term, Your Honor.
Thank you. Ms. Davis?
I was just confirming the kids are in counseling and will remain in counseling. And, you know, having a background in family law and criminal law, they intertwine. And I don't think that people recognize how damaging their behavior can be to young kids, from babies all the way through teenagers. The way that these parties interact with each other historically seemed to be strained. And then it went from strained to really bad and assaultive. I disagree with Attorney Macchio's characterization of the kind of mutual combat type that he described. From what I understand from the victims and from viewing the video, this was aggressive behavior from the defendants toward the victims. And the reports that Darren Hodges was, running through stop signs and tailgating, and it just shows that aggressive, angry behavior that is not conducive to helping raise children. These kids are living in the home with him and his wife and their dad. If you're willing to do this in the public, it makes me wonder what you say about the other parties behind closed doors. So it just goes on both sides. The way that you frame your relationship with the other parties is how your kids are going to be able to heal. So I just encourage both defendants to get involved with the counseling, meet with the kids' counselors, so that they can rehabilitate this relationship and then get to the point where they don't have this type of animosity. Because whether you say something or not, if you're all in the same area and there's tension, the kids can feel it, and it's not fair to them. Thank you.
Can I
We
get
got
name?
birthday parties, school pageants, graduation, prom, all kinds of things these parents are going to have to weather together. And you're right on the money. The kids can feel it.
Oh, Judge, just as to the restitution, if the court's going to order, we'd just like more information as to what was damaged, an estimate as to what it would cost to repair the phone, that sort of thing.
Yeah, where does that, if I'm going to do a probation, I can reserve on the restitution, but we'd like some.
She turned in, did you turn in a copy to victim rights?
Yeah, I believe so.
Receipt?
Let me look.
Yeah, receipts, we have receipts, all of that, yeah.
I don't think I have it.
Should be attached to our paperwork there.
Let's take a look. I didn't scroll down far enough. And here's a bunch of those. I had looked, again, I was looking for the victim impact stuff. And I got it. It was in Jalen's file. I never received a new statement from Carly Swartz. I spoke with her end of last week. That was as of this morning. So whatever you sent, I don't have yet.
I think I can get them out of these.
All right, well, we'll reserve on it, but it's 542.
It's
529.
It's the iPhone 13. It's a very old phone. So really for the cost of a new one is about $529.99. It's about $600.
All right, but that, if you had a car that was broken, you don't get a new car.
No.
So there's a valuation question.
I will say that like the newer model of iPhones are like $1,700. So I mean, as far as
so I don't want to shoot from the hip. We'll get more information about it. All right. You had a suggestion, Ms. Davis, that maybe he could use a little tune-up on anger management. And I think maybe that isn't a bad plan. I'm going to give 12 months probation, which you could complete at the end of 6. 13 days credit 3. Of those 13 days, 10 are deferred. So you're not going to do any more jail time if you do what I ask you to do. I'm sorry that you lost your job over this, because I know people that work there that thought you did a good job. Same thing, the fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee. Attorney fee is none. There's $480 probation oversight fee to pay for the class. No assaultive or threatening behavior, and no drugs or alcohol. Test as directed. And again, I don't think drugs or alcohol were really a factor here. But if they were, it was under my radar. $605 plus the cost of the class. And restitution, we will reserve on restitution. When I place somebody on probation, I can amend it. I can change it. When I just do a sentence, for example, I just gave you 10 days in jail, I can't revisit it.
Wow, once you say it, it's written in stone.
Reserve on the restitution, so I can add restitution on the iPhone to the probation once I get more information.
Your Honor, how would you like to receive? I just checked, and the only thing I have is the receipts from the kids' baseball fees. So I believe it's potentially an email to our victim advocate. Do you want her to forward that to the
whatever
department?
Something. Did you purchase a new iPhone?
Well, like I'm paying it off, like
that
my
one that's
service.
broken.
Yeah.
Still? Okay, so you're still paying off the one that is broken and it's not usable.
I can use it, but it's got like a big crack all the way through it, and then it has those glasses peeling out of it, out of the bottom part of it. So I mean, it's usable.
So you can
but
replace the screen.
All right, well,
it's getting like my screen, glass shatters are coming out of it. So
all right, we're gonna have to figure out some figure. I'll order something as a partial restitution for that.
Okay, we're gonna make a jump here.
In Darren's case, he's not a parent; he's a grandparent. So I would say the same thing: comply with all custody and visitation orders.
Okay,
but
we're gonna make a
not
jump
going to be part of the order unless you are. I think the little tune-up on anger management could be beneficial.
Amen. Yes, all around. All right, jump. Here we go. We're gonna pop over to not this one. We're gonna pop on this one. On 8. There we go. We're gonna go over to Judge Dad. Josh says we've got something going on with Judge Dad that we need to see. How far back do we need to go? I can't remember his name. Judge, it starts with an M, right? Not Middleton, but help me out, Josh. I've got a brain fart. McNally, there it is. Judge McNally. Judgment Valley. That was close, Siri. Judge McNally. Judge Boyd. Judge Phyllis. Come on. Honorable Michael K. McNally. There he is. Found him. We're going to go back just a little bit on this one until these folks sit down. All right.
2532.
John Capitan, appearing on behalf of Granite Televalley.
Good morning, counsel.
Morning.
Do I have anybody here, Tammy Siggers?
No, Your Honor.
Counsel, you can go ahead and take a default.
All right, Your Honor, we request a default judgment of possession. This is a termination case. We ask that the court issue an order evicting the defendant if the defendant does not move out on or before July 17th.
Fine, thank you. Submit your order. This case was scheduled for 10:30. It's 11:33. I'll give you a writ date, enter a default judgment, writ date the 17th. Just make sure you submit that over here today, if you would, please, okay?
I will right away, Your Honor. Thank you.
Have a great day. Sorry to keep you guys waiting today. It's not going well.
Oh, no worries. I hope you have a better day.
Thanks.
All right, take care.
Are they ready on Concord? Have you chatted with Mr. Jones? Jennifer?
Judge, I've been trying to message Mr. Jones.
If he's not calling you, I'm going to pretend he didn't show up. They can't just show up like this and not answer and not call and expect that I'm going to wait all day for them. This is crazy.
It's crazy.
I mean, we've called this case before, I thought, too, did we not?
Yes, Your Honor.
Man.
And I've sent him a message to please unmute. I've done the
and send him one more. Send him one more. You need to call and then your number immediately. If he doesn't, when the lawyer comes back, I'm giving him a default. So now who do I have? I'm waiting on lawyers, right? Is Concord and Mr. Mayers here by chance, or is this
Mr. Mayers is not here yet, but he should be momentarily.
All right, let me take this other case here, see what these guys are going to do here.
This is the one we've seen before, I think.
Pittaway versus Pittaway, 2502023.
Pittaway versus Pittaway.
Come on up here, guys.
Family on both sides.
Mr. Pittaway, if you prefer to sit there, I have no issue with it if you want to sit at the table. And Ronald Pittaway.
It's all worked out.
Well, you got to tell me. Okay, I don't mean to burden you, but you guys filed lawsuits, not me. What's that?
I said I didn't file a lawsuit.
If your son was in here filing a lawsuit for you in your name without you signing it, I'm going to have a big problem here. Did he do that? Did he sign your name? Mr. Pittaway, I'm asking you a question.
I don't remember.
Well, let me just...
I imagine I did whatever.
Hang on. John, come here.
It's all worked out.
Fine. Good. What's your name?
John.
You got to tell me your full name for the record. Take this over.
Donald James Pittaway.
And what's your name?
Ronald Leonard Pittaway.
I want you to look at the complaint on the bottom of that document. Is that your signature?
This down here, is that what he's talking
about? Yeah. Is that your signature? I can tell it's the son's signature by the way the son looks. Mr. Pittaway, you know the great thing about doing this job is I can tell somebody who's untruthful from here to Idaho. You started filing a lawsuit, signing your father's name on these documents? Are you kidding me? Who do you think you are? Who do you think you are? Come on up here. Come on up. Yeah, you. Come on up to the podium. You, right there. Sit down, sir.
Sir, sit down. Sign your son.
What's your name?
Donald James Pittaway.
Junior? Or the second?
You can call me that. That'll work. The second.
You're the second?
Yes.
Did you file these documents?
Yes, I did.
Did you sign his name as though you were acting like him?
I signed my name. I signed my name.
You ever do this garbage in here again? You ever do this garbage in here again? You are out of control on this. You're the instigator in trying to cause grief between your brother and your father. I don't know what I'm going to do on this. I really don't know what I'm going to do.
Remember when you asked me to contact an attorney last time we were in here?
I didn't ask you to contact an attorney. I think I told your dad to, but I could be wrong. I don't remember.
We both went and seen an attorney.
Mr. Pittaway, you could not sign a document acting as though you're your father and file it in a courthouse and expect there to be no repercussions. This is a fraud on the court. You filed an action as a fraud on the court. Listen to me.
Okay, I'll let you finish.
Thank you. I appreciate it.
Ralph is loving
I don't know
this.
what I'm going to do. I don't know what the appropriate thing is for me to do. I knew you were involved in this way too much. From the very beginning, I knew you were the instigator here. I can't understand doing this kind of thing to brothers, fathers. I just don't get it. I don't understand it. I never will. I don't get it. Unless you're just being greedy in terms of getting something that's not necessarily just yours. I'm going to tell you something. I don't know what I'm going to do on this. I might issue a contempt charge. And you might find yourself locked up over this one. But here's the good news. I think things through. I'm not always right, but I always try to be right. But for you to do what you did in acting like his lawyer, in acting like you're him, is above the pay. It's beyond the pay. If I were you, I'd go sit in the back and I'd be quiet. And I'm going to figure out what I'm going to do. I think I know what I'm going to do, but I want to think it through. In the meantime, I'm going to deal with this complaint, if I even should, that shouldn't have been filed because your father didn't file it.
The dad outed him. Said, I didn't file it. Ralph, we need you over here.
What do you do for a living?
Work at Marathon is their security department.
You're a security officer? Yes?
Yes.
And you just committed a fraud?
I could not imagine what kind of gall it must take to do something like this.
I called legal aid.
I don't give a damn who you called.
Okay.
And I don't ever use that word. That's how upset I am right now. If you're going to tell me some lawyer told you to do this, then that lawyer is going to be disbarred.
You guys gave me the paperwork to call on that, and I followed through on it.
Hang on a second. Now you want to implicate us. We gave you the number to call because that's what we do in landlord-tenant. We don't tell people to sign people's names to legal documents. Did anybody in this building, just to be clear, tell you to sign this complaint?
No.
Knowing that you were not the Donald Pittaway that's being referred to in here?
Correct.
I'm asking you a question. Did anybody in that staff, that civil department, tell you to sign this document acting as though you're your father?
No, sir.
Well, then what are you bringing up this? You gave me the number of legal aid for. You've caused a big problem here. I'm going to think this through. I think I know what I'm going to do. But I'm going to deal with them right now. So go sit in the back. Now, did you two come to a resolution? This has just been...
Yes, it was pretty simple once he was out of there. Just being my dad worked out, I got all this stuff out. Just wants to dismiss the case.
You're going to dismiss the case? Yes?
We all got it worked out. Yeah.
Mr. Pittaway, you seem like a very nice man.
I think I am.
Well, don't let your son get in the way of you and this son.
No, he's fine.
No, he's not. No, he's not. He filed a complaint acting like it was you.
My son does all the stuff around my house.
I don't care. He doesn't file legal documents without consequences. Do you wish to move to dismiss?
Yeah, I want to dismiss.
Are you agreeing to dismiss the case?
Yeah, there's nothing.
Jennifer, prepare a dismissal order, and you agree with that?
Yes, sir.
Dismissed per agreement of the parties. You can just put it on there, Jennifer. Mr. Pittaway? I don't know. You're going to hear from me. I don't mean to sound like a tough guy, but I find this so outrageous that somebody would think they can come into a courthouse and sign a complaint and provide it and act like they are the person who owns the property, to wit, in this case, your father. Good luck. South Point Square versus Patricia Deja.
Thank you, Your Honor.
2502438. You're welcome.
You're welcome.
Southwick Cooperative, correct, Your Honor. Creighton Gallup on behalf of Southwick.
Where's Patricia Deja?
Your Honor, I've not had her check in.
You can go ahead and proceed with your default.
Wow.
Thank you, Your Honor. Your Honor, this is date and time set for a non-payment hearing. The defendant is in arrearages. We're asking for the default
turn this off
judgment,
here for a second.
the amount of $1,027.54, which
Is that just rent?
Nope, $6.99 in rent, Your Honor. 3 late charges of $50, plus the statutory costs and attorney's fees of $178.54.
Yeah. Okay. Oh my goodness. Judge Dad laying down the law. Apparently that's one more thing you should not do. No, I think most of us know that. Signing your name or signing someone else's name, I haven't done that since high school, and I needed a note to get out of class. It didn't work then. Okay, just for the record, didn't work then. Somehow those the attendance office, they always know. They always know. Ralph Myers made my Monday. He was so happy. He's like, ooh, we got a hot one. We got a hot one today. All right, Judge Dad delivering the heat today, for sure. All right, let's see if we've got, in Raul Valle trial, we are looking at just over, let me make a little more, an hour, and we've got an hour and 13 minutes on the timer. It was actually 19 minutes and 45 seconds. They came back in, read everything off, said we're sending it all back in now. So 19 minutes off that timer would be the accurate time, but they've been together that long. Part of the process, they could have been choosing a forum and stuff like that. That's part of deliberation, so I'm going to count it. But we'll let that stand as it is. Down to Judge Stephanie Boyd, who we haven't been to in a while. Let's give a quick peek down there and see what's up.
Yeah. Okay. All right. The court is going to grant the motion. The court is going to order therapeutic community, give you credit for any time served. How much time are you asking for, counsel?
With credit for time served?
Yeah, you get credit for time served.
We haven't.
So the range of punishment for him is anywhere from 2 to 8 years. How much are you asking for?
Oh, in terms of being sentenced? Okay, We're asking for 2. And let me tell you why we're asking for that, Your Honor, is because you heard from the testimony that, he's turned his life around. He just has an extremely poor decision-making process. And we think the sooner he gets back in society, the sooner he can build off of where he is now, which is understanding of what's going on. And I think if the court chooses to punish him with that, which we would understand and appreciate, the lowest number to allow him to jump back into society, see his kids, and build off of the good place he is in his life right now would be the best thing for him. So we're asking for 2 years.
All right. I'm going to sentence you to 3 years in the prison, give you credit for any time served. I request the therapeutic community for you. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
We just now talked about it, Your Honor. I can go over it.
All right, because this is because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, good luck to you when you're released from prison. If you need anything and I'm here and you need help, just let me know.
May I ask how much back time I have?
Sure.
May I ask we'll find out. Okay. I'll tell you that.
Is that a Patricia Nash tooled leather purse?
All right, is the person here on Travis Smith?
That purple and white looks.
Lacey Strunk?
Yes. Yes. It's drunk. Yeah.
I'm not saying I have that same purse. I'm just. It looks like tooled leather from here.
All right.
No, it's a legislative issue.
Okay. All right, what is happening with this case?
Well, Your Honor, I file a motion to set a bond on Ms. Strunk here.
Are you ready to proceed on the motion to set bond?
Yes, Your Honor. The state does have a recommendation.
All right. And have you all reached a recommendation or no?
We have not, Your Honor.
All right. Court is calling 2025 CR 000308, State versus Lacey Strunk. Can I have parties announced?
Ashley Jones for the state.
Nelson Skinner for the defense, Your Honor.
And are you Ms. Strunk?
I'm Miss Burns now, but yes, Your Honor.
Oh, I'm sorry?
I'm Miss Burns now, but it was previous.
All right, it says Lacey Burns Strunk. Is that you?
Yes.
All right, defense, you filed a motion requesting a bond?
Yes, Your Honor.
All right. And state you're ready to proceed?
Yes, Your Honor.
All right, defense, do you have any witnesses?
I do. I would like to call Diane England. And
all right, Diane England, if you'll come forward, please.
Over here.
All right, and
Mayberry.
Just one at a time.
Oh.
And to the clerk?
Yes.
I don't have the thing on Strong.
Strong?
Yes.
They all
The
dress
docket
appropriately.
statement. All right, can you raise your right hand for me, please?
Judge will appreciate that.
Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Diane.
All right, defense, you may proceed.
Ms. England, you know Lacey Burns Strunk, don't you?
Yes, sir.
How's that?
She's my daughter.
How's that?
She's your daughter? Where was she brought up at?
In San Antonio.
You're in San Antonio?
Yes.
Is that where you were brought up at?
Yes, actually in Adkins, right outside San Antonio.
Adkins? That's still in Bear County.
Yes, sir.
And you have family members who were here before you? Your parents? Or your grandparents? Were they living here in Bear
yes,
County
sir.
as well?
Yes, sir. All of my family's from here.
For how many generations back have y'all?
Oh, since my great-great-grandfather came from Germany, I guess.
Since the Alamo.
Has Lacey Strunk ever, she's been residing here all her life?
Yes, sir.
Has she ever indicated a desire to leave Bear County?
Mm-hmm.
She's never threatened to move or
No,
even
sir.
consider it?
No, sir.
Okay.
All right, let's go off the record for a moment. So in the defense motion, he says that she's accused of contacting
Judge cuts
the
to the
complainant about returning the children's coats for cooling weather when he refused to communicate through a third party. Is that what this case is about?
It is.
Yes, sir.
All right, so here's the thing. Step back for a moment. Oh, no, just have a seat.
Oh.
Also, are we proceeding on a violation of protective order for somebody texting somebody to say, please return the children's coats because the weather's getting cold?
That's what their motion amounts to.
Well, no. I mean, I just want to know, is that the allegations?
Yeah.
Your Honor, yes, so there was a protective order that was agreed to in late August of 2022. The defendant then called the complainant several times, and then the last violation is the text about the coats. I will say that this case is just newly indicted, so I have not had a chance to review or talk with the complainant yet, and so we're just
All right,
here.
so is there any objection to a PR bond with well, I really can't do a PR bond legally.
And that's the issue.
I was going to ask you to do that, Your Honor.
Legally.
Illegally.
Oh, no. I will tell you this, illegally, I'm not allowed to do that, but if I could do it, I would grant your client a PR bond. This appears to be a bunch of nonsense to the court.
I think I have maybe $100 cash, Your Honor. Could we do a $100 cash bond?
No, I mean, I can't accept cash here. What are we doing? No.
Pulling out.
Take credit cards?
No. So what are you asking for a bond?
Your Honor, the state's asking for a $3,500 bond and a no contact order.
All right, so come forward, please. We're back on the record. State, do you have any concerns for the complainant's safety?
At this time, Your Honor, the state has not been able to make contact with the complainant, and so I can't say from the last conversation we had, yes, he was concerned for his safety. That was, however, back in February of 2023.
All right, so can somebody tell me, what is the basis for the protective order? What's the underlying facts for the protective order, allegedly?
Allegedly, there were a couple of assaults where this defendant is alleged to have committed against the complainant, as well as, I'm not sure of the relation of the second victim, but both of those cases were dismissed. However, it seems like there was a tumultuous divorce, and the agreed protective order was the result of those cases.
And then I have a previous, in the defense's motion, he says there was a previous jury trial
That was out of a different county for a violation of a protective order.
Against this complainant. All right, and it was a not guilty verdict.
It was a not guilty verdict.
All right, so this is what the court is going to do. I'm going to set your bond at $3,500. I'm going to place you on GPS. They'll do it at the jail. I'll ask that the fees be waived. You are not to have contact with the complainant. Do you understand? You're not to text him or her. You're not to call them. No contact whatsoever. And with regards to the children's court, this sounds silly to the court, but guess what? I have no control over that, right? So you need to make sure it's done through a third party. If he doesn't pick up with the third party, I'm sorry, you are going to have to buy extra coats for the children. Do you understand? I don't know why adults can't be adults when it's concerning children, but sometimes they can't. That's when the courts step in. So I'm setting your bond at $3,500. If legally I could give you a PR bond, I would, but I can't. And I don't know the entirety of the facts of this case. I'm just going by what the attorneys are telling me. So that's why I'm setting the bond at $3,500. I don't know about the previous cases involving this complainant, but it's as much for your protection as it is for the complainant, so no one will accuse you of anything. Now, with regards to the GPS, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, if you could state your name for the record.
Lucy Burns.
All right, do you have employment?
Yes, sir.
All right, what is your work schedule?
7 to 30.
All right, so this is what I'm going to do with GPS. With regards to the GPS, I'm going to do a tracking. They're going to put in the motion the address and the locations where you're not allowed to be. If you violate the GPS, what's going to end up happening is they're going to come back to me with the violation of the GPS.
Can I state something?
Sure.
When this incident first happened and the texting, he turned me in on that then. And they put me on a GPS and I wore it for 6 months and I have not had any contact with it in over 3 years.
So are you still on GPS?
No.
She has had no contact with him for 3 years, and for the 6 months she was on that GPS device previously. And the problem with that, from her perspective, is if the court orders a GPS, the last time the court ordered a GPS on her, she had to sit in jail for 6 days before they got
No, they don't have 6 days here. They have a GPS at the jail. They'll put it on her. Here's the thing. I'm trying to save you money. If, however, you want to pay for it for yourself, you can pay for it for yourself. But if you want the free GPS, it'll have to be done at the jail, and they'll have it done. If we're able to get you back at the jail quickly, they'll have it done at the latest tomorrow.
And you had to go to work what time tomorrow?
7:30.
At 7:30 in the morning.
All right.
Is that right? 7:30 in the morning?
Yes.
If nobody has any objection, I'll call the jail to see if they can make sure that she has the GPS placed on her tonight.
No objection.
Thank you, Your Honor. I appreciate that.
All right. So the bond is going to be set at $3,500. And if you all can put in the motion the locations and the names of the people she's not to have any contact with. So I'm telling you this, and I want you to hear me clearly. You're not to call this person, text this person, or anything. If you do any of that, regardless, it's a violation of a protective order. Do you understand?
Yes.
And it's a violation of my order. And then you're going to come back here because somebody's going to give me a pretrial violation, and I'm going to sign it if it appears to be in order. Do you understand?
Yes.
All right. I'll write it on here. All right. That will be all. And Ms. Ferguson, we need a date for this, a 30-day reset, please.
We just said
Hang on a second. August 4th.
Here's the thing. You can do a jury trial. You can do a bench trial. If you do a bench trial and come to me, what's going to end up happening is if the state proves their case beyond a reasonable doubt, I'm going to find you guilty. If they don't, I'm going to find you not guilty. And let me explain something to you. You can come to me. I'm going to keep an open mind. But what I can tell you, if there's a protective order in place that says you're not to have contact with him, then you're not to have contact with him. It doesn't matter what it is. You understand? So you can ask your attorney if it's best for you to have a jury trial or a bench trial. If the state proves their case beyond a reasonable doubt, so for a violation of protective order, if they prove to me that there was a protective order in place, and it's a legal protective order, right? And that you violated, I'm going to follow the law. You understand?
Yes, Your Honor.
You can't do a bench trial nullification with the court. You understand? And your attorney will explain that to you. So you want a jury trial?
Yes.
All right, Ms. Ferguson, if you all confer and get a jury trial date, please.
Yes, sir.
They're gonna take you and process you and process you out as fast as possible. Any question?
Get that lady a GPS. She's got work in the morning.
Appreciate your time, Your Honor.
You're welcome. All right, who's here on?
Logan,
Did he go get his?
All right, just one moment. I have
Can we get Christine?
Anthony Cantrell.
You want me to holler for him outside, Your Honor?
There's Anthony's.
Oh, no, Anthony Cantrell. I think he's on the Zoom now. Thank you.
Thank you, August 12th then.
Let me go in the top corner for a bit.
All right, August 12th, jury trial. All right, Mr. Cantrell, I'm going to send you in a breakout room with your client. I'll send you to breakout room number 1.
You're muted.
All right. Who is here on Elias Solis?
Ready?
Morning, Your Honor.
Good morning. Is there an application?
Yes, Your Honor.
Probation, there's an application. Court is calling 2025 CR 007297, State versus Elias Solis. Can I have parties announced?
Defendant for the state of Texas.
Amir Mamori for Mr. Solis, Your Honor.
And are you Mr. Solis?
Yes, I am.
She's consistent.
Counsel, you received all discovery. Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Solis, did you review the application for deferred adjudication with your attorney? Did you understand it?
Yes, I did.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, we are, Your Honor.
Mr. Solis, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand you're charged with injury to a child or elderly disabled bodily injury? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand this? You have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea, you're giving up those rights?
Yes, Your Honor.
Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court would grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Solis, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes.
According to the plea, punishment is to be assessed at 3 years in the prison. There's a $1,500 fine. State is silent on your application for deferred adjudication. There's an affirmative finding of family violence, and there's to be no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent? Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Your Honor.
State?
Yeah, there's the plea, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, Your Honor.
Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. Containing Exhibit 1 with all attachments. No objections, Your Honor.
Mr. Solis, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses, statements, and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments or review the same.
While she does that, we're just passing the 1.5 hour mark of deliberation. For those of you that had, oh, I need to end the poll. Let me end the poll really quickly before she finishes. Let's see, we have 4 to 6 hours, 37%. Tuesday or later, 30%. 2 to 4 hours, 23%, and just 8% thinking under 2 hours. That was with 1,000.
All right, after reviewing states Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. All right, proceeding with sentencing.
Yes, Your Honor.
All right, do you have any evidence with regards to why the court would grant him deferred adjudication?
Judge, in this case, there is an issue of self-defense. Mr. Solis did present himself to the police. He didn't leave. He was there. He gave them his side of the story. There is an issue of on whether we could take this to trial. But again, he doesn't have much of a prior record. So we'd ask the court to grant him the deferred judge and any additional, if you want to follow some TAP or any mental health issues.
In the police report, it says that he got up and he was upset because there was no food in the refrigerator.
That's self-defense?
I mean, that's what's in the police report. It says, I made the scene and got a statement from Erlinda while using my body-worn camera. Erlinda stated that this morning, Elias Jr. was calling her names and was cussing at everyone. Erlinda stated that Elias Sr. told Elias Jr. that he needs to leave. Elias eventually left the location. Erlinda stated that she left with Elias Sr., and when she got back home, Elias Jr. came back home. Erlinda stated she was in the room when she heard Elias Sr. and Elias Jr. arguing. Erlinda then heard Elias Sr. tell her that she needed to call for the police. Erlinda stated that she stepped out of her room
Is this junior or
and
senior?
saw that Elias Jr. punching Elias Sr. with a closed fist. Erlinda stated that Elias Sr. then punched you back trying to defend yourself. Erlinda was able to call the police when Elias Jr. left out the back door. Erlinda stated that she saw Elias Sr. arm bleeding. So why are you living with your father?
Good question.
Why? Because I had nowhere to go.
How old are you?
I'm 52.
All right, you're 52. You need to get your own place to stay.
I did, ma'am. I bought the house next door to them. But
Why are you living next door to them?
I bought the house next door.
Why?
This was a while back.
And I bet you still go to their house for dinner and everything like that. Right?
Yes, ma'am.
All right, so here's the thing. You're an adult male.
Yes.
At some point in time, you need to get your own place. All right, you're grown.
Yes,
your parents shouldn't be supporting you anymore. Financially, no. And you shouldn't be upset because there's not any food in the refrigerator. You know why? Why didn't you put some food in the refrigerator? If you would have put food in the refrigerator, there would be food in the refrigerator. You understand?
Yes, ma'am.
I'm not going to grant his application for deferred adjudication. I'm going to find him guilty. You shouldn't be hitting on your father. There's an affirmative finding of family violence. There's to be no contact with your father or his wife, Erlinda.
Yes, ma'am. Yes, yeah.
There's to be 3 years in prison, suspended and probated. How much Probation, are you asking for the length of probation time, State?
They will defer to the court.
What are you referring?
3 years, Judge. That was our agreement.
All right. I'll do 4 years. If he completes everything early, then the court will consider early termination.
Yes, Judge.
There's a $1,500 fine probated. Proof of employment within 30 days of release. There's to be no employment as a home health care provider or with minors.
John.
Who all lives in the home that you say you're now staying at?
Just them two, my mom and my dad.
No, you said you have your own home.
Oh, right now, no, they kept my house.
All right, so you're not living with your mom and dad anymore.
No.
All right, do you have any children?
No, ma'am.
All right, there's to be no residing
Just got out of parenting classes.
in any household with the elderly. And I'm going to put that at 60 or with minors. There's to be regular reporting by Zoom or in person, regular random UAs, field visits, 1 time per month until further notice, 100 hours of community service restitution. I'm going to order the anger management course. Once he's completed that, the community service hours will be deemed satisfied. So have you had an alcohol problem in your past? Any mental health issues? All right. Probation, is there anything else?
Judge, I apologize. I think the no contact me.
It is Elias Solis Sr. And the other person is Orlinda. And I don't have Orlinda's last. Orlinda Solis. All right, is there anything else you need from the court in order to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? Yes. All right. Good luck to you.
Thank you.
You're welcome. Mr. Bellevue, you and your client are going to be in breakout room number 2. If you'll go there, please.
Maybe Judge.
Yes, you may be.
Judge, just so you know, I have not received the paperwork from Hunter, even though I requested it last week.
All right, they'll send it to you in that breakout room, if you'll let Hunter know. Who's here on Lawrence Cloud?
Hunter, send the papers.
Oh, yeah, see, Mike telling you yet?
You have to be in trial. You can try on the, no, you have to get stuff up.
Okay.
I'm sorry to hear that.
All right. Oh, no, you can leave. I'll take care of him. All right, thank you. I'll send him down.
Morning, Your Honor.
Good morning.
Morning, how you doing?
Oh, I'm doing fine.
All right.
So your attorney, your client wanted to speak to you. He said he hasn't had a chance to speak to you.
Well, we talked today, Your Honor.
We spoke.
We kind of got
at length, Judge. And there is a motion to suppress that has been filed, Your Honor. So we're asking for a setting on that motion to suppress.
Is that motion to suppress going to be dispositive?
I believe so, Judge. I mean.
No, I mean, is it or isn't it? Because otherwise it will be run with trial.
No, it will be dispositive.
All right. State? All right. They're saying that if the motion is granted, of course, the case is done. But if it's not granted, they're saying they're going to enter a plea. That's what that means, dispositive. It means that if... All right, so then we need to... Can you do a jury trial setting, please? If y'all will confer with Ms. Ferguson.
But I mean, it'll be run with trial. So.
No, I don't know what to
All right.
Positive.
How long do y'all expect this trial to last?
For testimony, 2 days.
All right, Ms. Ferguson. Jury trial date, they say 2 days.
It's positive because I'm not going to take no pleas off. That's how I'm going to trial you. I want to suppress before trial, and you don't have the video.
All right, your jury trial date is going to be August 5th.
August 5th?
He wants to talk.
All right, thank you. And counsel, if you just sign the discovery acknowledgement before you leave.
Well, Judge, the state is inquiring about some additional discovery. to see if the Lotus Police Department has that discovery available. So that's all we're waiting on.
Judge, I don't believe that it exists, but just as a courtesy to them, I did reach out to confirm that. But to my knowledge right now, that video does not exist. I did reach out to the arresting agency earlier today saying, hey, please confirm whether this video exists or not. And I did confer with Mr. Quadruple about that, but I've not heard back as of yet.
All right. All right, so you'll be scheduled for jury trial August 5th, and they'll bring you over dressed for trial.
I have a question, Your Honor.
Sure.
I would like a suppression hearing outside of that because there's some objections to the indictment that I haven't got to put in. I haven't been able to speak with counsel.
The objection to the indictment is something completely different than a motion to suppress.
Well,
you can discuss that with your attorney.
And I will follow motions.
All right, thank you.
If necessary, Judge.
All right, thank you. Leroy Smith.
So we're going to find policy. That's crazy. You know?
He's going to get some
Hello.
We don't know what
bailiffs in there, stat.
Well, we need to get you out of here.
Yes, Judge. Since Friday.
So do you have all the discovery, counsel?
I do have all discovery. I'm conferring with the state. We're working on a plan, Your Honor, and we'd like to get a regular reset.
All right, Ms. Ferguson. Leroy Smith, I need a plea deadline date in 30 days, please.
I'm sorry,
Plea deadline date for Leroy Smith in 30 days. All right. August 4th, once he signs the reset form, he's excused.
All right, thank you, Judge.
Thank you.
Boy, I seen you was on.
All right, thank you.
You went viral.
Oh,
you're on viral.
Okay, I have no idea what that means. I have no diseases. What?
I have no diseases.
Yes, sure. Janet Silva.
I'm seeing that Yuri Buchanan was transferred from investigative services to field services.
Judge, so Miss Silva is not on probation, but she was grouped in the group where we were trying to get resources available for behavioral health. I received information this morning that she was found incompetent.
Okay. All right, then they're probably going to end up, because of the nature of the offense, if they don't have a stable outpatient for her, they're going to send her to the state hospital till she becomes competent.
So she, from my understanding, he's number 55 on the competency list. And they asked for the in-jail competency restoration program. Okay. So as soon as she's off of suicide watch, they're going to be able to do that.
All right, Ms. Ferguson, if I can have a 45-day reset for Silva. You're welcome. August when?
21st.
All right, August 21st. And what page is Silva on? Thank you.
Is this a phantom date?
Yes, it's a phantom date.
A phantom date. Phantom court date.
All right, Rochelle Walker.
Is that the attorney or is that the defendant right there? I think that's an attorney.
Hi.
Thank
you. Thank you. All right, they're tendering dismissal, Ms. Walker, they say, because there's a witness missing. So they're not saying they're dismissing because they don't believe that you're not guilty of this offense. So I'm telling you right now, whatever is going on in your life, you had better do a course correction. Otherwise, you're going to find yourself at somebody's jail or at somebody's prison. Do you understand? If there's a drug or alcohol issue going on and you need help with that, if you come back to the court, if I'm here, I will pick up the phone and call someone to help you. You understand? All right, good luck to you.
Thank you.
You're welcome.
You want to hold that or you want me to hold it?
Chris Cervantes.
President.
Council, good morning. Where are we on discovery?
I'm not ready to sign off on a discovery acknowledgement. He was just indicted in May. We got hired June 17th, so I'm still in the process of going through and making sure we have everything.
Okay.
I conferred briefly with Secure again.
Okay. All right, Ms. Ferguson, I need a 30-day reset on a discovery for Chris Cervantes, please. 30? All right, August 4th will be your discovery date. Is there anything else?
Judge, if I may, is it possible to do somewhere around August 15th? That's a Friday, or if the 18th is better for the court, that's a Monday.
We can do August 14th. Norma, I'm sorry, not August 14th. We can do August 11th because he's on Mondays.
I was just trying to pick a date when Charles was here.
Okay.
He is here beginning the 18th, August.
August when?
18th.
All right, Norma set it for August 18th.
All right. Thank you very much.
All right, once you sign the reset form, your excuse. Who is here on Christine Mountcastle? Remember, where's her attorney?
Go fetch.
No, he's no longer on Zoom.
Go fetch an attorney.
Yeah. All right, State, what is happening with Mountcastle?
She's the lady in the bottom right-hand corner.
All right, could you unmute for me, please?
Yes.
275 officer to 308.
All right, Miss Mountcastle, my understanding is that the state has tendered an offer to your attorney. I'm going to set this for a plea deadline date in 2 weeks. Ms. Ferguson, I need a 2-week reset for a plea deadline date.
What, you mean an offer to my attorney?
Yes, and your attorney is going to discuss the offer with you, okay?
I really appreciate it because I'm innocent, but I can't prove it. And because I was charged with aggravated assault with deadly weapons. Well, I didn't have any thought in my mind of hurting my husband.
All right, so here's the thing. We're going to bring you back on July 21st, okay?
Oh, okay. July 21st?
Yeah.
That's fine. I hope nothing happens.
Oh, we'll make sure you're brought, okay?
I know you said up to 6. Okay, thank you very much, Judge.
All right, thank you so much. And Deputy Laura, could you let them know that on the 21st, she'll need to be in court?
So we're just waiting on paperwork and then... What time?
It's gonna be 9 a.m.
9 a.m.?
They'll bring
you. Me to get that.
All right, so here's the thing, Miss Mountcastle, you're gonna have to make sure you're up because for them to transport you, you need to make sure you cooperate, okay?
Okay, bye.
All right, thank you.
She says, I'm innocent, but I can't prove
Who's
it.
here on John Anthony Martinez?
Something with the assault with a deadly weapon, yeah. Against her
Who's here on
husband.
Travis Shane Smith?
I am.
Are you all ready to proceed?
The attorney's proud of it. I am. It's me, Your Honor. I am said attorney.
Are you proceeding on the motion?
Okay. There's some big bags.
All right. Court is calling 2016 CR 4751B, State versus Travis Shane Smith. Can I have parties announce?
Duffy Pitlock for the state of Texas, Your Honor.
Bob Hicks for Travis Smith, Your Honor.
And are you Travis Smith?
I am.
All right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am, I did.
It's this document.
Yes, ma'am.
You reviewed that?
Yes, ma'am.
Are you the same Travis Shane Smith who was placed on deferred adjudication in 2016 CR 4751B for the offense of burglary of a habitation or force on February 13, 2017 for a period of 5 years? Is that you?
Yes, Your Honor, it is.
All right, State.
Yes, Your Honor. The state is intending on proceeding violation condition number 5 In Bexar County, Texas, the defendant, Travis Shane Smith, did then and there fail to report to the supervision officer in person for the months of September and October 2019 in violation of condition number 5.
How do you plead to that? True or not true?
Excuse me, Your Honor.
Sure.
Confirm with the state.
Your Honor, there is a correction to be made. The state is not proceeding on that violation.
Okay.
The state apologizes. State is proceeding on violation of condition number 17. In Bexar County, Texas, the defendant, Travis Shane Smith, did then and there fail to attend and provide verification of Alcoholics Anonymous / Narcotics Anonymous meetings for the months of May, June, July, August, September, and October 2019 in violation of condition number 17.
How do you plead to that? True or not true?
True, Your Honor.
The state will waive and abandon the remaining violations, Your Honor.
Any objections to the waivers?
None, Your Honor.
Did you understand by pleading true to violation of condition number 17, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine?
I do understand that, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 17?
I do so, Your Honor.
Court will find violation of condition number 17 true. Is there a proposed agreement?
There is, Judge.
I want to hear the excuse.
The judge is Your Honor, the state is recommending revocation and sentencing. The state understands you've got the full range. We are recommending 5 years, Your Honor.
We understand that it's been revoked. We would like to request 2 years instead of 5. He has, except for the things that he has done spectacularly badly,
except for the things he failed miserably at, he's been doing a good job.
he was sent to aftercare, sent to SATA and completed that successfully because of a series of drug tests and bad drug tests in 17. He completed the aftercare program, completed outpatient substance abuse.
The judge is going to have some words for him. That's all you got in praise of your client?
And since the time that this happened, why did you not attend?
You want to raise your right hand for me?
Yes, ma'am.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do, Your Honor.
All right, you can lower your hand, state your name for the record.
My name is Travis Shane.
All right, you may proceed.
Is there any reason why you did not attend the Alcoholics Anonymous or Narcotics Anonymous process?
Careful
here.
It
was solely for the reason that...
Just 1 second. Excuse me, if you all could whisper. All right, you can continue.
It was solely for the reason that I did not have any way to complete the money payments into the program. And I did not have, I had felt a sense of fear that if I went in, I would be arrested for not completing motion 17, the non-completion of the alcoholics, not just that. Right. Like Tom and Jerry.
It's like Tom and Jerry, you said?
Any other questions?
I felt the shame and fear, Your Honor, of that. And after a while, it became complacency, and I have no one to blame but myself on that. I understand that.
At least you're right there.
Any other questions?
He says I couldn't afford AA.
Sure, Your Honor.
I think that's what I heard.
All right, so here's my question for you. What do you think was going to happen when you didn't report?
I didn't think anything of it at the time, but I knew eventually something like this would come.
Oh, so you knew that if you did not report, a motion to revoke was going to be filed. Eventually, you were going to be picked up and arrested.
Actually, I didn't obey, Your Honor.
So did you ever call probation?
I did not, Your Honor.
All right. So what have you been doing since you have not been reporting?
I've been just living my life. I've picked up work. I'm steadily and gainfully employed.
Doing what?
I'm a welder and fabricator and installer.
All right. And how long have you been doing that?
For 3.5 years now.
Now you can pay your fees.
So why didn't you pay any money? If you've been welding, welding pays good money. Welding pays more than what I make.
That's a fair question, Your Honor. And as I said, it was the simple complacency of not having done it. And I regret now, looking back on it, not having done it.
All right.
I understand it was only my fault.
All right. Anything else,
Saying the right
counsel?
thing, but she's not going to let this one slide, I don't think.
No, Your Honor.
All right. I need your client to fill out the trial court certification form. He needs to sign that. Thank you.
Of course.
All right. The court is going to find you guilty, revoke. The court will sentence you to 5 years in the prison, give you credit for any time served. You'll receive credit for successful completion of inpatient treatment. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
I did, Your Honor.
Did you understand it and sign it?
I did.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion,
yes,
not the fact that you were on deferred adjudication. Do you understand?
Yes.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. Do you understand?
I do understand that.
Good luck to you. Do better, okay?
Yes, ma'am.
All right. Good luck to you.
Do better.
Mm-hmm.
Thank you, counsel.
You know, you have a relatively funny article back in your office about defendants.
She doesn't want to talk about it.
But I talked to him about what he told you about her two silly addictions.
She
Every
says.
day, Judge. No big scheme.
Yes.
Yes, she wants you to leave now.
Yes. Thank you.
Selena, that is awesome. This deserves a party horn. 927 days. That is just great, Selena. Thank you for sharing that.
Let's hear out Arturo Lopez. Hello.
Judge.
Hi, where's Mr. Lopez?
He's right there.
Come down, please.
Mr. Lopez, come on down.
Hi, good morning. All right.
I like her glasses.
All right. So is your client a citizen?
I do not believe so. I'm not.
No. No. So he says no. So are you going to handle the immigration issues or do you need an immigration attorney appointed?
Well, what I'm asking for is for, I think, convenience is to maybe reappoint him to somebody that speaks Spanish, because I think probably be better in the big picture.
All right. All right. Do you have any objections to this attorney being placed with a Spanish-speaking attorney?
No.
All right. Your excuse. Thank you.
He's like, I'm out of here because I can't talk to my client. Let's get one that speaks Spanish. Translator's like, now what?
All right. Your attorney is going to be Monica Guerrero. She'll get in touch with you. We're going to recall you in 2 weeks. I need a 2-week reset, please. All right. We're going to recall you back on July 21st. Okay. All right. Thank you. It's good seeing you.
Likewise, Judge.
Your Honor, I also need an interpreter for my case. I'm sorry to jump in, but before she leaves.
Yes, if you'll come forward with your client.
Naranjo, Perez Naranjo.
Jesus
Who is that?
Andarza.
Perez Naranjo, he's coming up.
Can I have his file, please?
Why are you not
Sorry
here in
about that,
person?
but I thought it was interpreter. I said, might as well.
No, no problem. Okay. All right. Thank you.
2 hours of deliberation time just passed.
And Norma, what page is Lopez on? Oh, thank you.
Oh, the backpack lawyer that was always headed out the door.
All right. On Mr. Perez Narano, what are we here for?
In restitution, Your Honor, the state then probation will check to see if there was any restitution outstanding or not for the case.
State. Who's the state's attorney on Perez Narano? It's a debit card abuse and violation of motor vehicle tax.
Isn't that the one where they all shared the same cup? They all drank out of the same cup.
All right. Do you know if there's any restitution?
If I could have a minute to double check, because I haven't.
No problem.
Yes, it was.
All right, sir, if you have a seat.
They had a styrofoam water cup,
and
everybody
to
drank out of
the
the same
interpreter,
cup.
yes, we'll call you back.
It was really fun.
If you have to go somewhere else.
I can wait a few minutes.
All right, awesome.
Yes.
All right, just have a seat, sir.
I'm on the clock.
All right, okay, I'll take it up. Just give me a second.
Your hat.
Remove your hat. Or yourself. She removed herself.
All right, Logan.
The lady in fuchsia, I think that's not pink, that's fuchsia. She has a purse that is lawyer sized, meaning you can fit a lawyer in it.
Hello.
How you doing?
What you doing?
I'm great. How are you?
Oh, I'm doing okay. We had a rough time getting you here.
Yes, ma'am.
Just have a problem with my wrists. They don't seem to be separating. Other than that, I'm doing great. What
So
about
did you have
the
a
cup?
chance to confer with your attorney?
A little bit, yes, ma'am. Just need more details.
Need
Oh, okay.
more details.
So has the competency evaluation been filed?
Yes, it's been filed. We're set in court on the 29th.
Of this month?
Yes, and hopefully by then we'll have the report.
Is this
It's a
Anakin?
status conference, I think.
What's his name?
That's where we're at.
I do have an affidavit I gave to him. You could give it to me just so if you could look at it.
Please remain silent. Please remain silent.
All right, so here's the thing. If that's an affidavit, sometimes people have affidavits or non-prosecution or whatever they may have. That's something that your attorney needs to discuss with the state, because really affidavits or non-prosecution, basically they usually say, I don't want you all to prosecute this case. Please dismiss it. But as I tell people, it's always the state, on criminal sides, it's the state of Texas versus.
Yes, ma'am.
Because if you're charged with a crime, it's supposed to mean that you've offended the state of Texas, not only the person who's the complainant, but the entire state of Texas. So that's why it's the state of Texas versus. Now, if you have an affidavit of non-prosecution from the state of Texas, that's completely different. But just having it from the complainant, it's just usually something for the state to
Any
consider.
affidavit, Judge.
Okay. All right. So, Ms.
He just made
Ferguson,
his own.
can you recall this for the first week in August?
It's like I've got a letter that I signed that says.
All
you
right.
can't
So you're going to be
prosecute
back in
me.
this court on August 4th so we can get an update of what's happening on your July 29th case. Okay.
Yes, ma'am.
All right. Thank you. Thank you, counsel.
Thank you.
I've got an affidavit. Give it to her, lawyer. Give it to her. The lawyer's like, shut up, remain silent. No, I don't know why in this area the lawyers all are so experienced. I think it's a good sign. I'd rather get a lawyer that has years of experience under their belt than is still a little green around the edges.
Humberto Lira.
Jess, we have been waiting for a verdict for about 2 hours.
Oh, Mr. Lira.
I can show you that.
I'm doing okay. Listen, you need to make sure that you're on
Nothing's
time
happening
for
right
court. Have you heard what I've told everybody else? Like sometimes I have other judges who sit in my place because I have a meeting or I'm at a CLE. Those judges, sometimes when they sit, they don't take into consideration why you're late. It's just that you're supposed to be here at 9, you're not here. And so they end up taking you into custody. Do you understand?
Yes, ma'am.
All right, Ms. Ferguson, can you set this on the next docket day for a criminal trial division, please?
Yes.
Thank you. July when? All right, they're going to bring you back for jury trial on July 22nd. Once you sign the reset form, you're excused.
Great, thank you.
You're welcome. Oh, sir, just wait here. She'll give you the reset form.
You've got a new profile picture. Looks great. Okay, I want to see. There's another bag. Look at that. Look at that big blue bag. The thing is gigantic. Looks like a camping backpack. Do you think it's got rollers on the bottom? I think it has rollers.
John Anthony Martinez.
It's like a portable file cabinet, I think. What's funny about this court is the microphone has a little a sneeze guard on. I don't know what you call it, a sneeze guard. I don't think they've changed it in years. It's got to be like that microphone cover has got to have every specimen known to man on it. But underneath, it's clean. It's shiny clean. See the microphone in the top right-hand corner? It's sort of just behind the prosecutor's chair. But do I have purse envy? No, and I don't collect purses. I don't use purses. Actually, my wallet is... I usually wear the wallet out until one half. Like I like a trifold wallet, okay? And I usually wear it out so that one half of, one third of the tri like comes off and becomes a bifold wallet. That's when I get a new one. I'm very close to that right now, and I always get black wallets, like a black, thin, because I don't carry a lot. I don't have a lot to put in it, but black thin wallet, and I might show you one day if I can find it. I've looked at the Ridge. I'm just not quite there. I'm not quite there with the Ridge wallet. First of all, it's about 5 times as much as I've ever spent on a wallet.
All right, everyone, just give me a moment.
Take your time, Judge. We'll just people watch in your courtroom with Jesus. So you're George Costanza. Well, we have some things in common and some things that were different in. Judge Boyd's net worth is $4 million. How did you get her net worth? Oh, just you've been adding up her purses? $4 million, mostly in purses. The Ridge requires you to carry money on the outside. Sharkey, quick solution. I don't carry money. I just don't carry money. Welcome back, Judge. We missed you. That is a fine purse, by the way. All her purses are fake. I mean, they're real purses. They're functional, but they're knockoffs from the real brand, from the expensive brand. Have you ever looked at the wallets made by the inmates in Texas? No. How do I sign up for a Texas Con wallet?
Hello, Mr. Bellevue.
Judge.
Yes.
Oh, yes.
Oh, and has Howie been brought out?
I don't want to search for a prison wallet, but
We're trying to focus on it right now. That's going.
All right.
See where we're at on that status.
All right, thank you. And Mr. Bellevue?
Texas Prison Museum.
Yes, Judge.
Yes. So do you have your paperwork?
I've signed it, and at the jail they tell me my client has signed it, so it should be coming to you.
All right. Let me see what I have.
Sorry, Judge. Didn't mean to take your space there. I was just going to disappear so we could see Jesus. He's still here. Okay. Texas Prison Museum sells leather wallets, and they make badge holders and everything. Trifold wall. $52. $52.50. Granted, it's leather tooled. I'm talking about, I do like the thin leather. I don't know. This is like raw or cowhide. I do like mouse hide, the thin stuff. $52.
Okay, so state, you may want to check.
Well, that was the cheap one.
With the paperwork, because I don't have any paperwork to sign on my end. The only thing I have is a discovery. Okay.
You had said earlier that you sent the paperwork to.
All right.
Unless you send it to the clerk, I can call Naya.
All right.
Got the paperwork right now for us.
So it looks like it's my process.
All right.
Yeah.
Who is here on Alan Mayo? Hello.
How you
doing? Fine. All right. The court is calling 2023 CR 9481 State versus Alan Paul Mayo. Can I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Anita Perez for the defense.
And are you Alan Paul Mayo?
Yes, Your Honor.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Alan Paul Mayo who was placed on community supervision in 2023 CR 9481 for the offense of evading arrest, detention, second or more on May 23rd, 2024 for a term of 2 years? Is that you?
Yes, ma'am.
All right, state.
Yes, Judge. The state is alleging violation of condition number 4 in Bexar County, Texas. The defendant, Alan Paul Mayo, did then and there fail to report to the supervision officer as directed for the months of June and July of 2024 in violation of condition number 4.
How do you plead to that? True or not true?
True, ma'am.
All right. Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you up to 2 years in the prison, and up to a $500 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true
Yes, ma'am.
to violation of condition number 4?
Yes, ma'am.
The court will find violation of condition number 4 true. Is there a proposed agreement?
There is, Judge.
Yes.
That is to continue probationer on probation, but to amend conditions of probation for compliance hearings every 3 months until probationer is back in compliance, and also to amend conditions of probation to include ISP in lieu of gang supervision.
Gang.
All right. So he's been missing since June of 2024. So where have you been? Well, I mean, if you want to answer questions, I'll have you raise your hand to give testimony, or either
Attorney's like, sure, you can talk.
Defense.
Yeah, that's fine, Judge.
You want to raise your right hand?
Yes, ma'am.
Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand. State your name for the record.
Alan Paul Mayo.
All right, where have you been?
I was in Killeen doing a motel, 4-story motel for Nick and Sam. They owned a bunch of properties in the
Wait a
hills.
minute, I'm sorry. In Killeen for what?
Doing a motel property for Nick and Sam. They own the Hilton Inn. They own American Best. I was working for them, and then my mama got sick.
First of all, let me break your story down a little bit. Number one, did you have permission from probation to be in Killeen?
No, ma'am, I did not.
All right, so
Sorry.
continue.
All right. And then I came back here for the holidays. I had a little money. I spent Thanksgiving, Christmas with my mama. And then her birthday was December 29th. And then she died the 7th. She went to the hospital, ICU, life support. My mama, she worked at a petroleum club 26 years. My sister had to take her off life support. It's been an ordeal. So I just kind of got lost in the...
Sorry to hear about your mom. So when was she placed in the hospital?
January 6th, week after her birthday.
All right, January 6th of 2025?
Yes, ma'am.
All right. So then here's my question for you. Where were you June 2024?
Yeah.
And you didn't report?
No, I went to work.
Where were you in July 2024?
I might have been in Killeen.
Did you report?
No, ma'am.
August,
No, ma'am.
September,
No, ma'am.
October,
No, ma'am.
November,
No, ma'am.
December.
No, ma'am.
I don't think you're a good candidate for probation. Okay? All right, the court is going to find violation of condition number 4 true. The court will find you guilty. The court will sentence you to 2 years in the prison, give you credit for any time served. The court will recommend the therapeutic community, and there's a $500 fine, time, and money to run concurrently. Did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Right, so you have a limited right to appeal. That right to appeal is as it relates to the allegation in the motion, not the fact that you are on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, sir.
Thank you, ma'am.
You're welcome.
Thank you, ma'am.
Watch the fuchsia shirt. When she picks up her purse, it is ginormous. It's like it can fit several duffel bags in it, full, with bodies. It's really big.
Yeah.
There it is. She's got it. She's got it. What is that purse she's got on? Maybe it's like a Aldi bag.
Yeah.
All right, on Essex, I'm still waiting for paperwork to come through on my end. I haven't received any.
It's a ginormous purse.
Acknowledge.
It's a tote.
All right. And do y'all have an update on the restitution for Perez Navarro?
Oh, Jen, you're on right. Sorry.
All right, Perez Navarro.
That purse, when she comes through security, it must take 2 officers to search it. One to dive in and search, the other one to lift the first guy out.
We have not received any evidence to present to the court regarding restitution.
All right, we're going to go on the record. The court is calling 2024 CR 3071 and 2024 CR 3072, State versus Miguel Perez Navarro. Can I have parties announced?
Megan Galloway for the state.
And Susan Darza for the defense. Sorry.
And are you Mr. Perez Navarro?
Yes.
All right, we have an interpreter here. If you could raise your right hand for me, please. Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
Did she get sworn in last time?
All right, you can lower your hand if you'll state your name.
Norma Nero.
All right, thank you. All right, so we're here for a restitution hearing. Off the record, the state has informed the court that they have not received any documentation of a restitution amount. Is that correct?
That's correct.
All right, the court will note for the record that the defendant entered his plea of guilty on September 12th, 2024. So the court has been awaiting restitution since that date, and so has the defendant. With that being said, because there's no restitution amount presented, defense, are you asking for the court to close the issue of restitution?
Yes, Your Honor.
All right, then the restitution will be closed. I'm sorry, probation. There's no restitution amount. Thank you.
Thank you, Your Honor.
You're welcome. Yaya, I'll put you in breakout room number 2. She's going to swear your client. Yes, thank you.
We're getting down to the bottom of the docket here.
Paperwork after this. Yeah. Thank you.
I just had a coach for a little bit now.
Yeah, no more paperwork after this. Who's here on Ashley Peel?
That was Victoria. She just walked.
All right.
I'll go to her.
All right, thank you.
For now.
Judge, Mr. Howie, Judge, she did. Mr. Howie, I'm still waiting on a call back from.
All right, so if you can come back this afternoon, either in person or by Zoom, I want Mr. Howie's case taken care of today.
I understand.
All right, thank you.
Well, I'm waiting for a call back.
Okay.
Right, it's 1 o'clock, which means it's time for lunch.
Hi. No problem.
We may just hop through this one.
Oh, Ms. Peel, if you'll come forward. All right, Ms. Peel, you were scheduled for a bench trial today. The state has tendered a dismissal to the court. They're saying that it's a missing witness. They're not saying they don't believe you committed the offense. They're just saying it's because of a missing witness. So whatever brought you here today,
don't do it
you need
again.
to make sure you do better. Otherwise, you're going to find yourself at somebody's jail or maybe somebody's prison. You understand?
Or in somebody's cemetery.
All right, good luck to you.
Thank you very much.
Thank you. Have a good one. Yes.
Quick
I
jump.
have MTR on the docket. I'll be back for that one as well.
All right, thank you.
Sounds good. We're going to jump to Cedric Simpson.
Done anything to your son. Is that right? Okay. He's
Okay, just
never
peel on.
abused your son, assaulted your son, or anything like that, right?
Thank you.
Okay. And
Sorry, Judge. I had you both in there. It's a new view of the judge, Judge Simpson.
and when you said that he tried to, or he told you that he had taken a number of pills, what day was that?
We're in a hearing right now?
Okay, but it was sometime while you were in the hospital, right? And doctors and nurses and CNAs and other people walked into that room, right? And if you were really concerned about the pills that he took, you didn't tell anyone, you didn't report to anyone that he may have.
Are you hearing
Okay,
voices
so you
that I
didn't
can't?
believe that he had done that. Okay.
There's a
No
witness
further
that's apparently
questions.
not mic'd.
You need redirect.
The judge
Okay,
is
Madison,
caressing the
how you
world's
doing?
smallest mustache.
A few things I wanted to follow up on. So counsel asked you about essentially telling Mr. Burns that, you know, giving in, saying, I'll do it one last time. And you were saying that you agreed because you were scared. So you did it because you were scared. Can you tell us more about that, about what was going through your mind and what that fear was?
Apparently, we're going to have to bail on this. We cannot.
Say if I didn't, because we said because it was our anniversary that was the reason that we had to, because we were still married. Sure, it wasn't long.
Okay, I'm going to bail on this one.
And you asked if Mr. Burns has ever abused your son directly, Benjamin.
We're going to jump. We're going to jump. It doesn't sound like we're headed in a good direction here. Judge Simpson didn't look too pleased with that case either. Let's see if we've got Minecraft Court or anybody up today. We're currently at 2 hours and 25 minutes in deliberation time. The Raul Valle trial. I think everyone's going to lunch. That might be our sign to go to lunch as well. Olga, you've been a translator in court? That is awesome. Hang on.
All right, Miss
Now we
Essex,
can
if
hear.
you can
Sorry.
unmute for me, please.
We couldn't hear for a minute.
Hi, Your Honor Boyd.
All right, are you Kimberly Essex?
Yes, ma'am.
All right, you have a right to appear in person for this plea. Do you understand that?
Yes, Your Honor.
Do you have any objections to the court taking your plea by Zoom?
Yeah. No, ma'am. No, Your Honor.
Who said yeah?
All right. Defense, any objection to taking this plea by Zoom?
No, Your Honor.
All right, and defense, state any objection to taking the plea by Zoom?
No, Judge.
All right, and defense, you have not.
Yeah, that initially, like my thing.
Defense, you have not signed the discovery acknowledgement. Have you received all of the discovery?
I have, Your Honor. I thought I signed it this morning.
I have a document where it's not signed.
I apologize.
All right. Court will find that the state is in compliance with discovery. Are there any applications?
There is, Judge. It's an opposed offer.
It's an opposed offer?
All right. The court does not have the application for deferred. Is she applying for deferred adjudication or community supervision?
Straight probation, Your Honor.
All right. Miss Essex, can you unmute yourself, please?
Yes, Your Honor. Now it's unmuted.
I would stay on this.
Do you know how to mute and unmute yourself?
Well, last time I did that, I'm not allowed to touch the screen. So.
All right. So I'm giving you permission to unmute yourself because there's a lot of noise coming from your end. It's making it difficult for me to hear and the court reporter to hear. So in this case, are you applying for community supervision, which is a form of probation?
Yes, ma'am. Yes, Your Honor. Can you hear me?
Yes, I can. Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, we do.
State, are you proceeding on the indictment as presented?
Judge, two things. The state is proceeding on count 4, paragraph A. That's an exploitation of elderly charge.
Just 1 second. Could I have a file stamp for a plea, please?
All that paperwork was sent by
No problem. All right, thank you. All right, so state, you said you're proceeding on which ones, please?
Count 4, Judge, paragraph A, exploitation charge.
And are you waiving everything else?
Yes, Judge, and then we have an oral amendment.
All right, and what is any objection to the waiver?
No, Your Honor.
And what is the oral amendment?
The oral amendment on count 4, paragraph A, Judge. It's a part in the middle that reads, an elderly person 65 years of age or older. The amendment is following the word older to add hereinafter styled complainant.
Any objection?
No objections, Your Honor.
And Judge, as to the enhancement paragraphs, the state is waiving one of the 2 enhancement paragraphs. Judge, Essex or repeater.
All right, and which paragraph are you waiving?
Sorry.
Jeff and Don Swanstrom. All right. So in this case, it's Isaiah and Melissa Morgan who are the petitioners and the Swanstroms who are the respondents. All right, before we get started, can I have each of you raise your right hand, please?
I'm loving the map in
And
the
do you
background.
each swear the testimony you give in this case will be the truth, the whole truth, and nothing but the truth?
I do. I do, Your Honor.
Yes. Thank you.
I did see
Okay,
Don say
so
it.
the Morgans are the petitioners here, and I'll let you decide between yourselves who's going to go first.
Isaiah.
I guess I'll go. So, as we submitted our evidence, as you can see in the emails, as well as pictures that were taken over our privacy fence, this has led to us seeking this order. Emails were sent to Snap-on Tools, which in a way I am affiliated with, but they are not my employer. I am a franchisee. So it caused turmoil in my workplace. It caused a pending suspension, as well as I had to serve proof of all this as well to Snap-on. And then as well as another developing in this, on June 17th, cops have showed up to our house once again, let me know that they called, made a complaint. I asked the officer if there was anything I was doing wrong, and he said I was within my rights and there's nothing he could see that I am doing wrong, but it was his job to notify me. So as far as that, the officers on Tuesday, June, I want to say, or it was like May 28th or something like that. I had emailed the city of Tenino because a spotlight was shined into my backyard. I took pictures of it at 10 o'clock. I took pictures of it on at 11 and pictures on at midnight. The chief of police had contacted me and said there was nothing he could do personally, but he could go ask them to take it down. They didn't have to remove it, but he would deal with it. And at that time, I had told the chief of police as well that, you know, I don't look to take it any further. I would just like the spotlight taken down that was directly shined into my backyard.
What are these?
So he went and made contact with them, in which they did take it down. And this was probably about 9:30, 10 o'clock in the morning. And then he had called me back and notified me that they had removed it. I had instructed the officer that that was great. I wasn't going to seek any more legal actions on the case. Then at 10:35, Snap-on Tools customer care emailed me, letting me know that somebody was making a complaint against the franchise.
I think he's in his Snap-on truck.
Which at that point, they were confused on what was going on, which I had instructed them it was my neighbors. So at that time, I called back the chief of police and I said, hey, now after you've asked them to take the light down, they have now sent an email to my employer, or not my employer, but to Snap-on's franchisee complaint line, or whatever you want to call it. And so I asked the chief of police, what do I need to do next? And he goes, well, if the email doesn't directly harm you or anybody on your property or your property, you're going to have to seek an anti-harassment order through Thurston County, which at that point I had got off the phone with the chief of police. I had called my wife, let her know what was going on. And at that point, I think that was June 3rd or June 4th, the order was granted for the temporary upon the evidence we submitted. And then it's just, now it's continuing. I mean, I have them circling my house. As I've talked to the cops, it's been a couple times, several times over a span of quite a while that these people have been calling, making little complaints. I've asked the chief as well, like, how many valid complaints have you seen? How many times have you cited me for anything? And he basically told me there's been nothing that we've been able to cite. Now, I do also want to add that I was arrested for disorderly conduct, which is in Tenino Court, which is currently, from what I understand, is going to be dismissed on August 17th. This is kind of Memorial Day weekend. This happened. Then these guys start attacking us, and it's just progressing. And honestly, other than June 17th when the cops showed up, it's been pretty peaceful. It's probably been the most peaceful in probably several months. I don't know if this is in retaliation because of me contacting the city, getting ready to get permits to do a new fence and build a shop. I don't know if this is all because of that, but I want to just be able to go about my life. As far as I'm concerned, these people attacked me, said slandering words about me to really somebody who didn't even matter. And then in the pictures, you could see that they shined a spotlight point blank into my yard. So that's kind of where we're at now, and we're just looking for peace.
And we're going to sue for peace.
Sounds like it's all right.
And Miss
He's wearing a
Miss
Snap-on
Morgan,
shirt
are you
in a
going to add
Snap-on
anything
truck.
to what Mr. Morgan said?
Yeah, I was the one that initially first saw. So in the picture, it's a little hard to see, but there was a middle finger light that they had put up onto their window into our backyard, as well as my dogs were barking at the time. I was getting ready to go to bed. I do wake up early at 2 o'clock in the morning. So I ran out there to go grab them, bring them inside. And it's when I heard the Jeff Swanstrom tell my dogs to shut the fuck up. And then he responded with, "I'm going to call the non-emergency," is what led to the Memorial Day weekend outburst where my husband was arrested. I did take a picture and show that, and that's just when that escalated. So my story is just the previous part leading up to the floodlight in our backyard, and then the email right after we asked them to get it taken down. For me, I think it's just been, I do work part-time from home, so I am home a lot, and to not feel safe to have my dogs out there. Because if you're cussing at dogs, I'm not really sure like what else you're able to do, and sending emails to people's work to have some reprimand of, I'm not really sure why. They did, in 2024, they did ride their bikes in front of our house during 4th of July. They introduced themselves. They were super nice. They met our dogs, so I know that they've met our dogs before. So I'm not really sure what happened in between last year meeting our dogs and then where we're at today. But it has been peaceful, like my husband said. Just not having any interaction or any yelling or things back and forth. It's just been nice, and I would just like to keep it that way.
Okay, thank you.
We want the middle finger light turned off.
The Swanstroms?
Isaiah,
Yes, Your Honor. Did you
chance.
receive the documents that were sent in last week?
In my file.
Because there should be a statement from the Tenino Police Chief, as well as from us, and some attached videos, photos.
You submit those. Do we have anything?
I have not been served anything
Yeah,
additional.
it looks like there was some material submitted this morning. That's kind of too late. So why don't you just tell me what it is you want me to know?
Well, no, I did. Well, I was confirming with the court. I actually sent them last Wednesday, and I was confirming that you had received them. And it looks like they must not have sent them to you until just now. There's no illuminated middle finger. I put up a little sticker on the window because after Isaiah was moving the Snap-on truck up and down the fence for I'm not sure what reason, I'm just assuming it was to try to harass and intimidate us, block us from something. I'm not sure. It's really large. If you have the pictures, you can see that it towers over our house. It's really strange and uncomfortable. Yes, we were out putting some things in our shed on Memorial Day weekend. Their dogs were barking. My husband did yell at the dog, then went and got it a biscuit and tossed it over the fence because he's never been mean to the dogs. We, like all the pets around here, we feed our landlord's dog, who is also sitting in your courtroom right now. It's just a thing that we've always done.
You've got a dog in your courtroom?
They've never spoken to us and asked us to stop feeding their dogs. It was the first time I'd seen that was in their statement. So, of course, we immediately stopped feeding them.
Who's
we
the
had a
lady behind
diabetic
me?
cat, so
Who
we
is this?
understand food allergies.
Stop. Okay, we're good.
Dawn, stop.
As far as reporting the truck, I was told that was well within my rights, just where it's parked. It's just a huge towering obstruction to us. Would you like me to read the police chief's statement to you?
That would be hearsay.
It's not a matter of what I would like. If you'd like to submit something, go ahead.
The police chief's statement contradicts their statement that the police chief said.
He's like, if I got my way.
I just don't want to be called a liar. They're telling me I said things that I didn't say and do. Yes, we reported them to Snap-on. I feel I was in my rights to call a corporate company when the vehicle's used for mischief, I thought. After that time, I have not reported any more back to Snap-on. I left it alone. It's his job. You're right. Maybe the first time was to Snap-on, but after that, I don't want the guy to get fired. I want nothing bad to happen to him. I don't want nothing bad to happen to his dogs. There was something that they told me that they have dogs with allergies. If I would have known that, I'd have never feeding their dogs a biscuit, and I'm sorry. I won't ever feed their dogs a biscuit, and yes, occasionally they can be annoying, and yes, occasionally you can yell over the fence. I apologize, I didn't mean that. Yeah, I yelled at their dog across the fence. He was being annoying, and sorry, I apologize for that. Other than that, I don't know what we've done wrong.
All right, thank you, sir. Okay. As far as I can tell,
nothing
from the material that's been submitted here and
nothing's happened
in support of the petition and what I've heard from everybody here testifying today, there is not any basis to issue an anti-harassment order. I'm not at all satisfied that any harassment has occurred. I'm sorry that you don't get along. I'm sorry that you find the need to complain about each other and call the police and make reports and report to the employers, but that, if that's how you're going to deal with each other, then
Angela,
I don't think that's pleasant, but
workplace.
You're certainly within your rights to do it. If anything else happens, maybe that'll show a pattern or a course of conduct that harasses another person, but at this point, I don't see that it does. So this petition for an anti-harassment order is denied.
Betsy Jean, we're not going to pick up another big case before I leave for 2 days. But we might do.
There was a temporary order issued by Judge Pro Tem McDonald back on June 4th, and that order is terminated as of now.
So
now, do we get 14 days to contest this decision?
No, this is a final decision of the court. You can appeal a decision that you don't agree with.
You get a lifetime to lick your wounds.
Now, Mr. Morgan, I think there's another case involving you, so I'll call that one next if you'll just stand by.
Yeah, this is their landlord. I felt like this should be realized in the previous court case as well.
All right, but wait until I call that case.
Oh, that's the landlord. Is that who Angela is? Is Angela the landlord? I swear she had Geiger counters in the background behind her.
All right, the court clerk will
all sorts of
distribute copies of this written order to each of you later today.
Thank you, Your Honor.
Thank you.
Yeah, you're welcome.
So, Isaiah.
Right, so next I'm going to call, make sure I have the right one.
Jeff and Don, you're free to go. Now, will landlord step up?
That is Willardson versus Morgan. Devin and Crystal Willardson. Okay, and you're here in the courtroom. Yeah, you grab a seat there in front of one of the microphones. And this is 25-178. Am I saying your name right? Willardson?
Yeah.
Okay, thank you.
So they sued for a restraining order against the neighbors.
In this case,
and against
Mr. Morgan,
the landlords.
Mr. Morgan, you're the respondent. The Willardsons are the petitioners, so they're going to get to tell me their side of it first. So before we start, can I have each of you raise your right hands, please? Do each of you swear the testimony that you give in this case will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, thank you. All right, and as between the two of you, I'll let you decide who wants to start.
She submitted all the paperwork.
Submitted the petition?
Yeah.
Okay. Yeah, go right ahead, man.
Oh, well, I was just going to say, I believe that as long as you have what I've written, I don't think that I have much else to say as long as it's, written well enough in there of the two different incidents that have occurred.
All right. Can I ask you a question, though, just because it was brought up earlier and I wasn't sure? And that is the incident that you described in the petition, is that the thing that led to the criminal charges that Mr. Morgan referred to before? Or do you even know?
So I believe what Mr. Morgan is referring to is the incident on Memorial Day weekend where he had came over to our property. He believed that we were the ones that called Snap-on. That's untrue. We've never called the city or police on him ever. We can't even hear his dogs or anything, because I know that that's been called before as well. So I think that that's what kind of heightened. He thought that we did something that we did not. There was, our children were present as well. That's why our children are a part of this petition. And then as he went to go walk back onto his own property, he made a threat towards my husband, saying, "I'm going to pursue you." Is that what he said? And then that is what led to his arrest for that.
Yeah, he said, "I'm going to sue you."
It was kind of weird how it happened, because he had come over and then it just so happened there was a cop driving by and he pulled in on an unrelated topic between him and his wife. And he told him to go back out on his own property, and then he was mouthing off to the cop, and then it escalated. He ended up getting arrested from that. But in the meantime, he had threatened us twice. And the first time the cop was like, "That's a threat. Go back on your own property." To go over there. And then while the cop was then on their property is when he made the second threat, and that's what got him finally arrested. And that's the second instance. The first instance, he was mowing his lawn with the deck all the way down, and it was flinging rocks into the side of our shop. And then, so it's like his house, our shop, apartment, and then Jeff and Dawn's property. And it was just flying over the fence, hitting it. So I said, "Hey, can you raise your deck up?" And he just flipped me off and then went back to mowing. So I just sat there and videotaped it. Then he came over to me. He's like, "What's your problem?" Called me the N-word, said he was going to call the cops. And I was like, "You should." So then we talked to the police officer. He said that we should look into doing a protection order if he's coming onto our property, which after we had that conversation, he came into our yard where I was doing a flower bed, walked through our flower bed, down the property line towards Jeff and Dawn's. There's a dividing fence there, and then back onto his property. So the cop was like, "Well, he's trespassing. You should possibly look into that." And then it was, I don't know what the time frame was, 2 weeks, 3 weeks after that was the second incident. And the scary part was he was coming into our property while our kids were in the yard aggressively. It wasn't like, "Hey, bud, like, what's going on here?" It was aggressive.
All right, is there anything else I need to know before I hear Mr. Morgan's side of it?
Okay. Mr. Morgan might be having a bad day today.
Mr. Morgan,
yeah,
go right ahead, sir.
So the incident of rocks being flung is from March 23rd, where Devin proceeded to stand on some object or hold himself up on my 6-foot privacy fence in my backyard, where he continued to record me while I was mowing. I always mow my yard in an L pattern because of rocks. I go down my fence line of my other neighbor, I turn right and go down their fence line. That puts my rock guard that's on my deck, as well as my chute, points anything towards my house to cause damage to my house. That way I don't cause damage to anybody else's house. So that's from March 23rd. They say they were going to pursue something. Why are we waiting till June 6th? Why did you file on June 6th when on June 3rd I had filed? June 4th, I got the temporary order granted. June 5th, I got the Swansons served their temporary order. And then on June 6th, not only did the Swanson, but these people too, decided they were going to go down to the courthouse and try to get a cross order, which was denied. But I guess the Swanstroms were, or not Swanstroms, but the people in the courtroom right now were granted a hearing, which I don't know how, but somehow they failed to serve me. So I don't know how anything we can talk about March 23rd being part of this incident when we're March April, May, June. We're almost 4 months. And there was no way I flung rocks. So, but the only thing I can tell you is that Devin did decide to hop over my fence. He did record me, which, if I am correct, under, I don't know the technical RCW, but you're not allowed to record somebody or take pictures of somebody in their own backyard. Did I tell him he's a piece of shit? Correct. Now we fast forward to where I got arrested on Memorial Day weekend. Memorial's Monday, so I got arrested that Saturday by Officer McClellan. I have gone to court on it for my arraignment. The judge did let the prosecuting attorney know that Isaiah, well, in the police report, it does state that I said, I will fight. You're right. I 100% did. Once I got out of jail, I started pursuing this order to protect me from these people because they've done nothing but cause problems. We've got sheds being built too close to our property. It doesn't meet city code. I've already been in contact with the city. I have notifications. I should hear from them later today on that. I got gardens being grown right on my fence, causing weeds and all other stuff. I usually spray my fence line with Roundup. I've tried not to do that because these gardens are right on my fence line. So as far as I'm concerned, they're encroaching my property. They're invading my privacy. So at this point, you know, I just wish that the previous case would have been granted, because now I'm being attacked not only by the landlord, but I'm being attacked by the renters as well. Clear as day, they caused a nuisance, his renters. And then he's sitting here doing this as a retaliation on me. And also, if you could please look at the notice of serve on there. No evidence was served, just a notice of hearing.
Thank you, Mr. Morgan.
Yep.
All right. Once again, this is not harassment. I'm sorry about that. So the conflicts between you as neighbors are not harassment. Your issues about how the lawn is mowed, where trucks are parked, displays of signs and decorations and windows, you know, you're gonna have to find a way to deal with that in a peaceful way. But harassment means something else. It's a course of conduct directed at a specific person that harms them. And, you know, you may have heard an earlier case involving stalking, which was a really good example of when that occurs, but that's not here. So this request is also going to be denied. Do you have any questions about that?
Does she have the Wi-Fi password?
I just have
on the
proof that he's lying.
Behind her?
I have videos of him launching the rocks.
Okay. All right, fine. I mean, you talked to me. I understand there was a conflict over how he was mowing his lawn. Okay, then that may have caused harm. That may have caused damage. I don't know. I could easily see rocks being flung from a lawnmower, damaging things like cars and windows and sort of like that. Fine. There may be a remedy there for that, but it's not harassment.
Okay. What about coming on to our property?
You can trespass him.
But you got to remember, you came over my 6-foot fence.
Hey, let's stop. Now we're not going to continue this in this forum. Okay. The parties have asked me to make a decision about an anti-harassment order. You've asked for an application of the law, an anti-harassment order. I've listened to your evidence. I've told you that there is no anti-harassment here. There is no harassment that can be granted. That's the end of it. Okay. Now you've got to find a way to get along. If you're going to continue to go at each other, maybe you're going to be back here and next time it will be harassment. I don't know. But I'm saying you're going to be neighbors no matter what happens here. and probably a good idea to find a way to get along peacefully in your neighborhood. All right, but for today, what you've asked the court to do, which is grant an anti-harassment order, I can't do because the law doesn't support that. That's what I'm here to decide. All right, that'll be the end of your hearing. I'll get this order ready for you so that you all can have copies of it.
Yeah, they'll
So
be back.
I have one quick question.
Oh, sure. Ask away.
Yeah, go ahead, Mr. Morgan.
So if emails continue to get sent to Snap-on, does that warrant warrant harassment? Because technically, the truck I own.
Mr. Morgan, I can't give you an advisory opinion on whether I'll issue an anti-harassment order in the future. That wouldn't be proper. Here's that.
Okay, thank you.
The clerk will make a quick copy of that for you.
They'll be back either in this court or in a criminal one. They need to learn to get along. What finger did he just show us? What did you just do? All those Snap-on drivers dressed like a NASCAR driver. Or maybe it's vice versa. I don't know. All right. Do we find out why Angela's here? I want to know what's in the background. We've got the Wi-Fi address already.
Michelle Armstrong and Angela Edwards.
Here we go. Here we go. Angela's giving out the Wi-Fi password.
Make sure you're here. I see Miss Edwards here. I see Miss Armstrong here. Okay. Now in the case 25-176, Miss Armstrong is the petitioner. And Miss Edwards is the respondent.
Nope, she's not a JA.
And then in number
she's the respondent.
25-198.
Suit and
Miss
countersuit.
Edwards is the petitioner.
Yes, we got it both ways. We get to hear both people complain.
Miss Armstrong is the respondent. So you've each got petitions against the other pending on this calendar. So what I'll do, probably make it easier for both of you, is just to hear them both at the same time. I know that I'll decide them separately on their merits, but it's probably easier for you to just go ahead and talk to me about both cases together, and instead of just doing two separate hearings that both involve you. So
3 hours of deliberation so far.
I'm going to have both of you raise your right hands, please. And do you both swear the testimony you give in these cases will be the truth, the whole truth, and nothing but the truth?
I do. Yes, I do.
All right, and Miss Armstrong, I'm going to have you go ahead and go first. And like I said, you can address both your petition and Miss Edwards' petition.
Thank you. I would like to ask the courts of Thurston County for a 1-year protection order to be granted today. Angela has harassed me, my children, my family, and friends since she has moved in next door to me. There have been numerous small aggressive behaviors from Angela towards myself and my children. Over the years Angela moved in, the harassment has continued with increasing frequency and increasing aggression. A few years ago, Angela put up a fence, and near the south part of the fence, she has put up a rock wall. Angela has trespassed at my property beyond the fence and beyond the rock wall numerous times. She and her husband have made a habit of moving my trash can. Angela, in July of 2024, trespassed numerous times in a single day. Police were called more than once that day to remove Angela from my property. Her husband also removed her from the property that day. She was drunk. She was outside tending to her lawn. I was doing the same. I had my infant child with me. She went beyond the rock wall, beyond her fence to attempt to attack me. As a single mom, I had nobody there to help me, so I ran inside. I locked the door. She attempted breaking and entering into the home. She was banging on the door, trying to get in, using her hands, her feet to try to get in. She would not leave the porch. I called the police. She was screaming. She said she wanted to kidnap my child. She said that I didn't deserve custody of my child.
Whoa.
Police responded. They told me that they had a conversation with her, telling her never to trespass onto my property, never to speak to me again. Police were called again. That's when they told me that they were going to take her to court about it. I was told that she was on probation for a year to not speak to me after that event. Since that event, she continues to harass me about my lawn, especially. She makes rude, snide comments about my lawn. She makes rude, snide comments towards my children. She kind of talks at me. I don't have any indication that I want to engage in a conversation with her. I have never indicated that I've wanted to engage in a conversation with her. I've done everything I can to ignore her and avoid her. She lives right next door to me. So she constantly concerns herself with my lawn, with my daily life. Very strange behavior from a neighbor that I've done everything I can to avoid. Her harassment is vindictive and it is directly attacking towards me and my family. She's attempted to have me evicted. The managers, we've had several throughout the years. They've let me know that she files complaint after complaint about my lawn, attempting to get me evicted. Not only is she harassing me, but she stalks me. She has installed a camera that faces directly at my vehicle. It doesn't face her property. It doesn't face any of her belongings.
That could be an issue.
Her camera literally stalks me day and night. She records my vehicle. She records my lot. I feel like her camera should be faced on her lot, not faced on my lot. It's very creepy, very much feels like stalking behavior aimed specifically at myself and my children. I'd like to ask the courts to ask Angela to change the placement of her security camera to face her lot and face her property and face her vehicle, not stalking towards me and my children.
There are two sides to this story. I want to hear the other side too.
After my temporary restraining order was approved, Angela quickly retaliated in an attempt to mimic my action and has filed a protection order petition against me. I've done everything in my power to avoid Angela. I didn't even know her last name. She knows the last names of my children. She knows the last names of the people who I'm near. I don't even know how she knows as much information as she does about me because, like I said, I've literally never even told her hello in my life. She talks at me. She yells at me. She's very snoopy. She tries talking to my friends. She tries getting information on me. She's a total complete stranger to me. And I've always noticed bullying behavior towards her, so I've done everything I can to avoid her. But having her next door, I see her often, and just yesterday she was outside listening to vulgar music that I don't want my kids to hear the lyrics of the music that she blasts really loud. And as I was taking my garbage out, she yelled at me, "Oh my God, are you serious?" And in her petition, she says that she doesn't like where I put my trash can. She doesn't like where I park my vehicle on my own lot. And her and her husband have gone to the lengths of even moving my trash can. So she yelled at me just yesterday. She has a protection order against her. She's violating it. She has showed that
Angela's
she cannot follow the police's instructions to leave me and my children alone. I'm the protected person. And yet in her petition, she implies that she has an order against me, which is invalid, which we also verified at our last hearing. When this one was continued, we verified that there is no order for me to not speak to her because I literally never have, and that we would be hearing her petition today. She is hyper concerned about my life. She hyper monitors my behavior. She's extremely interested in the daily lives of me and my minor children. Her stalking behavior is directly directed at me and my children, and it worries me greatly because she seems extremely vindictive and aggressive, and her being an adult being aggressive towards children is very concerning behavior. Angela has attempted to get me evicted countless times in numerous different ways. She's also called the authorities on me like I said, I've done nothing to her, and the only time that she has had anything brought to my attention is her petition that I received notice for. Other than that, I've never had any sort of indication that I've done anything to even approach her. Like I said, I've done everything to avoid her.
What song is Angela listening to? Wrong answers only.
When I do have my friends here, she instantly, or when I'm gone, she instantly tries to have conversations with them. She tries to convince them that I'm a prostitute. In her petition, anytime she talks to anybody about me, she instantly tries to claim that she knows that there's prostitution at my home, which is just very bizarre behavior to me because she doesn't know anything about me or my life, and yet she concludes a vast array of very negative things about me. Her aggression towards my children is admitted in her petition. She notes that she is agitated by my children when we do chalk art or when we play ball or when we play toys outside while we're minding our own business, living my own life. She accuses my child of, several different things in the petition, which shows that she has anger and aggression behavior towards my children. She claims that I have unauthorized tenants, which is none of her business. She continues to admit that she is annoyed by my daily behavior, which shows her feelings of aggression towards me, which are very concerning, especially considering she tried to attack me a year ago. And I really feel like she's just getting more and more agitated just for me just living my daily life. I noted that she's trying to contact my son when I have Washington State workers present. He's a baby, and she admits in her petition that she tries to talk to him even when I have Washington State workers here. I'm involved in several programs, and the only people who are allowed to have authorization to speak to my children when I have Washington State workers around are people who have been approved by me and approved by the state. So her attempting to talk to my children, even with Washington State workers present, is a direct interference of my involvement with the programs because, like I said, she's supposed to have permission to be able to be associating herself with the children, especially when there's workers here. She has no respect for authority figures. She wouldn't respect the police telling her to leave me alone. She doesn't respect the fact when I have Washington State workers here, she won't leave me alone. She admits in her petition knowing that I do not want her to speak to my children. And she admits that she knows that I will redirect my toddler to tell him no if he's ever attempts to say hi to her because he's a baby. And he doesn't know that she has animosity towards me and my family, and she has attempted to harm me while holding my baby. And some people develop obsessive personality types, and Angela has demonstrated behaviors of an individual who will not stop harassing me and stalking me and my family, my minor children, without an active protection order in place. Angela's petition makes unsubstantiated and unexplained claims with no explanation for several of her requests. I've done everything in my power to avoid Angela, avoid everyone at her residence. Angela monitors me daily and has been for quite some time now. I do not want to be harassed and stalked by Angela, nor miss any more work due to having to attend things like this. I have priorities, which are providing for and protecting my children. I need to be attending work and not dealing with harassive neighbors. So I really feel that this order is very necessary. I would like to please ask you to grant a 1-year protection order against Angela for the safety of me and my children. Thank you.
What are the bets that Angela drops a cursey word here?
All right, Ms. Edwards, can I hear your side of it?
Absolutely, Your Honor. So everything that Michelle just said is a complete out lie. She did not say one true statement through that whole conversation. And she actually didn't even read the petition correctly because a lot of things that she just said never happened. And she read it out of context. I am a university professor. I was a licensed pre-K through 12 instructor up until recently when all of this stuff started happening. I'm a mandated reporter. And so Michelle has had her children taken away from her because of abuse. And she does not have custody of any of her children. Her older two kids just recently started seeing her for the summer break. But yes, I will, the only thing that I can agree with is that a lot of stuff happens because of the fence. So before I hardscaped my garden, as you can read in my statement, Michelle would take her garbage can and pile a bunch of sticks in my yard almost every week. And this went on for months on end, months on end, months on end. And it's extremely irritating. And she does it because she knows that it gets to me. I have never spoken to her since a year ago. I don't even know where she comes up with that story. I have never tried to attack a child. Matter of fact, we used to be on speaking terms. And then there was a lot of stuff going on next door. The police are always there. The reason that I have access to a lot of information is because I'm friends with all the neighbors and they tell me a lot of stuff. And so that's where I get my information. My camera is not directed at her driveway. I have the camera turned as far as I can on, it's a door cam, it's my door cam. And I have it turned as far on towards the house that it will possibly go. But the door cam will move when it picks up movement. I don't have any control over that. And some of the evidence that I have, that I've provided, I have contacted the sheriffs in the past over her frequency of visitors that she had. As I explained, there was a time when she broke up with her boyfriend that she had a different gentleman visit her every single day for weeks on end. And
sorry, that's not your
she
business.
also admitted to some of the neighbors that she was hooking for different things. So that's where I came up, got that information from everybody talking about it. And it was the sheriff and my attorney who advised me to collect the evidence because they can't arrest her based on having multiple partners. They needed more evidence than that. So that's that. So as far as her,
did you do your
her
own
behavior,
sting?
she is the one that's aggressive towards me. She does things to purposely taunt me to try to get me to react so she can entrap me. She does this every day with her trash can, with her yard. I'll give you a couple of examples. So when the final court date for the criminal trespass happened and I entered into the contract, I came home that afternoon and Michelle was piling up a whole bunch of garbage, random garbage, spare tires, different weird stuff, and put it all in the front right next to my rock wall. And then I saw her kicking my fence. So that was a little strange. It's interesting that she even filed this order to begin with, because if you notice the date of when she filed and when we had our final inspection, that was on June 3rd. She filed it on June 5th. And I don't have any control over what the managers do. I don't know why she thinks that I'm doing it. We have rules, very strict rules at our community that we have to follow. And Michelle also has mental health issues. She's been to the psych ward at least 5 times since I've been there. And there is records of that. As far as me being aggressive towards her children, I have no clue where she even comes up with that. Matter of fact, the first time she went to the psych ward, I helped a neighbor take care of the kids because she had like 8 kids over at her house and it was just a lot to handle. So she asked me to help out with that. I have no idea where she came up with, I tried to kidnap her son and I never tried to attack her. And as far as this particular case is concerned, I'm not understanding why we're re-going over last year's court case. She's just going over it again and again and fabricating new materials that never happened. I have never spoken to her. I have never been in her yard. And the thing about the parking and the garbage can. So
I've never been in her yard.
She wants me to stay away from her. I want her to stay away from me. Yet she parks as close to my fence as she possibly can, because I do a lot of gardening. I garden almost every day. And another example of how I feel like she's taunting me and retaliating and trying to annoy me with her passive aggressive ways. So she hadn't mowed her yard, and I know that we can't make her mow her yard. It's irritating, but I understand that. But she'll let her weeds get to about 2 or 3 feet tall. And she hadn't mowed her yard for almost 2 months. And she finally mowed it last Sunday. And then she got served papers on Monday, and it was just odd that she had mowed her yard already. She had a supervised visitation that day with her younger child. And then after they all left, and I had been outside all day, she was inside. And so she comes out later and mows. She's like a foot away from me. She went back and forth a couple times and then went and put the lawnmower away. And so that's where I feel like she's just taunting me to get a reaction. She wants me to break my contract so that she can get me into trouble. I haven't done anything to her. I'm allowed to play music in my own yard. And her dogs have always been an issue. Her cats have always been an issue. So one of the biggest reasons that we built the fence was because of the dogs and the poop, and that her kids would keep leaving their toys and their stuff in my yard.
The poop.
And I would never say anything about it. We just let it sit there for days on end, and no one would ever come and pick it up. And so that's extremely annoying. Anytime that you try to tell her, or if I try to, or a neighbor tries to kindly approach her and say, hey, this is going on with your son, could you please like ask him to stop? And she says, oh, my son doesn't do that. But yet we watch him and we see it and we hear it. So, and then last weekend, I think it was like Friday or Saturday, I was sitting in the living room with my son. We heard some strange scratching noises. We opened the window and her cat is clawing at my screen and damaged it. Her cat comes into my yard almost every day. It's extremely annoying. Since I've had to pick up their poop for so many years, I just get really agitated.
Your son
and then her dog that
just
she has staying there
smeared
now,
feces
she
all
always has
over
a
my
different
bathroom.
animal all the time. But this new dog that she has, I've seen it off the leash like 4 times. 2 different times just recently in the last couple of weeks, it's come on my property. One day it was running away from Nolan and came up on my porch and jumped on me. And so,
Ms. Edwards, I'm going to ask you to take a couple minutes and wrap it up, okay?
all right. So there's that. And then that's what I'm saying. I'm the one that I feel like I'm being harassed, and she taunts me over and over. She does passive aggressive things all the time. And if you look at her record, she's just like filing civil protection orders left and right. I haven't done anything to her. As far as attacking her, that's all lies. Like I said, everything that she said today was a misallegation and a lie. She fabricates things. But if I'm on a contract for the items that happened last year, that's done and dealt with. I haven't done anything to her. I haven't been in her yard. I haven't spoken to her. I have not spoken to her children. And I explained that one time of what happened when Cyrus was calling out to me. So, and I don't know how she expects me to understand state workers or whatever that, I don't even understand what all of that means, but how am I supposed to know who a state worker is and what the laws and rules are against that? I don't understand that. But Michelle is very unpredictable. She has manic episodes very regularly. It often gets the police are called, the neighbors are involved because everybody's outside. She disrupts a lot of myself and the neighbors. again, I have never been aggressive towards her children. They don't even live with her, like I said. So she lied on her petition order that they live with her, because they don't. And it's, yeah, everything is annoying. She just taunts me and taunts me and taunts me. And I heard the earlier case.
All right, Ms. Edwards, I think you're starting to repeat yourself. You've said all these things before. So if that's all, then I'm going to go ahead and give a decision to you for both of these petitions.
All right.
All right. So in both matters, I mean, it's kind of similar. I'm hearing allegations about conduct between neighbors that's annoying and, you know, difficult and maybe unkind, but I'm not hearing anything that I can credibly find constitutes a course of conduct that's harassment in either case. I mean, you know,
I'll be back.
Your neighbors, you know, obviously have some friction in your relationship, and I can tell by the nature of the allegations made in the petition that, you know, these things are annoying, but I certainly can't find that these are courses of conduct that are harassing toward the other. Just neither one of you have demonstrated by preponderance of the evidence that harassment has occurred. So in each petition, I'm going to deny the petition for anti-harassment orders.
Thank you, Your Honor.
All right, and the court clerk will send you written copies of those orders later today.
I guess it's cheaper to file a motion with the district court than pay for a therapist, and that's what we're getting here. It's cheaper to have the magistrate hear you out and let you speak, and then tell you you're full of it, than hire a therapist and spend a couple hours in treatment. That's what it is. It's the cost of healthcare. That's what's causing all these issues in Thurston County, Washington. So, oh my goodness. I don't know who's right, but they're both wrong. I can tell you that. Angela, get your nose off the fence. Quit looking over the fence. She's parking too close to my fence. Well, your fence is where the line is. That's where your cares stop. I'm a mandated reporter. She hasn't cut her grass in 2 months. I'm sorry. Mandated reporter is a serious thing. It's a real thing, and it generally involves children and mistreatment. But didn't she go like from I'm a mandated reporter and like straight to the lawn care issue? Just... I need some words of wisdom.
Next matter will be
from
Jerry and Candace Livingston versus Jeffrey Hughes.
Tell me it's more neighbors. Hello, Candace. Please tell us you've got something substantial.
Livingston. All right, and Mr. Hughes, are you there?
Yes, we're both in portrait mode.
He jumped off of Zoom about an hour ago.
No, he's here.
All right. Did he drop off?
Yeah, I don't see him here.
Okay.
Maybe his phone died.
All right, so this is number 25-181. I can see from the record here that Mr. Hughes was served and he was present earlier on the calendar and has not remained for his hearing. So I'll make a decision based on the contents of the petition. It looks like that petition was heard and a hearing was set by the court.
He didn't show up? Man, that's
Your Honor, may I kind of add to something?
Oh, sure, please do.
Not really, no. I mean, I'm
okay.
Ex parte?
decision as to whether to issue an order based on what was filed and what Mr. Hughes had notice of. Yeah, I think that, yeah, I did review this petition earlier. There we go. All right, and there was some supplemental evidence filed as part of the petition.
Judge, you're going to have to read that out loud because we can't see what you see. I didn't know you could do this. I mean, what a smart thing to do. File your paperwork, show up for Zoom, leave before the hearing. Now they don't get to say anything in court. It's all just based on the paperwork that's been submitted. If you have better paperwork, you win. I had a neighbor who thought they were mandated reporters for my trees one time. Filed a complaint with the city, with code enforcement over my trees that were encroaching apparently on the sidewalk. 2 dwarf fruit trees. And I was given a warning, a citation, where I had to fix it within I think it was a 2-week period. And I did. I fixed it. I carved the trees into 2 letters. The first tree I carved into an F, and the second tree I carved into a U. Only visible from the street. Like you had to be straight outside looking at my property, like driving by. That's when you see it. And I carved them into an F and a U because I was fed up with people just not coming to me and saying, hey, can you cut back your trees? Poked me in the eye as I was walking by or something. I'm like, I would have done that in a heartbeat. But the first thing to do was call the city. So my FU trees, I posted pictures on Facebook. The sheriff from my county thought it was absolutely hilarious. Actually came by to see the trees in person. Loved it. I sold the house. And when I sold the house, the trees were still pruned into the FU shape. But the realtor pictures did not capture the glory. I know I could have ended up in a court just like this over my trees. Christy G, I'm so happy to be a part of this family. Glad I didn't have an FU tree next door. Yes, I sort of feel bad for my neighbors across the street, but I think they were at an angle far enough off that they didn't see the full letters. It is a true story. Yes, I carved my trees into an F and a U. I was pretty proud of it because a tree does not want to grow in an F shape. I had to get very, very creative to trim it properly. And trimming something in 3D like that, if you check Street View on Google Maps, now it's changed. New homeowners, I think they've actually taken out those trees, or at least one of them. But they took out almost all the trees, installed solar on the roof, cut down the tree that had the swing.
All right, Mr. and Ms. Livingston, I've issued your anti-harassment order by default. That order's in effect for the next year until July 7th of 2026.
Okay. You win just for showing up.
Clerk will send you your copies of that before the end of the day.
All right, thank you.
Thank you.
I've actually shared the pictures here.
We have an unaddressed case here. That's Ayden Tooley versus Matthew Green, number 25-193. And neither party is present. was no temporary order issued and notice was not served, so this
dismissed.
Will be dismissed.
Okay, I'm looking for my trees pictures. Hang on.
And then you tell me, but I think we
found him. I think he's done. He just said he's done. He just killed the stream. Okay. I only have pictures of them individually, not side by side. Hang on, they're in the wrong format. I have to reconvert them. Okay. You guys get to see my trees. It's been a long time since I've shown these. All right, so here was my F tree. I thought I was pretty proud of that. That's the F. And here's the U. There you go. You got them. Those are my trees. I'm serious. I did it. I still don't know to this day who it was that complained and had an issue about my trees, but pretty much it killed the trees. But I was not kidding. I mean it's basically. Oh, hang on. Whoa, whoa, whoa. What do we have going here? What's going on? Just saw movement.
Counsel, before the jury comes in, I just want to let everyone know that the court did receive a note from the jury. I'm going to mark that note as a court exhibit. The note reads, "We are hopelessly deadlocked, 11-1 on the charge of murder at count 1.
11-1.
Signed by James Stolman, jury foreperson, 12:47 p.m. My intention is to bring the jury in.
11-1.
Give them a brief instruction to continue deliberating, and then send them back out to continue their deliberations.
They're not supposed to give the count. But it's
Counsel, do either of you wish to be heard on the note?
No, Your Honor. No, Your Honor.
So I would ask my clerk to mark this. Thank you.
It doesn't say which
for
one.
Jury to be brought in.
It doesn't say which way this is going, but we have here, I believe, an Allen charge type request. There may be a more formal version that could be offered later, but 11-1 and hopelessly deadlocked. That means that one person will not move. One person will not move. one person, at least one person, believes that what he did that night was, and they said as to the count of murder.
All right.
I wonder if they agree on the others.
Council, please stipulate that all 12 members of our jury are present.
State will stipulate, Your Honor. Defense stipulates, Your Honor.
Thank you. All right, ladies and gentlemen, I did receive a note from you regarding count one and the fact that you are deadlocked on count one. That has been marked as Court Exhibit 7. Look, I recognize that most of you, if not all of you, have never been through this process before. There are numerous exhibits and many days of evidence to consider. I did instruct you to consider all the evidence. By the court's estimate, at the time that we received the note, which was 12:47 p.m., you had been deliberating for just about 2 hours or less. Please remember, each of the 4 counts must be deliberated upon separately. If you would like to deliberate on counts 2, 3, and 4, and then return to count 1, that is fine. At this point, I simply suggest that you continue with your deliberations. You should review the evidence and the position of each juror to determine if any evidence has been overlooked or any juror's position misunderstood with respect to either the evidence or the law. Please continue to discuss and consider the opinions of other jurors. Kindly explain your views and listen to the views of others. Majority, please listen to what the minority has to say. Minority, please listen to what the majority has to say. Ultimately, you will make up your own mind and decide this case based on your own individual judgment and conscience. But at this time, please return to the jury room to continue on with your deliberations. Thank you.
All right. Either the jury all believe, 11 of them believe this was self-defense, because this is on the murder charge. This is not on the assault charges, but this is on count 1. There is at least one person that believes that that was self-defense.
Nothing from the state, Your Honor. Not from the defense.
All right, court stands in recess.
All right, let's go to recess.
We'll keep an eye on that as we keep the audio on as well in case something happens. But at least one person believes that the count 1, which was the Jimmy McGrath charge, which was the charge of murder, believes that was self-defense. Hopelessly deadlocked on that. That means one person is not guilty and the others are guilty, or 11 are not guilty and 1 is guilty and refusing to move. That is, I do apologize. I'm not going to go to the Turtle Boy hearing. If the folks are asking, I'm not jumping over to that one. I haven't covered his stuff throughout the trial. I know he's had a great interview out there with Alan Jackson that did really well. But that's I've been avoiding that aspect of the trial as much as possible for the Karen Reed trial. It's possible they have not debated any of the other, because the instructions say start on count 1, go to count 2, go to count 3, go to count 4, right? We heard those instructions for days, Thursday through this morning. Wow. Hopelessly deadlocked. They've got to be like 100% convinced and refusing to budge to say hopelessly deadlocked. I've never heard of a jury saying after 2 hours we're hopelessly deadlocked before. Oh, wow. With only 20% saying guilty on Aria's poll, I'm guessing 1 thinks guilty. What does that mean? How do the lesser charges matter? Molly, in Connecticut, or in this particular case, they have things called lesser includeds. So you have the charge that you're charged with, like you're charged with murder and first-degree assault and second-degree assault, as Raul was. But under the charge of murder, there are lesser charges that are included. So they call them lesser included. It's like, okay, it might not have been murder, but it might have been manslaughter, or it might have been reckless endangerment, or reckless. I think it's reckless manslaughter. It's like trying to remember what the terminology is in Connecticut, but a lesser crime that sort of says, yes, death occurred, and it was because of something you did, and you did something wrong, but it wasn't that you had planned for the murder to take place. It would be a lesser included. They're on that first charge, and they're hopelessly deadlocked. They can only go to the lesser included if all of them agree that the state did not prove all the elements of the first charge. They can't go to a lesser included if they're like, well, we can't agree on murder. What about the next one? Nope. If they don't all agree, they're stuck. They're stuck on that charge. I think it's safe to go to lunch. Possibly. I've got the timer going again. She says about 2 hours of deliberation. Looking at in Connecticut what the rules are as to the Allen charge. An Allen charge is just for this. When a jury reaches a point where they're in a log jam, think of they're all bound up and stuck together and they can't make any progress. They get issued an Allen charge, which is sometimes called a dynamite charge. This is where you set off a stick of dynamite in that log jam and it shakes everything up. And then they say, okay, now try again. See if you can make some order out of that. Connecticut judges may utilize an Allen charge or similar instruction when a jury reports that it's deadlocked and unable to reach unanimous verdict. This instruction, also referred to as a dynamite charge, encourages jurors to reconsider their positions and strive for a unanimous decision. Looking at this, the controversy over this is an Allen charge can be coercive, potentially pressuring minority jurors to conform to the majority opinion. Okay, she doesn't have to give it word for word. I don't know if I'm just looking. I don't see if it has a limit to how many times she can do this. If they turn around right away and come back with another one, this jury is maybe not on speaking terms, or at least one person is not on speaking terms with the other. You've got 12 angry men going on right now in that jury room. The judge said to move on. I wonder if they will. Molly, you're welcome. Thanks for the great question. Appreciate it. Ivan, steaming. He's piping hot, mad. I don't have my phone. Where's my phone? I don't have my plug. I can't take a call yet, Ivan. I can't find my... the adapter I have 3 of. It's a goner. No calls today. Sorry. You got to put it in chat. I have the cable. Tell you what I'll do. It's a pain in the butt, but let's see if I can get Bluetooth to connect on the phone. Forget device. I have to forget the device and remember it like every single time. Okay, Evan, just for you. We're connected if you want to call. I'm not sure if you're in a place where you can, but it does weird things with the ringing and the beeping too when I have it on Bluetooth, but okay, we're going to be on 4 here. Bring the timer back. 3 hours, 40 minutes, 41 minutes now of deliberation here. The jury saying they're hopelessly deadlocked. Sorry, that's loud. Come on, Ivan. Hang on. Ivan, hang on just 1 second. Sound, speaker, roadcaster. Okay, can you hear me now? Ivan, you there?
Yes, sir.
There we go. So you're
Yep, can you hear me?
I can hear you. You're piping hot mad. What's on your mind with these lesser includeds or hung jury? What's up?
Well, for one, I've always hated the Allen charge. Whatever, I don't know if it was officially that. I feel as if either way, whatever the ratio is, whatever way it's leaning, I think I would just assume it's 11 guilty because what I've learned is that our chat and true crime people in general tend to over dissect everything. Certainly more than juries do. I feel like we weigh sometimes very differently than they do. And so regardless of what the poll said, I just have to believe that it's 11. I would be shocked. And if it is that, either way, regardless of which way it leans, if you truly believe this person is not guilty, and you've already made up your mind, that means their mind has been made up well prior to this. Now, whether that's appropriate or not, sort of immaterial. I don't know what the reason I dislike the Allen charge or the spirit of the Allen charge so much is the jury already knows what they're supposed to do. You give lengthy instructions about what their job is, what their duty is, what they're supposed to be doing. They don't need to be pushed over a line because so many times when that happens, the fate of somebody's life is in your hands, and you are essentially, for lack of a better way of putting it, being bullied into groupthink is all it really comes down to. And even if it's the other way, if they're 11 not guilty, and it's the opposite, then it's a travesty for the victims. And so either way, it is I don't understand how this hasn't been, brought up in some kind of higher court or re-looked at or whatever you want to call it. But I don't understand why it's appropriate to somehow admonish the jury for doing already what they are, tasked to do, and essentially saying that, the teacher has to come in and tell you what to do, is what it comes down to. I don't like it, and I don't understand what evidence could, I understand people are saying it's only been a few hours. Well, I don't think this is a case where there is a whole lot of nuance to. I mean, we know what happened, okay?
Right.
Now, whether there isn't some, hidden, theory of what happened, we know what happened, okay? We know, we may not know exactly the number of people, and I don't think anybody's, decision is coming down to the little facts that we don't have the, details of. The event, it isn't like, the trial we just watched where there's a dispute over, how the person was deceased or, who is responsible for it. We know. You either think he's responsible of the charge that's being, given to him, or you don't. So while I get it's only been a few hours, I don't understand what evidence could be re-examined for you to make up your mind in a different way other than coercion or being bullied or whatever you want to call it. So
yeah,
that's all I'm going to say because
I agree. The
if I
jury
say anymore. Yeah.
And we get demonetized. Yep.
Yeah.
Ivan, thank you. You're welcome to stay on if you want, but I know you're a busy man.
Yeah, I'll hang up and listen.
All right. Thanks, Ivan. We'll see you, man. Love you, man.
Yep. Love you. Bye.
All right. A couple things. The jury goes back in there, and it's going to be 11 people going, so, and one person going. And I don't know who texted me this, but if you Google Norman Rockwell, The Holdout, I think it is. The Holdout. Norman Rockwell is an Americana artist who painted pictures, and he's got this. It's basically a scene inside a jury deliberation room where 12 people are on the jury, and there's one woman with her arms folded, sitting on a chair, and 11 men leaning around like, with all the looks, all the faces around looking at it, and that's what's going on right now. And I mean, it's like foretold the future when you got to send that text this morning. It was, it's incredible to think that's happening here. And now, if that one person changes their mind, is it because that they went back and they listened to the other side and like, oh, you're right, that does make sense. It is murder. Or is it, everyone was pressuring me. Even the judge is pressuring me, saying I have to go back and do this. So she's expecting me to change my mind. I don't know what's going on. Rosemary, we just got a note from the jury. We just listened to in court where the jury came back in and said they had a note. They said we are hopelessly deadlocked on the count of murder, first charge, count of murder, 11-1. Now it doesn't say which side was 11, which side, if they're saying this is self-defense or not. But I don't know if this will force somebody to change, because the fundamental factors here is that one person, at least one person or 11 people, are looking at this and saying this was justified, this was legal, the action he took was reasonable, and that he needed to do it to defend himself. And in that light, it was okay. It's justifiable homicide, literally. It's legal under the law to kill in this situation. It's a tough compromise to go from that to switching to say, actually, no, he was not justified. You'd have to look at the facts and say, okay, maybe he either provoked this. Now I have to change my opinion on whether he provoked it, or that he. Let's see, somebody's trying to call. Let's see if it works.
To accept, press 1. To send a voicemail, press 2.
The phone was so loud, I'm sorry. Hello, this is RA. Who's on the phone?
Hanging with Yins.
Hey, how's it going, hanging with Yins?
Everything's going good. I actually did a jury duty where there was 11-1 holdout, and it was very frustrating, and it lasted 2 more days to convince that person that the person was not guilty. So 11 of us voted not guilty, and this other person says she could just tell by looking at him he was guilty.
Oh, no.
Oh, yeah.
He looks guilty?
I think she was. Yeah, I
He's
think she
got
was
that
trying to get
guilty look
attention.
about him.
Yeah, I think there was something wrong with her. She looked like she was trying to get attention, and we're like, all of us are just, no, he's not. I think it was a police setup.
Wow, that is
because they found a gun in his apartment after he got out. He turned the keys over, and then the police were doing this random search of his apartment after he moved out, and they happened to find a gun. And it was all like, no, that's just too crazy. That's just too fishy.
That would never happen.
So that was our case.
The
It
police
was
wouldn't
interesting.
plant evidence, would they?
They said they found it. Yeah, after he turned his keys in, he was already out of the apartment. Yeah, that happened.
That's crazy. I hope the one experience I have with police and evidence is that mine went missing. I found a gun, and legally in the state where I found it, you turn it into the police.
Yeah.
If it was not used in a crime, it was not stolen, not reported stolen. After, I think it's 60 days, you go down to the police station and you get to keep the gun. Congratulations, it's now legally
Yeah, you're
your
supposed
gun.
to. Yeah.
I did that.
Yeah.
Filed the report, turned in the gun, went there 60 days later, and they said, we have no record of you turning in a gun 60 days ago.
It's probably in some police officer's collection.
It was
or
not
something.
a good gun. It was a Ruger Bearcat, which is a .22 revolver. It's like the grips were all cracked and everything. It needed serious love and attention to get back into working order. Rust. It had some issues, and it's new. I'm thinking $225. Okay, that's about where it's at. Okay, so it's
That's
not
not very
worth committing
valuable.
a felony for, right?
Yeah,
But I'm
right.
worried that if it went missing and a police officer had it, what if it got found again? That it's if it's untraceable, if it's hasn't been stolen, hasn't been used in a crime. Yeah. Anyway.
Yeah.
Anyway.
Yeah, but I've done the 11-1 deal, and it's not fun.
Yeah. That was
Yeah.
the story I just shared happened the day I was late for my first date with my wife. and that's why I was late.
Oh.
But wow, 11 to 1.
Yeah.
I imagine that first day and the second day, that must have been just, you guys were not going to change. You're not going to be like, oh, all right, well, maybe we'll come your way. If it's just like,
it was just like,
looks guilty.
It was so suspect. The police, it was just like how, you just want to shake the woman. Like, how are you that naive that you think that somebody just left their gun there after they moved out and everything was gone?
Yeah.
But the gun, that's the only thing they're going to find?
Yeah.
You know, it just reeked. The whole thing just reeked.
So
I'm like, no.
gut feel on this case with Raul Valle, sorry. Do you think that one holdout is a guilty or not guilty?
I hope it's not guilty, because I don't think he tried to kill anybody. I think he manslaughter or something, but not first degree.
Yeah. Yeah.
You know, I don't think he went there trying to kill anybody. So,
I agree.
Alrighty.
Thank you very much. Thanks for the call.
Thank you.
We'll see you.
Bye.
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 All right. I think it's safe we can go to lunch. I've got my fingers crossed that we can do that. I've got a salad here, which I'd like to eat. It's delicious. Look at that. There we go. It's not Pinterest worthy, but it's next to it. I have a question. When was the knife looked for in the woods? As soon as they heard about it, so 6 months later. Because they didn't get any news about the knife in the woods until those two boys came with their lawyers, asked for immunity, and gave that testimony. So it was 6 months later. The jury had sent one note indicating they were hopelessly deadlocked. They got the Allen charge, and they were sent back in to go back to work. So we'll see what happens here. Why you get a receipt for the gun, getting lost is common. Golden Mare, I got the cop's business card, which you'd think would be enough. I should have got a case number on it. Yeah. The whole bag of croutons on that salad, got any lettuce? It's buried under there somewhere. All right, we need 97 more likes to reach the threshold for 1,000 likes for the live stream. And I think what we'll do is we'll take a very brief break. I'm going to eat my salad here at my desk because if anything happens, we're going to pop live again. There's a chance the jury could flip right back and say, nope, there's nothing you can do that will change my mind and nothing you can do to change your mind. So we're hopelessly deadlocked. I wonder if they would go to those other charges and say we can agree on the others that they were either self-defense or get a partial verdict, right? I don't know. When do the alternates come in? The alternates should not be replaced unless there's a problem with the first juror. And now there are ways to remove a juror that's deliberating, even against their will, but you have to basically allege that there's something improper going on with them not following directions or refusing to follow directions or refusing to deliberate or something like that. And a note would have to be passed to the judge, and the judge would probably talk to the people and then make a decision. If it was that quick, it was 10 guilty. I agree. It seems like locally there was a lot of pressure and a lot of uproar and negative feelings towards the defendant in this case, from what we can see from the news. Tried Old Bay on scoops and melted cheddar last night. It's like nachos with Old Bay seasoning. It is yummy. It is really good. All right, we've got another call. Let's see if we can. I'm trying to. It takes forever to connect. Hang on. Hello, this is RA. Who am I on the phone with?
Hi, it's Amy Mancy.
Amy, how are you doing? Sorry, the volume just comes in so loud.
Good. I can barely hear you.
Is that any better?
I can hear you better now.
Okay.
Yes.
Amy.
Yes, thank you.
Amy, what's happening?
Hey. Not a lot. I'm avoiding schoolwork and calling you.
Oh, good. Let's chat for a while.
So I was just about 5 minutes behind. I went back to hear the note, and then I went forward, and then I was still about 5 minutes behind, but I think I'm caught up. I have a question for you. Before the last caller, you were saying the 11-1 that they were just. I got confused by what you said. You had said that they thought it was justified, that he could have done it. Is that what you said?
If they're hopelessly deadlocked, that means one person has decided one way and 11 people have decided the other way. Not that they're like wishy-washy. The hopelessly deadlocked means the decision's been made and we're firmly on our sides. So either one person believes that the murder was justified or 11 people believe that the murder was justified. Because we don't know how the split is. They said 11-1, which they should not say. That's something we shouldn't see. The judge should not have read it, in my opinion.
Agreed. She shouldn't have read it, but I think she has to read it exactly how it's written on the paper.
Yeah.
So if you're saying, let's just say that it's 11 are the guilty. Let's just do it that way. And you say that they are saying he was justified. Doesn't that mean it's self-defense?
Yes.
Okay. But they can't even get to the self-defense yet if they can't get past the murder. Isn't that right on the jury charge?
Well, it's possible they went through all the charges and worked their way down and are hung because one person says it was self-defense and the other person said and the other side says, or one side says it was self-defense and the other side said they weren't. They can get hung by going through that whole process on charge number 1.
Okay. All right. I was thinking that it's possible they're not even past murder to consider manslaughter.
The way it would work is on charge number 1, if you were to look at a verdict form, let's just take charge number 1 by itself. Say that was the only thing that was on the form. And you were to look at charge number 1, and you were to see the jury filled it out saying it was self-defense. The way it would look is that the state has proven everything as to murder, but it's an exception because it's self-defense. So they would say, yes, they proved that it was Raul Valle who took the action, who killed Jimmy McGrath, and they'll go through and it happened in the county on this date. They'll go through all the elements, but then on the bottom you're going to say, but it was self-defense. That's my understanding.
Which matters when sentencing comes.
Well, it's verdict. There would be no sentence. So you would say, yes, we all agree on this, and then we look at it is a defense of murder to say it's self-defense. It's a defense to the charge of murder to do it in self-defense.
Here's what I can tell you. I hope I never have to be on a jury for a murder trial that has lesser included. I think they've got just a disaster, not a disaster, but so complicated, and on Thursday when I said, let's do the poll of all of the parts of just that one, I mean, it was a couple hours or so that she had read through just, charge number 1. And I can't imagine being done and deciding on that with all of that evidence in that short amount of time.
It's pretty quick.
But
it's pretty quick. But we know one thing: the jury did not read the instructions again, so because they'd still be reading right now. But.
Yes. Okay, that helps me understand, and maybe someone else had the same question, and that'll help them as well. I'm the kid in the room that asks the one question when nobody else is asking.
But everyone else has that question, so thank you for doing that. I appreciate that.
Yes. I am still that kid when I'm in a classroom as a para. I'll raise my hand and ask the teacher, "I'm sorry, I'm confused." And I've never had a teacher that minded me asking of, "Hey, wait a minute, I didn't understand what you just said." So I don't envy their position whatsoever. And I think this is going to take a while.
I think so too.
As it should. It's a big deal. And I can't read their minds.
Yeah.
I will tell you that there was a case that got finished up today in Australia that Grizzly True Crime covered earlier today. She made a post about it, and while I'm watching you and watching her at the same time, because all I do is true crime.
And she's awesome.
Not really, but she is awesome. She had a short little video about a lady who ended up being guilty for putting the mushrooms, the death cap mushrooms in the beef Wellington. I hadn't heard about it. She had covered it before, but I hadn't heard about it. The jury charge for that jury was 365 pages long, and it took
that's
six
not
and a half
a jury
days
charge.
to
That's a
read
jury
it.
sentence. That's terrible. That is terrible.
I know. I just thought I gotta call and tell you, 365 pages in 6.5 days. I mean, I would have forgotten days 1, 2, 3, and 4 by day 6.
Yeah.
I'd have been like, wait a minute. What did you say was the first one again? That's
I would have forgotten my
incredible.
name in that much time. I'd be like, I don't know why I'm here anymore. What is even going on?
Yeah, where am I? Who am I? Where's my car? I can't find my car.
This is not worth $8 a day. I can tell you that. All right.
Exactly.
Thank
All
you
right.
very
Well,
much.
that was it.
Yep. We'll
Talk
see
to
you.
you
Thanks for
later.
the call. Bye.
Bye.
All right. We're going to jump back up to Thurston County, Washington for a different court, different magistrate. One I like watching as well. Just happened today as well. So let's go this way. Oops. It comes in right now.
Morning, it's Thurston County District Court. Our motion calendar for Monday morning, 7 July. A couple folks in the courtroom, others appearing remote. These proceedings are being live streamed on YouTube to increase public access. Michael Burrow. Okay, thank you. Robert Mays.
President Counsel, Your Honor.
Anna. Morning. So we're proceeding on the motion to suppress.
We are, Your Honor, and the state's stipulating to the facts as presented by defense.
Okay, I haven't received a state response to the motion.
Yes, Your Honor, the state just intends to argue that the response says they don't believe they accurately characterize the law itself, but the state does agree, generally speaking, with the law, just the defense's interpretation of the law and facts.
Okay. Cadenhorn?
And for the record, Your Honor, Thomas Murphy, appearing for Mr. Cadenhorn.
Sorry. But I don't see Mr. Cadenhorn here, but sometimes the video doesn't display accurately, so maybe you are here. Mr. Murphy, thank you. Go ahead.
And Your Honor, I will rely heavily on the declaration, the motion, and memorandum that we have presented, but I am ready to proceed as well.
Sure. Motion, go ahead.
And Your Honor, we would ask the court to, at first we would ask the court to dismiss based on the state's failure to apologize, Your Honor. I'm drawing a blank in my mind. The state has not established the corpus delicti of the crime for driving under the influence. There are admissions made by Mr. Mays when he is contacted by the trooper in this case. These admissions were made prior to Mr. Mays being Mirandized. At that point, we suppressed those statements. There is no observed driving of Mr. Mays when the alleged violation is being alleged to have occurred. The state's relying heavily on the fact that Mr. Mays is the registered owner. He had the keys. This is insufficient at the time to prove that he was driving at the time of the alleged crime. The state also alleges that Mr. Mays was inebriated at the time of the accident. They're basing this on observations made by the trooper when he arrived on scene. Things that are said as flush face, watery eyes. Mr. Mays was in a traffic accident prior to this contact with the officers. There was an airbag deployment. There are many things that could have accounted for the observations made by the officer. I've also asked the court to suppress evidence based on there being no probable cause for detention and arrest. The officer conducts field sobriety tests of Mr. Mays. Again, there was an airbag deployment, which the officer, when he asked these questions of Mr. Mays, he never asked him whether or not he needs medical attention. He basically just goes into accusations of Mr. Mays being drunk, driving while inebriated. Then he begins to conduct the field sobriety tests in a manner that isn't necessarily voluntary or giving Mr. Mays a voluntary opportunity to do the tests. Basically paints him into a corner saying, I have you detained at this time. Will you do these field sobriety tests? It doesn't give Mr. Mays an opportunity to really volunteer or do them voluntarily. Also asking to suppress, again, reiterating what I said, any statements made by Mr. Mays prior to him being Mirandized. From the first contact with Trooper Cody Warren, Mr. Mays is not free to leave. He would not feel as a reasonable person free to leave at that time. There were statements made prior to being Mirandized that we believe should be suppressed based on lack of Mr. Mays being aware of his constitutional rights to remain silent. He's basically being interrogated by the officer, asking questions about whether he was inebriated, whether he was drinking, whether he was driving the car. And there were tacit admissions to driving and to have consuming alcohol made before he was Mirandized. We'd also ask the court to suppress the field sobriety tests. Again, as I said, these were not voluntary. There was no real meaningful opportunity for Mr. Mays to refuse to conduct the field sobriety test because at the time the Trooper Warren contacted Mr. Mays, he asked him to go to the front of the car, stand in this imaginary box, and conduct these field sobriety tests. For those reasons, we asked the court to not dismiss, but also to suppress any evidence that was gathered by Trooper Warren based on Mr. Mays not being Mirandized prior to the questions beginning.
So the state stipulated to this?
I'll get to you in a moment.
Yes, sir.
Hello, Mr. Burrow. Welcome. Hello, Attorney White, with your advertisement on the screen. Welcome. This is the belly shot. This is one step above the one-eye slant shot, which young teenagers, particularly female ones, seem to have perfected. Someone had to have filed to be the pool media, and if nobody files, then there may not be any audio or any video stream. If the judge starts snoring, I get a bingo. He's reading.
So I'm assuming that since I didn't see anybody, Deputy Watson or Trooper Warren have not been subpoenaed for the hearing.
Correct, Your Honor. I had no intention of calling them as we were stipulating to defense's facts.
They're stipulating to the facts.
And to be fair, this hearing's had to be reset a number of times, and I didn't want to risk them.
Great, actually, I noticed that.
He turned on the mic and then started whispering. Thumbs up, thumbs down, what?
And is the state intending to offer the police report in this case for purpose of the motion hearing, or just rely on declaration?
I would rely on the declaration of facts in conjunction with everything that's previously been found, which would be the police reports, the PC out of the police report. If the court doesn't have a current narrative, I can absolutely provide that to the court right now.
All I have is the motion. I don't have anything else.
My apologies, Your Honor. I thought the court had read the narrative in this previously. I will rectify that right now. The pertinent fact outside of their narrative is that the PBT reading was 0.24.
0.24?
Pertinent fact. 0.24?
0.24? That's the BAC? Mrs. Angels, there was one question. The jury said we're hopelessly deadlocked 11-1 on the charge of murder. Judge said go back, try again.
It's been sent to Madam Clerk.
So we get to wait. Actually, we don't have to wait because we're watching what happened this morning. We're going to fast forward. I'm sorry. I didn't mean to make you guys wait. I'm used to it being live. This happened this morning, so we're going to fast forward a little bit. Read. Oh, let's go here. Attorney White comes back on. Not looking for work. He has no interest in finding new clients. He's not hanging his shingle out there with his name up there trying to get people to call him. Probably would not be able to consult with you if you did call. Okay, so maybe his docket's a little thin, but he outs himself. Judge still reading. Kicks back, gets comfy. Still reading. Still reading. Oh, there we go. I think he's about done here. Attorney White just comes on for the commercial. He doesn't have anything in court. Oh no, I thought he was holding up talking to somebody. We have a road nearby called Frog Level Road. And it's full of frogs everywhere. Is he going to sit here this whole time? He's just reading a police report. Still reading. Guess he's getting paid by the hour.
I have here.
Oh, there we go. Here we go. He's going to start talking. Here we go. In the next 10 seconds, he's going to talk.
So the concern I have here, and the reason I was surprised, one, about the non-appearance of the officers for today's hearing, and the fact that I didn't receive any response brief from the state, was in reading this previously, the defense motion to suppress, there are some facts typically the court would have that aren't reflected in here one way or the other. So Mr. Mays was contacted standing outside of a Tesla, which turns out he's the registered owner of, and had keys. Everybody seems to agree with that. I don't see any indication whether there was another occupant of the vehicle. Doesn't say anything at all about that. Also noteworthy is the fact that contacted shortly after arriving on receiving the call from dispatch, but there's no indication in anything I've just looked at, which was just the first time presented to the court this morning, any information about the time of the accident. All we know is people are standing outside of an accident on the side of I-5. Nothing about, yeah, I checked the hood of the cars and they were still warm, so clearly it happened recently.
It's a Tesla. It's
nothing about that. Something an officer present in court would probably be able to answer.
Teslas don't have motors to
from memory. So we don't have much time. Did the accident occur half an hour before? Did the accident occur 4 hours before?
The hood of the car wouldn't work on the Tesla.
Well, I understand that, but on the truck it might. So there's no statement from the witness, from the truck driver who was struck saying, what time is the accident? Did this occur? How long have you been sitting out here? Nothing. So I have no idea. And Mr. Thompson, do you point to anything in here that can tell us when the accident occurred?
I would,
based on what has been stipulated to here today.
So it could have been sitting outside the car for hours just drinking? Is that what you're alleging here?
I would articulate that the cab call, as well as I think the line, again, where you're not abandoning our common sense, but you don't call an accident on the freeway in 4 hours after it happened. You call it in immediately after it happens, especially when there's been airbag deployment. And so law enforcement responded to a call within minutes of it being dispatched, which was midnight 22.
Right. I mean, I looked at that, but I don't see anything about anybody opining as to when the accident occurred. No, nothing other than somebody called and said there's been an accident. Nothing that said it didn't happen at 9 o'clock or 10 o'clock or 11 o'clock or 11:30, 12. The call was 12:20 or something like that, 12:21. So we have no way of pinning down a general time at which the accident occurred, which of course becomes problematic on a breath test if you're trying to prove that it was an evaluation of blood alcohol or breath alcohol within 2 hours of driving.
I agree. However, that would be a trial issue, Your Honor.
I understand, but I'm trying to make clear in my head, I don't see any evidence been presented to the court about the time of the accident.
Understood.
Okay. And then Mr. Kattenhorn, not in his declaration of facts, but in his arguing motion, makes a statement of fact saying that Mr. Mays was seized, and it's unclear as to when the seizure occurred, whether he means at the time of arrest or prior to the time of arrest. I would assume he means prior to the time of arrest because he's making an argument that Mr. Mays was seized prior to being arrested because he said the officer took Mr. Mays' driver's license. That's a statement Mr. Kattenhorn makes on page 18 of his motion. And that would specifically go to the issue raised by the defense of the suppression of any statements made prior to that point, if in fact that did occur. Was Mr. Mays already seized at the time the officer is asking him what happened?
And without conceding, Your Honor, that he did in fact take his ID, right, because that's not in the statement of facts and it's not in the report. So it should not be considered. But I would argue that law enforcement has an obligation to identify all those involved in the accident because they have to, or a collision, because they have to write a collision report. So that wouldn't constitute a seizure. That would constitute a constitutional or a statutory obligation of law enforcement. They do have to record that information down for the collision reports.
And an appellate court looking at this saying, okay, was at the time of these questions, was Mr. Mays free to go if the officer's holding on to his license at that particular point in time? What do you think the response might be?
I would say the appellate court would articulate that that's a fact that's not in the record.
Well, that's right. The reason it's not in the record is because we don't have a trooper here to say, no, I didn't take it then. I took it when I arrested. And it's not reflected in the police report, and we don't have a trooper here. So, but Mr. Kattenhorn says it happened at some point. I can't tell from his statement as to when it happened. I do think it would be relevant for me to consider the argument of defense that he had been seized, but I don't know if there's evidence of seizure prior to the statement or subsequent to the statement. The officer's definitely allowed to say what went on here. I totally agree with that. But the defense has asserted one little fact there on page 18, which is problematic. So we can deal with this in two ways. I can go ahead and make my rulings based on what the parties have stipulated to, and there are a whole host of issues raised, and I'll address them based on what I have. Or we'll continue this motion hearing until next Monday, and I would expect the trooper to be present for testimony to answer the salient questions that I think still exist.
And I've already reached out to my staff to see if anyone knows if Trooper Warren is currently around and not out on leave or something like that. We have a number of troopers who are out on leave. Hopefully I could give the court an answer in anticipation of the court's request. I will also email Sergeant Kirkaby. If the court doesn't mind me texting.
Go ahead and do your job right now in the courtroom. Is that Mr. Farag back there? No, that can't be him. There are no dogs. This would be frustrating if I was the on the defense side. I don't want the judge to rule today based on what was provided. It's like, here's the date we had in court, and they didn't show up. So you're just extending it out so they can get extra shots of this. But Mr. Farag is missing.
Court can give me 30 seconds. Okay.
Okay, but you're on the timer. 30 seconds. It would be epic if Mr. Farag walked back into the court. You're going to finish my trial. Lara Wilson, no verdict yet. Coming up on 4.5 hours of deliberation, though.
Thank you, Your Honor. I wasn't able to get in touch with Sergeant Kirkaby, but I will endeavor to have Trooper Warren appear next Monday.
I'll endeavor. I'll try. I'll give it my best effort.
Right, Jesus.
This is the slowest court ever.
Okay. I could rule on this motion, but it might not be what either counsel is looking for, because I think there's important information that's not provided in the police report or the stipulation of facts that the presence of an officer would allow the court to make appropriate and accurate ruling.
With that in mind, Your Honor, and no objection from Mr. Murphy, I will absolutely get in touch with Washington State Patrol today to find out if Trooper Warren's available next week. And if he's not, I will find his first availability on a Monday to come testify and relay that to both Mr. Murphy and the court.
Well, yeah, the other thing you can do, since there appears to be a willingness to go forward on stipulated facts, is have him write a supplemental report. I think these are important questions. What evidence does he have as to when the accident occurred? Were there any other occupants seen for Mr. May's vehicle? And the issue has been raised by defense about the seizure of a license. When did the license, Mr. May's license, take place relative to any statements made by Mr. Mays? I think those are issues that the court will need to address.
Blew a .24.
Mr. Murphy, did you have anything you wanted to add?
Not really, Your Honor. On the 14th, I may have to be in Clark District Court down in Vancouver. I might not be available.
21st. Okay, is this your case now, not Mr. Catton?
It is, Your Honor. I think the 21st would be appropriate. That would work. And if that works.
Okay.
This is going terribly slow.
I'd seen so many resets. Why is this motion keep getting reset? And now I'm going to be the one doing it. But
to be fair to Mr. Murphy, it's been a comedy of errors across the board on this case, and I don't think through anyone's particular fault.
It's reset for 2 weeks. Schedule council, 21st of July, 10 in the morning.
There you go, 21st of July, 10 in the morning. Let's see what Mr. White has going on here. Just 1 second. Mr. White, who does not need people to call in.
White, good morning.
Here's Mr. Burrow.
And Mr. White, we do not have a plea form.
Understood, Your Honor. We had some other things we needed to look into. There was, Mr. Burrow was eligible for a pretrial services diversion. There was an ineligibility issue. We think we may have that sorted out. He's also got a Superior Court hearing a week from today in relation to sort of those same issues. So basically, I've created a waiver of speedy trial for this case. Just asking if the court can maybe continue this to 11 o'clock next Monday, or possibly put it on Wednesday the 16th, or I guess anytime thereafter. But we certainly aren't trying to drag our feet on this thing. It's just some of the people we need to talk to are out of the office, and some of the we just need updated reports on some of the situations to hopefully try to revive this diversion situation.
Revive
the diversion on this charge in this court, is that what you're?
That was what we were looking into, Your Honor. That was what was initially offered. And then there were some compliance issues that they said potentially made him ineligible, but we think we may have those sorted out. So I'd like to weigh in with, I believe it's Mr. Alden. Let me just double check that so I'm not misspeaking. Mr. Oh, where'd it go?
It's gone.
That's Betsy. I'm sorry, Andre Clark. Trying to get with Mr. Clark to find out, but he's out until the 10th. And so basically, like I said, we're just asking for a short continuance to try to see if
hold please,
if we can get any change to this situation.
You may be seated.
Breaking news right here.
We are back here today to continue on with the trial of the state of Connecticut versus Raul, Valle. I would ask counsel to please place their appearance on the record for purposes of today's proceedings.
Good morning, Your Honor. Mark Dershall for the state of Connecticut.
Good morning, Your Honor. Tatiana Messina for the state of Connecticut. Good morning.
Good morning, Your Honor. Kevin Smith for Mr. Valle, who's at my side.
Good morning. Is everyone all set to call the jury and to continue the charge?
Yes, Your Honor. Yes, Your Honor.
Oh, wait. Full stop. Hang on. Why did it just stop? Nothing happened. They just stopped. That was this morning. That was continuing with the charge. We don't want to listen to that again. That was a false alarm. I think I bumped the wrong button. Yeah, this is live. Sorry. False alarm. Baker raid. All you bakers just saw me do a false alarm. I thought we had an answer, but I bumped something that I shouldn't have, and wanted to replay terribly boring jury instructions. So now we have to jump back up to 2 here and see what's going on up in Thurston. We could also go, hang on, we could also jump down here for a second. Hang on. What's this one? Minecraft court. We haven't been down here in ages.
The following day, when you came to work, were you made aware that a bolo had been released by the...
The audio's terrible. Never mind. Going back to 2.
Why was the pretrial services reporting ordered on the Superior Court case?
Spice alert on the last guy.
I don't believe so, Your Honor. That's showing up as being on for a treatment review on the 14th, and I didn't see anything about like a final termination from that from the Superior Court.
Well, I'm asking because I don't see anything in the docket text of our case that indicates any obligation along those lines.
He was still in the screening process for this when my understanding is the violation sort of took place, which basically just sort of shut down the screening process, Your Honor. So I'm not sure how far he got with the pretrial services on screening in for this case, which I also can't necessarily find out this morning because, again, Mr. Clark is out until the 10th.
Okay. Jump to 2. Judge Middleton's doing a small claims court. We've been handling some small claims issues with some neighbor disputes back and forth. And so in the spirit of what we've been following so far today, we're going to continue that. And
by...
Why is that not working? Jump to 8. Never mind, 8. Jump to 8.
Yeah.
There we go. I'm on the crackly signal. Hang on one second. Let's get this fixed. Judge Jeffrey Middleton. There we go. Fixed it.
Good afternoon.
Good afternoon.
Good afternoon. iPad 2, is that Scott Moore?
Yes, sir.
Scott
I'm
Moore.
going to ask you to take your hat off, if you would.
Yes, sir.
Yep. Yeah, it's a close shave.
All right, it's 3 o'clock. It's time for our small claims docket. We're on time. We had 3 matters set for today.
Super T, thank you.
That's not bad, Jim.
Ethan Rhodes versus Sean Cothern. We don't have service. Plaintiff was here and he asked for a 30-day extension to get service. Scott Widener versus Geraldine Morton, no service. So those matters are off. What is left is a claim by Chandler McBride against Scott Moore for the amount of $2,274.38 for damage that he is alleged occurred to his vehicle while it was in Mr. Moore's possession. Ooh. So let me tell you both, gentlemen, we are in the small claims division of the 3B District Court. As such, the rules are different and they're more relaxed. In small claims court, neither side is allowed to have an attorney. We're more relaxed on the rules of evidence and procedure. I'll allow things in. I'll allow some hearsay, not a lot of foundational requirements. But neither party is allowed to have an attorney in small claims court. Claim is limited to $7,500. There's no formal record being made in a small claims proceeding. And importantly, any decision here is final. There is no appeal from small claims. Once we begin, any decision is final. Mr. McBride, you understand that?
Yes, Judge.
Mr. Moore, you understand that as well? Mr. Moore, you agree?
Yes, sir. Yes, I do, Your Honor.
All right, I'm going to ask both of you to please raise your right hand. You both swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
It's got some bling on that.
I do.
What's with the fist?
Yes. All right, let me go to the actual complaint here.
Mm-hmm. I've never seen somebody be like, I solemnly swear.
The affidavit indicates that Mr. McBride took his car to Scott's Auto Detailing in Three Rivers, and his front bumper was damaged while it was in the defendant's care, custody, and control. Refund of payment for services not performed, plus the key fob was not returned or replaced. So
I have that? You kept his keys?
He's asking for those amount of damages. Now,
why'd he keep his keys?
Will you just let me know, Your Honor, when I can talk? I'm not very good at this.
You're fine. You're fine. You don't want to wait your turn. So there's something called a small claims summary, which Mr. McBride filed, where he lists his damages.
Thank you, Kelly. Fist bump.
Cost of services not performed, $150 for 2 vehicles. Key fob to be returned or replaced, $59.95. Then he got several estimates regarding the repair of his vehicle, and he's asking for $2,744.18, which is the higher of the 2 estimates.
Lower.
Well, Chuck's estimate was $1,744.
Right.
You've got Auto Body USA, $2,744.
Yes, this is the total, including services refunded, the not completed services refunded, and the key fob. So the amount is the total, including the cheaper estimate of the 2, the services not performed.
No, in your estimate, estimate 2, okay. 2,000, I didn't scroll down far enough. 2,000, you're going with a cheaper estimate. I don't want to give a plug here, but Chuck's Body Shop just did a wonderful job on my vehicle. On time, as quoted, looks great. So they do good work there. Anyway, so Mr. Moore, this is your chance to respond.
Hey, I'm ready.
Let me first of all show us pictures.
Oh yes, we get pictures.
I wish my pictures around with the $15,000 of damage to my garage that this caused. To knock my garage foundation off. It knocked my garage foundation off. So this is a handicap van. He parked the van right in front of my garage, which he did a great job parking it right in front of my garage. It started raining.
So I had to move the van into my garage about, I would say, 8 feet. Didn't even have to hit the gas pedal, just went to put it in drive and presumed to go forward. And I don't know what it was, if it has something to do with the handicap, but the brake went straight to the floor. My son was on the side of me, my 7-year-old son. I'm screaming, Jace, the brake is going to the floor. It won't let me stop. I had no idea what was going on. I've never had an incident like this. I've never drove in a handicap van before, but I only had to move it, like I said, 7 or 8 feet just into my garage. No need to hit the gas pedal. It would have just coasted in, and there was no brake whatsoever. I had no idea what I was dealing with. I just know that his chair has to be in place when you get into his van. I don't know if it takes a special chair. I don't know what. I just know that the brake went straight to the floor, Your Honor. And I only had to move it a few feet. It didn't get drove anywhere. I literally just had to move it a few feet to pull it all the way in. He had parked it right in front of it. You know, I have several thousands of dollars of damage done to my garage because it is knocked off the foundation. My pictures are all over Facebook of what it did to my garage.
Scott Moore,
you know, I have no problem paying for the detail that they were supposed to get, but you know, I was told that I could drive that van and everything was okay. And like I said, I did not drive it. I just moved it up a few feet. I didn't leave. I didn't go anywhere. You know, I know Michigan has a no insurance thing. And I don't believe that I should have to pay that money for the van being fixed because there was no brake there. I could not stop. I could physically not stop the van from moving 7 or 8 feet up. I have 21 years of doing this. I've never had an issue like this in my 21 years of detailing. Never have I had an issue of hurting anybody's vehicle. Been doing this a very long time. And it just so happens to be that this ended up being a handicapped van that this had happened on.
Well, I can't really tell what I'm looking at here in this picture. Can you both see that on the screen?
Yeah, it's about a quarter, let's say it's about a quarter size, 25 size little dent in the very bottom of the bumper, which this van already had some paint chips and stuff like that, which I get that's irrelevant. But I have roughly between $12,000 to $15,000 in damages on my garage.
All right, well, so what are we looking at here, Mr. McBride? The front or the back of this van?
It's the back, because it's got reverse.
Yep, it's the front bumper, and it's dented in on the vehicle's passenger side sensors. There. A dent that was not there prior to bringing my vehicle in. So, and I believe there's another picture that shows closer.
Yeah, what's this?
That would be the damage caused, the dent in the bumper.
That's the same.
All right, so it's two different views of the same thing?
Yes.
One's white, the
other's
black.
So that's the extent of your damage.
Yep, that's the very bottom of the bumper.
All right.
Yeah.
Now,
is terrible pictures.
What's this business with the key fob?
I have the key fob. I don't know why it wasn't in the vehicle, but I do have the key fob for them. That's not an issue. His mother had pulled in. She didn't ask if anybody was okay, if anybody was hurt. All she cared about was that little dent that you see there in the very bottom of the bumper. My son was frantic as she pulled. She slid, almost missed my driveway because she was coming in so fast.
Who is this?
That's his mother.
Would you like me to add any context to this, Judge?
Yeah, let me stop for a minute. I'm starting to sneeze again. I had a terrible bump this morning. Whatever it is, it's in the courtroom. It's not outdoors. All right, so he brings this in. He parks this is at your mother's house there on North Main Street?
Yes, Your Honor.
And you do your detailing in the garage?
Did have to do it because it was raining. It started raining. So I had to pull it in to get out of the rain.
So we can't see the garage in this picture. Where is your garage?
It's around the back of the house. He parked
so over here, or does it enter from the alley in the back?
Yep, just where you had it. See where you had it back by that fence?
It's right there.
Goes back behind there.
All right. All right. So what type of van is this?
It is a Chrysler Pacifica, model years 2018, and it is a wheelchair modified van. I have a physical disability from spinal cord injury back in 2012.
Oh, I'm having a rough time today.
Oh.
I can't tell what I'm looking
So he says your van was defective. He went to move it, and maybe it's a matter of he didn't know how to operate it. Does it have hand controls?
It has hand controls, and by law, it can still be driven with a driver's seat in there, and the gas and brake are both very much functional. The vehicle and brake was functional when I drove it there, and the brakes were still functional when I left with it. Never had any problems with my brakes not working or acting up in any manner. I also have my vehicle serviced multiple times a year, and people have been in it and used it in different capacities. Not once had an issue until now.
And like I said, sorry.
Yeah. So obviously he doesn't want to drive a van and crash his own garage and do thousands of dollars of damage. Your allegation is he was careless or negligent when he did it, and his allegation was that your van either misfunctioned or he didn't know how to operate it with hand control.
And I was told, Your Honor, that I could drive it. There was I was not told about any hand operations. Like I said, I've been driving. You can look at my driving record. I've never been in any accidents. It ended up being a handicap van that this happened on, but no other permanent damage.
Did you know it was a handicap van?
I was aware of a handicap van, and I was told that I could drive it by this gentleman here. I did not know that it took any special seating or any hand. I didn't know about any of that. I just was told I could drive it. And when I got in it to proceed to move it forward, the brake went straight to the floor. Like I said, I didn't even have to move it 10 feet, Your Honor. In thousands, I wish you could see the pictures of my garage and what it did. And he's, got a very small dent on the bottom of his bumper.
How do you do
all right, now supposedly there was something about 2 vehicles and detailing not paid. Tell me about that.
Would you like me adding context to the story, and I guess maybe even presenting more of the case from my side? So I was informed by my mother that she had met Scott and that had arranged for there to be 2 detailings done. She had prepaid him for 4 of those, so $300 in total, $150 for each vehicle. They'd been in communication. I attached screenshots of text message communication. So then from her, I was told there were some complications with scheduling for hers, and then for mine, that if the day of May 5th worked to bring my vehicle to Scott's, she had sent me the address. I went there, brought my vehicle to his garage. It was 9 a.m. I left my spare set of keys in the cup holder like I do when I get my van serviced any other place. I got out of the car. Scott was coming out of his house. I said I'm on my way to a meeting. I was heading over to the Chamber of Commerce, which is right down the road from there. I said, call if there's any issues, but the keys are in it. and everything was shut up. Like the ramp was in, everything was good to go. I thought everything would be in good order. And if there's any complications, he had been in communication with my mother. He can call and let me know. And then it was a few hours later, I received a message from my mom saying that he didn't want to finish doing services. Something was strange with the van, was acting up. And I went back there. I saw that the van was now in the garage. He had, said there's something wrong, was acting pretty frantic himself. And then I got into the garage, saw that the van was closed. I could see that there was some damage to his garage. I mean, it would be the paneling that was at the end of the garage was, it was damaged. And then that led me to think, okay, well, there's likely something, wrong with my vehicle after this. I backed my vehicle out to take a look at it. At the time, Scott was, I'd say just during that time, I realized I wasn't really dealing with a reasonable person and wasn't going to get anywhere in conversation with Scott as to, what exactly happened and any responsibility accepted from this. So then I saw the damages, took pictures, called 911 to report an accident. I was informed that they would come out only for a vehicle-on-vehicle collision, but that had to be taken up in this small claims court and worked out through insurance. And then I got the information provided, and then it went this route, and then we ended up here. As far as my mother came by after the incident occurred because I let her know that there was.
What's your mother's name?
Monica McBride.
Okay. Oh, go ahead.
Oh, yeah. And so that was all. I had realized that there was going to be no progress made by me staying there. So I had left, and it was a rather uncomfortable spot to be in, tucked away towards his garage. And so I got myself and my vehicle out, and that was that was my main goal there. Brakes, everything in the vehicle was functioning fine. What I suspect happened is the floor of the van was slippery from some cleaning solution, and my suspicion is clean the floor or put some solution down on the floor, went to move the van, and it was slippery for my wheels to be on. I could see how he could slip and then lose control of the vehicle while he's in there, and then that causing it to crash. I don't know. I was not there, but that's my suspicion, and it logically checks out in my mind.
Hey, actually, just a minute. Had he actually done any detailing of the vehicle?
No, sir. I never started the detail. I never even started working on it. Never even sprayed a thing on it, Your Honor. That's what
I would have to say that's.
So he was paid $150 to do 2 details, and he didn't do either job.
No, he was scheduled. Right. He brought the vehicle to get detailed. The van wasn't functioning right. It was there to get detailed. It would have gotten detailed if it would have been.
Yeah, I understand. So the key fob that he didn't return is $59.
I have that.
And then how much? What's the $169 for? I forgot.
So in replacement of the bumper with my modified van, there's a sensor in the front that needs recalibrated after replacement of the bumper, and after the collision, that sensor is off the. It's not in line, so it's not functioning properly. So the sensor that's in the front of the bumper, along with along with the bumper itself, that's damaged. So that was included in the quote because that needs done at the dealership. So it's two separate charges. So it's the replacement of the bumper, and then the work done by the body shop for that, and then also the recalibration of the front camera from the dealership.
All right. Mr. Moore, you wanted to say something else?
Yeah, I have no problem. He can have the key fob, and we can work out a thing where he can get the detail money back. But other than that, I'm just not. This is, like I said, I've got $12,000 to $15,000 in damage in my garage. The whole concrete is busted off, and they've got a tiny little dent on the bottom of a bumper of the van that's already got chip paint, and it's not new by any means. Like I said, I'll be willing to reimburse them for the detailing. I have the key fob. That's no, but the money for fixing the van is just insane. I just, there was no, nobody said a word. Are you guys okay? Look what happened to your garage. All that mattered was that little tiny dent in the bottom of the van. That's all that anybody cared about. My son's safety, none of that mattered. And that's really, Your Honor, that's really all I have to say.
Well, Judge Middleton.
I could see you were okay. You were more than willing to come talk to me. I could see everyone was okay. And that wasn't a concern at the time.
Nothing was a concern at the time, just that the van would get fixed, but nothing about my garage, which is like caved in. I've got great pictures.
We don't have them.
So your little ding versus my $12,000 to $15,000 in damage of my garage. Believe me, I didn't mean if I would have thought this would ever happen. Believe me, this would have been played out totally different.
Yes. This is a civil lawsuit, even though it's in small claims court, and the plaintiff has the burden of proving the matter by a preponderance.
Preponderance is a lower threshold,
which is just barely more than half. Criminal case, the burden of proof is higher. Mr. McBride says that he mishandled my vehicle and put a dent in it. Mr. Moore says I wasn't properly trained in the operation of his vehicle and the brakes didn't work. And he obviously, if he was going to move 10 feet, would not voluntarily crash into the back end of his garage. So obviously either the vehicle malfunctioned or he didn't operate it correctly because he didn't know how to operate a handicapped vehicle.
Wasn't operated.
I didn't ask you anything at this point.
I'm sorry.
I'm just ruminating.
Okay.
The vehicle's 7 years old. It's got 117,000 miles or more on it, and it's got a dent in it. I can testify that when you get a dent, with the video monitoring equipment, rear view cameras and those things, it can make a dent very expensive. I can attest to that. If this was a mini tort action, there would be a limit on the amount of damages, but it isn't that kind of case. Then the defendant never got his money back for the actual detailing. Mr. McBride, would you rather have the key fob back or the money for the key fob?
If the key fob was returned, that would be sufficient. I'm not looking to do anything punitive. I'm just looking to get set back straight to where my vehicle was before I brought it to Mr. Moore's business.
All right, I'm going to grant the recalibration, but I'm not going to pay for this dent. It's 50-50, your version versus his version. It's not clear who's more at fault, but I will allow $300 for the detailing that you paid for that never got, and I will allow the recalibration.
And if he wants to come over, Your Honor, and pick up the key fob, I will leave it in my mailbox if he doesn't want to.
Right, that's what we're going to discuss.
Okay.
Judge, can I?
60, we'll just call it 170.
Chandler's not happy.
So it's $470 for the plaintiff. 470, 8625 in court costs. Is $556.25.
And I'll have to make that monthly installment.
I put shall return the key fob. It's easier to get their key fob returned. I don't want you to just leave that in there indefinitely. How about if we pick a day, Mr. McBride, when do you want to pick the fob up? Do you have a reason to go to the chamber?
Yeah, I could pick it up. Should be able to pick that up Thursday this week.
That's no problem. Let me know what time and I will make sure I'm there.
All right.
Scott's being quite agreeable. Probably because he just got out of paying for a big repair.
All right. I don't know. Like I said, it was 50-50. I did allow recalibration. The dent ain't much on a 7-year-old van, but it isn't the way it was when he got it. The van, obviously, I don't think he obviously intentionally didn't do this, but it ended up causing him a bunch of damage, which now he's stuck with. So that's my ruling. I'll prepare a proper order and send it out.
Can I?
Now, let me, Mr. Moore, you have 21 days to pay that. If you don't pay within 30 days. So I would suggest once you get this judgment, you just write a check to Mr. McBride.
I'm not going to be able to pay. It says I could make like $50 installments or something.
No, I want you to pay him. He paid you money, $300 for work that you didn't do. So I don't know, you spent it on next week's bill. I want you to pay this within 30 days.
30 days.
All right. Okay. All right. You're both good to go. Thank you. I'll send you a copy of the order in the mail.
There you go. Judge Middleton dividing the baby, so to speak. All right, we're past the 5-hour mark on deliberations.
All right. I'm not sure what the right answer to that is, but that was the answer. All right, that finishes our day. I got some more PPOs to do.
All right, we'll see you, Judge. Have a good one. Nice to hang out with Judge Middleton now and then. Let's see, we have... I think he's all that was going. We do have Judge Ricky in Kansas. Haven't been there in a while.
Next case that you're ready to present on, Mr. Watts, I do have a Mr. Snyder. I think he might be yours.
He is, Your Honor, and I can take that one up right now.
Okay. Mr. Snyder, if you go ahead and unmute yourself in case we need to address you personally. Daniel Snyder?
Yes.
This is State of Kansas versus Daniel O. Snyder, case number 2024 CR 11. James Watts appearing as defense counsel, defendant appearing separately by Zoom, Amber Norris for the State of Kansas. What announcement is made here, Mr. Watts?
Thank you, Your Honor. My client would ask this case be set for a preliminary hearing as well.
Okay.
Mr. Watts' chair has seen better days. Taken a few naps in that one, I think.
Note that Mr. Snyder is under an Owens bond of $5,000 professional surety. He's appeared on time today.
think we covered that one, Josh. Which one was it? We covered a couple up there today.
August 6th at 10 o'clock a.m., Mr. Watts. August 6th.
Yes, sir. I could do that. At 10 a.m.?
Yes.
Yes.
All right. The Snyder preliminary hearing, it's an evidentiary hearing, contemplated currently to be done by Zoom, will be set for Wednesday, August 6th, 10 o'clock a.m. Mr. Snyder?
Yes, Your Honor.
I see you live in Wichita. I'm going to need you to travel over to El Dorado on that date.
Okay.
You can appear in either your attorney's law office, or you can be at the Judicial Center Zoom location and participate from essentially a courthouse location. But you need to come over to El Dorado for the next Zoom hearing, because it will be an extended evidentiary hearing, and I want to cut down on the number of Zoom hookups that we have on that meeting. Plus, I want your attorney to have immediate access to you and you to have access to him.
Okay.
So,
which is why my preference would be here in my office, Your Honor.
Okay. Do you hear that, Mr. Snyder?
Yes.
Just go to James Watt's office to participate for your prelim.
Three T's.
Wednesday, August 6th at 10 o'clock.
WATTTS.
Yes.
I'll maintain you under your current bond pending further proceedings in your case.
And
Okay, thank you, Your Honor.
All right, Mr. Watts, anything further?
Just one thing, Your Honor, for the record, I've gone through the affidavit and the documents in this case. There does not appear to be any video in this case, and that isn't always necessarily the case, but this is a case with a traffic stop where video, I think, would be entirely relevant. I don't know if there's a video out there that just hasn't been requested, hadn't arrived yet, but I would ask the state to inquire and see if there's video of this matter.
It would seem to be a reasonable request, Ms. Norris. Do you agree?
Yes, Your Honor, I'll make a note.
Okay. And thank you for following up on that. And if there is such a video, if you'll get a copy of that over to Mr. Watts as soon as practicable, but certainly so that he has an opportunity to look at it prior to the preliminary hearing.
Thank you.
I appreciate your office's efforts in that regard, Ms. Norris.
Yes, Your Honor.
Mr. Snyder, I can let you go at this time as your proceeding today is concluded.
Okay, thank you.
Mr. Snyder's happy about that. Mr. Watts will let him sit in the nice chair next time.
All right. You have others in custody that we need to address here, Mr. Watts?
Judge, I don't believe I have anyone else in custody. I have a Michael Smith that I believe we can take up.
Okay. We'll take up the Smith case then.
Is that a bong? What is that in the spec? Oh, no, that's a magnifying a reader. I thought
Michael
it was like
Smith?
a massive pipe.
Yes, Your Honor.
We'll call your case. It is State of Kansas versus Michael Brandon Smith. Case number 2025 CR
Still might be a bomb.
222. Mr. Smith appears separately from his lawyer, James Watts, by Zoom. Amber Norris appearing for the State of Kansas. What announcement is made here, Mr. Watts?
Your Honor, it's my understanding my client would waive his preliminary hearing this afternoon in this matter.
All right. Smith, I have some questions I need to ask you about that. Mr. Smith, do you understand that a preliminary hearing is a proceeding to determine if there's probable cause that a felony crime has been committed and that you committed it?
Yes, Your Honor.
You understand that if you waive preliminary hearing at this time, the court will bind you over for trial without any further determination of probable cause?
Yes, Your Honor.
You understand that once you waive your right to a preliminary hearing, you cannot get that right back, though you may proceed to trial later.
Yes.
Have you had an opportunity to consult with your lawyer before making a decision to waive?
Yes.
So do you now formally, freely, and voluntarily waive your right to a preliminary hearing in your case?
Yes, Your Honor.
The State of Kansas waive its right to a preliminary hearing, Ms. Norris?
Yes, Your Honor.
Court finds that both parties have knowingly waived their rights to a preliminary hearing. Defendant Smith is bound over for trial on any and all felony charges of his information. I'm inclined to proceed to formal arraignment at this time. Mr. Watts, does your client desire the charging document to be read to him?
Your Honor, we've discussed the charges in this matter would waive formal reading of same and are a not guilty plea at this time, as the case be set for a pretrial and jury trial settings.
All right. Court will accept the plea of not guilty to all charges, and the court will establish pretrial conference and jury trial settings.
Okay, apparently we left Thurston too soon. We left too soon. We need to go back. I don't know if this is Mr. Farag or not. Thurston County District Court 1. I've got to see who this is here. Oops. It's going to be right up here. Wait. No, is it gone? Please don't be gone. No. Come on. Still there. Okay, here we go. Oh, we got it. Okay, we're going to go right here. Ready?
He used to work at Olympic Outfitters.
Oh, okay.
He now just runs that out of his own house.
This gentleman here in the back on the pew.
The court has nothing else for me. May I be excused?
Of course.
Thank you, Your Honor.
He's not Mr. Frog, but he might be. I don't know.
And Mr. Black, good morning.
Mr. Black. Not Mr. Frog.
And your criminal charge was dismissed on Friday, is that right? Thursday?
I don't know. Okay, well, thank you. How come I wasn't notified?
Well, that's not what you're here for today. You're here for the traffic infraction. That's what it's for. I don't know.
I thought this was a motion hearing.
It was going to be, but the state made a motion to dismiss your charge.
Okay. So now it's going to be contested?
Yeah, I'm waiting for your file to open up here. Sometimes our technology lags, so I'm waiting for it to give me access to your file.
Mr. Black's mad.
I didn't come prepared to contest the...
Oh, come on. Don't do that. Don't do that. YouTube, why are you doing YouTube-y things? I can still see it's there.
Actions.
Oh, it's back.
Well, that'll be easy because you can tell me whether you have insurance or not. But hold on a second.
Sure.
Let me just explain. Failure to transfer title, the trip permit, and the driving suspended charges, which are all criminal charges. And those are the ones that you'd filed all the pleadings on, which I've read all your pleadings.
Okay.
All the pleadings.
You have any comments on it? Just curious.
I'll give you my comments here in a moment.
And I believe the police report states that I did produce my insurance, but it took me a while to find it.
Do you happen to have a copy of it with you?
Yeah.
Yes, you.
Take your time. Bring your paperwork up.
Should I approach?
Yeah, please.
To the middle of the big paragraph.
Amber did the digging and found the Facebook exchange back and forth from the defendant's or from the plaintiff's mom talking about that car detailing issue. Thank you, Amber, for that. Oh, Scott Moore just posted on Facebook. Today's Zoom court went exactly how I expected it to go. Thank you to Jeff Middleton for the very fair ruling. Definitely a win in my book.
And do you have a copy of whatever you showed the officer by way of the insurance proof?
Yes. Oh, it's on my phone.
Yeah, that's fine. Do you have your phone with you?
Yeah, but I let somebody, one of my employees, take care of that. And he, whenever I need my insurance, I ask him where it is. But it'll take me a while to find it if you need me to.
Well, see if you can find it while I'm reading this.
I have an employee to look through my phone for my insurance. This guy's got to be related to Mr. Frog. I was just reading a Facebook post from the person who we just watched in this court a little bit ago, or the other court, Thurston County. No, that was Judge Middleton. The one we just saw in Judge Middleton. The car detailer guy, Scott Moore.
Okay. Bringing it up.
Okay, great. So this is showing insurance for somebody, not you, for a car. I don't think it's the car it's identified here. Okay, it could be the vehicle. Who's Thomas Harris?
He's the employee that takes care of that stuff. He registers the vehicles, gets insurance for them.
And employee of yours?
Yeah.
And what type of business?
Biodiesel.
Biodiesel? He makes his own
gas station in Grand Mountain.
He makes fuel out of what? Fry oil?
All right, and then the other thing to note here is that the insurance is purchased the day after the stop.
No.
Yeah, look at 411. Stop was on
No.
14.
Well, I can call. I'm sure it wasn't because when I called him, he produced this instantly. So I can call him and get it.
Bought insurance the day after and tried to pass it off on the judge.
And you saw that, right? You saw that it said effective 4/11.
Let me take another look.
Are you making just a speaker call right here? Busted. How much? Hey, Mr. George, how much you pay the new guy? Anticipate that around 4:30 or so they might call it quits here on deliberation. Who's he calling?
Yeah. Thomas, you're on speakerphone. I'm in court right now. The criminal charges were dismissed, but the no insurance charge. Remember when I called you when the police stopped me and you sent me a copy of the insurance card? Well, the insurance card looks like it was purchased the day after the stop.
Oh, it maybe it's been the wrong one. Tell them that tell them we have a different insurance card. We've got so many vehicles here. It's crazy. There's no way to get an insurance card that quickly when I'm working like that. The only thing I could do was send you some proof of insurance that I had in my phone.
Okay. Yeah. All right.
So what did they say?
Well, you're on speakerphone now. I'm in court, and
that's the worst.
I mean, you got to realize we're working around.
How could this possibly be purchased the next day? You didn't purchase insurance the next day, did you?
No. What they may have done is what they do is they renew the insurance every 6 months or so. And what happens is it automatically prints out ahead of time. And so what may have happened is they give us the card in advance, and then I get it online, and then I just put them in my phone. But I got so many cards in there that it's hard to find them.
Okay. I think that explains it.
Okay. Yeah.
Okay. Well,
if you need me, I can look up and see where.
Well, let me ask the judge. Your Honor. Okay, that's all, Thomas. Thank you.
All right. Thank you. Bye-bye.
He wasn't under oath. Just for the record, don't call someone on speakerphone in court.
I'll find that the card you displayed is just the automatic renewal card that comes in. Coincidentally, it renewed the day after you got stopped, so I'll go ahead and buy that. Dismiss the ticket.
Gets it dismissed.
And that to you.
Everything's dismissed.
Me, about your criminal charges, they were dismissed without prejudice. Now, without prejudice means they can be refiled. So it's up to the prosecutor to decide whether they're going to refile them.
I prepared something for the court.
Without the prosecutor here, I can't make any decisions. I'll just share some general thoughts with you because I see you've got a subsequent driving suspended ticket out of, looks like Tumwater. So
Tumwater. Troy,
you have a court date, I believe, in August on that. Let me check. So my guess is, since you have a new charge right away, that they may not be willing to dismiss the new charge, and they may resurface the old charge because, as I said, it was dismissed without prejudice, which means it can't be refiled. So right now you're scheduled for court on the Tumwater driving suspended charge on the 5th of August at 1:30 in the afternoon. So that's a Tuesday at 1:30. We're doing court. So without ruling on anything that might be filed on the new case, I'll just share some thoughts with you, which are that the view that you set forth in your pleadings is, we see that occasionally, very similar language. I don't know, sometimes the briefs we get in this line are all read the exact same. Yours is not the exact same, but a lot of language, exact same.
What's that?
There is no case in the country that says a state cannot regulate the driving, both commercial and private, on any public thoroughfare. So, I read your arguments as to why you believe the freedom of travel means you can drive your private vehicle on public roads, which are paid for by the registration of the vehicle, by the way, in part. That you believe you can drive because you have the constitutional right to travel. That it's never been interpreted that way. So the constitutional right to travel does not apply to overcome the requirements that states have imposed
to require you to register your vehicle on an annual basis. That is it. I pay my registration fees every year because I have to, in order, if I want to put my car on the road. And I know if I put my car on the road with expired tabs, I'm going to get stopped and I'll have to pay the fine and I'll have to go get my car tabbed. I just know that's the way it works. And that's how the system is set up. So there's no legal argument there. You know, you made it in a sort of a big way, but I think it's a misinterpretation of what you believe the right to travel is. It does not give you the right to travel in any state not adhering to that state's laws. And every state has a registration law like the state of Washington. So you've asked for my general.
Have you noticed that in courts, a car is referred to as a motor vehicle? A friend riding with you in the car is referred to as a passenger. You're engaged in traffic, and what the problem is, when a person registers his private property automobile with the state, he's declaring it a commercial vehicle.
No, that's your interpretation, and I'll just tell you that's not the interpretation shared by the courts. We don't see it that way at all. So the law makes very clear that all of us who have vehicles that we put on our roads, they have to be registered. Doesn't matter whether we have passengers, no passengers, if we drive them ourselves or not, if we're engaged solely in personal business or moving from point A to point B, none of that exempts us from the requirement to appropriately register our vehicles, which is used as a means of supporting the construction of the roads that we drive on.
Yeah, you know what? You said you've seen a few of these. What compels people to do this is the state abusing its power to license drivers, as well as doctors and other professionals. If you don't behave the way the state wants you to in your private life, in your family life, the state, through the family court, can have your license suspended. And that's just strong evidence that the system is not set up to make the road safe, but to control people. And people don't like that.
Yeah, no, I understand the philosophy behind that. We don't do anything here with suspending licenses or not. We just interpret whether the person has a license or doesn't have a license. That's the only rule of the court there. Now, I will say what you're referring to is the ability of the Department of Licensing to suspend licenses for the failure to pay child support as
it's
ordered.
Government support.
What's that?
It's not child support, it's government support.
Okay, well, it's called child support. And that's what it's, you know, if you look on your driving record, you have one of those things there that says, it says failure to pay child support. I understand there's a different way of looking at it. But it is not directly related to driving. I get that, but the legislature made that. They thought, how can we leverage people to pay what a court has determined they should pay for the support of their children. And they decided that one good way to do it was to leverage the ability to drive. So that's what the legislature decided to do. They created the law. Nobody has determined that law is unconstitutional.
A lot of people have, but they haven't taken it.
Right.
So in family court, the court rules don't apply. You know that. And due process is streamlined. So your driver's license can be suspended through a court procedure where it's a free-for-all. I've seen it.
Okay. Yeah. So I like I said, I understand the philosophy you're indicating. I'll just, when the case comes to me on a driving suspended charge, I look to see if your license is active or if you don't have the privilege to drive on the state. And you view it as a right. The law views it as a privilege, and the privilege is enacted if you are properly registered and insured.
Well, it's a privilege to operate a motor vehicle on the highways, but the courts have ruled, and it's in my brief, it's a right to travel by your automobile, by your private property automobile.
No, there's no court. Like I said, you can look all you want, but there is nobody has ever found a case that says a court upheld the ability of somebody to drive in whatever state on public roads.
Well, driving is a commercial term too.
Okay. To operate a motor vehicle in any regard.
That's even more a commercial term. Look at
to operate your car. No, there's no case that says you can operate
means
your car.
Using a business machine on a public utility.
No, that doesn't. Operate means I'm operating my computer. I'm operating.
That's a colloquial.
My pencil.
That's a colloquial term.
Well, then you're pushing your example into sort
Look
of.
at Black's 5th edition. You'll see that operate means using a business machine for gain.
No. Okay. I disagree with that, and I don't think you'll find any case that supports that.
Okay, so I appreciate your input.
All right.
Thank you.
But we'll see you on the 5th of August.
Okay.
All right. Bye-bye.
He's like, oh my goodness. I'm going to call in sick that day. 5th of August. 5th of August. Going to be like, something came up. Something came up. All right. It's almost 4:30. I think we're going to hang tight till 4:30, and then we're going to call it for the day. I don't think we're getting a verdict today. So, man. Thurston, Washington delivering today in style. Thank you, Thurston, for all that greatness. Let's see. We've also got, Court 3 was done. 2. I don't think we've followed anything in 2 today. 4. What was in 4? Yeah, it's been a while on 4. Okay. Good. Hey, it's been a fun day looking at. Let's go back here. There we go. 5 hours 39 minutes. Fun day looking at the verdict clock as it counts. Can you explain the official meaning of a kangaroo court? It's generally the meaning I understand of kangaroo court. I don't know the source of it. First of all, I don't know where its source is from. My understanding of a kangaroo court is one that is false. It's a procedure only, but they have one purpose, and it's a conviction, not the truth. If they let them deliberate as long as they want today. Then I'll expect a couple of you guys to notify me if we get a late verdict coming in, and we'll do a live with that. Does that work? They may go longer. It's possible. Man, crazy. I saw the verdict, or the death toll in Texas is up to 95, which is just terrible. Wonder how the fan is doing, if it's thinking of us. I saw what you sent, Ember. Couple things. Lincoln Riley's killer, Jose Ibarra, gets major win as judge allows him to undergo mental evaluation for a shot at a trial redo. It's a long shot. He would have to get the mental evaluation, have to come back a certain way. But apparently Scott Moore has taken to Facebook already, that gentleman who owns the detailing place where he may have caused a dent in the handicapped van bumper. He's got some postings in all caps. I mean, like, all caps. A whole page full of caps. Wild. Good stuff. Carborough, North Carolina. Is that... Oh, my goodness. We've got some flooding in a lot of different places here. I have not been following North Carolina, my home state, to see what's up there. The flooding they've got there was pretty bad, I heard. 10 inches of rain. 10 inches of rain. Wettest day on record. It's today. Well, nothing is happening here. We're watching as much as we can just to see what's up, but nothing's happening out of court. So we're going to probably wrap it up. Wrap it up in about 4 minutes. We'll stall for just a minute. Just a reminder about what happens this week. We're not going to pick up another big case. I know there are a couple big cases happening right now. We're not going to pick up another one until after I get back from Virginia. I'm going to Virginia at the end of this week. Thursday, Friday, Saturday, and then we'll pick up a case. We might be doing catch up to an existing case. We might look for new ones that's coming up, but that's our plan. So we're going to plan on court hopping and watching for a verdict in this trial. Possibly would be a half day on Wednesday because I need to get some packing and loading the vehicle done because I've got to leave out early on Thursday morning to head to Virginia. It's about a 6-hour drive. So that's my plan. That's my plan. And honestly, like every free brain cell I have is focused on this project for this weekend. Don't forget your pillow. There's so much I need to not forget. Let's see. As soon as we take a break, in 10 minutes, there'll be a verdict. North Carolina is beautiful. It's an amazing, amazing state. I love it. Bring the fan cooler. I will bring the fan. I'll bring the power. I need to charge, like, I've got maybe 15 different items that have to be charged before I go. What's going in Virginia? Me filming a reenactment, a period reenactment, a youth church camp thing, and I'm making the video for it. I think we've got 4 cameramen now. And so we'll be up on about 2,500 acres of private property, running around in the hills, filming, dressed up as if we lived in the 1800s. It's going to be great, except for me. I'm going to have an e-bike and all the electronics. So, all right, make sure to remember all your buttons, Shannon. I definitely will. I will bring the sleeping bag this time. I won't forget it. Thank you. We chalk road trips, taking my 5-year-old from Florida to Illinois this month. No idea what places we'll see along the way. There are plenty of beautiful places to see along the way. Many great states there. I don't recommend stopping in Georgia. No hard feelings, but I've always driven straight through Georgia and never regretted it. So you need a to-do and a packing list? I do, but I have to create the to-do and packing list myself because my purpose up there is different than everyone else's. So it's just more work for me. Must see you in leather pants. I want to see Laurie. I'm not sure if that's going to happen. I'm pretty sure I've got my clothing picked out, and it's not going to be leather this time. Although I did get a hat. I might show you my my straw. I won't say it's a cowboy hat, but it's a straw hat that's sort of cowboy hat looking. Bravo chick, sorry. Last time I drove through Georgia, it was right after we watched, I think, a trial out of Georgia. Was it the road rage trial? Was it Hannah? I think it was Hannah. Yeah, it's a pioneer reenactment. Yep. Is the whole fam going or just me? Just me. Well, I actually just me and a couple of my sons. Don't have adult son here, Mrs. R.A. here. Anything since the note earlier? Nothing. We've just been sitting waiting for 4:30, which is right now. Nothing's happening. Gam, we're up there sort of same latitude as about Washington, D.C. area. So we're up on the north part. But it's all private property we've rented. What did the note say? The note said, we are, if you didn't see, the note, we had a note that came in probably a couple hours ago. And it said, we as the jury, I think 3 hours ago, we are hopelessly deadlocked, 11-1 on the first charge of murder. And the judge gave them a go back and try harder. You've only done it for 2 hours, basically, complaint and or directive, and they have been back there since then. So, no verdict, Anita. Probably not till tomorrow. Right now. Will it be live streamed? The verdict, yes. The thing I'm doing, no. It's not even going to be public. Do you think will it be soon? No, I think it'll be tomorrow that they come back with another note and say we're deadlocked. Uh, 4 a.m. We had the jury's deadlocked. They've gone back to deliberate. They're still back there. They may be considering the other charges and might be able to come to agreements on those. But as to the first charge of murder, we anticipate that nothing's changed. I'm going to be more angry if the holdout caves now. Every hour that passes would suggest bullied into it if they change. Why can't I tag when commenting? Are you on a phone? Will you bring the neck fan or not a good choice? I just don't have enough space for comfort items. It's all going to be gear. And I mean, I'm taking the e-bike and batteries and chargers and radios and drone. I've got a drone going up there. I think 1, 2, 3, 4, maybe 5 cameras, 2 gimbal stabilizers, tripods, Starlink. We're taking a lot of stuff. Computers. It's going to be a lot. They have till Wednesday at 11. Yep, that's when we call it quit. So they've got to come back with a verdict by then. Two hours indicates to me that they did not even take the time to review all the evidence and the video, etc. Someone might have made a decision during the trial. Yeah, I think so. That's a quick verdict. I almost went metal detecting on a very historic property up in Virginia. And the night before, the landowner was talking to a friend and said, yeah, we've got these guys coming up to do some searching for, some history here. And the friend was like an archaeologist. And they're like, no, it's the worst thing in the world. They'll ruin everything. So they called it off, and now everything is still rotting in the ground up there. But it was right next to a battlefield, like private property right next to a battlefield, Civil War. Does the defendant and the lawyers just have to sit there and wait in court? We think they're probably nearby and being notified, but we don't know exactly when. Okay. For some reason, it keeps resetting. Still nothing. Still nothing. All right. We've had some fun. We've done a little court hopping, which we haven't done in a fair while. So that was all good. The court would come back right as we end the stream. That's what they do. Thanks, y'all, checking your points balance. I think a few of you have accrued quite a bit. I saw a couple of you who have broken. See this right here? It says that you are greater than 50. Right? That's the greater than sign. If it were going the other way, it would look like an L. That's the less than sign. A couple of you, like Virginia Little, is ranked 23. So less than 50, which is awesome. So thank you for your support. No, we don't have a court watcher up there in this one, Barb. It would be nice if we did, but we do not. Grew up playing on the battlefields, riding dirt bikes on over the berms. Where are y'all getting the 11-1? They said that? They did in the note, Dana. They said we're hopelessly deadlocked 11-1. Honey's mom, the points is just something we've turned on. We might use later. We might turn it off, but it's a way that people who are not members can track their participation, and it ranks everybody as to basically how long you've been here, how much time you've spent watching the channel. Need more points, Judgy. Red Pen, I saw you talk this morning, then you sort of took some break and did some adult things, and you're back again, which is wonderful. Yeah, usually they're not supposed to give a breakdown. Sometimes in the instructions they're saying, if you do have to give us a note, don't tell us your process, where you're at in deliberations. I did adulty things for sure. I'll check on. All right. Barely been here today and nobody noticed. Oh, we noticed. We missed you terribly. Creeping Grizzly here, all up in your channel. Recovery Addict, you rock, and this community is amazing. Diana Banana, thank you. Gazella is amazing as well. Or does she like Gizella or Gazella? I need to know how she likes her name said, and I'm pretty much, I butcher everyone's name, so it doesn't mean I'll say it right. But Grizzly True Crime is one of the great ones when it comes to LawTube and LawTube adjacency. And watched her on Courtroom Confidential with Josh last week, and she was absolutely amazing, especially considering she was, 2-3 o'clock in the morning, her time. Just incredible. Just incredible. How long can they deliberate? Probably till about now, but the idea that the camera is still rolling means they're still deliberating. So we could sit here for a bit and see if we get like a little bit of closure at the end of the day, maybe 5 o'clock, but not sure. Is everyone ranked at 50? No, your rank is greater than 50. That's the greater than sign. So it only ranks the top 50, and then everyone else is more than 50. Gizella. I want to say J. We call her Mrs. G when it gets confusing. Gizella. I do a terrible job with names, so even though I know it now, I will forget later. But yeah, she is wonderful. So lower is better. Lower in the ranking is better. Higher points is better. How do you see points? You just type exclamation point points like that, and it should respond. What time did they come out with the deadlock? I've been working all day. About 3 hours ago. A little over 3 hours ago, actually. 3.5 maybe. Is there a verdict? No. Nothing new, Mrs. Angels. By the way, I checked out your channel on YouTube. It's awesome. Got 30 videos, Mrs. Angels. You've posted 30 videos to YouTube. That's cool. That's like 30 more than most people, just for the record. Must be one serious holdout for them to come back with that so soon. How many different charges are there? There are 4, but there are lesser includeds to each charge, so the instructions are really complicated. And they took 2 days to go through instructions. Linda Lou, good to have you here. Welcome. Did I hear you're traveling in? Yes, this week I'm traveling, and I will not be doing a live show. First of all, no podcast. You tell Thomas that. No podcast on Thursday because I'll be up in the mountains. Technically, I'll have a camera and Starlink, but I'll be working on this other project. So no podcast on Thursday, and then nothing on Friday. So no live stream Thursday, no live stream Friday, and we'll be back on Monday. Deanie Mo's Diver gifted 5 memberships. Thank you, Deanie. That is super, super generous. Which way do you think the jury is leaning, guilty or not guilty? Nikki, I personally think they're leaning guilty. I think that we had 11 guilties and 1 not guilty. Let's see. Were you well after all the jelly beans? No, Camilla. The jelly beans that we had on Thursday night were terrible. They were not good. SJ, I have no points. I'm sorry. Hopefully that they'll accrue. Sometimes they take some time to show up, but hopefully the counter will go up for you. Kelly H., thank you very much for the super chat and your generosity on the channel. Thank you. Celestial Force, I was trying to figure this out on Baker's channel. I was like, why are they monitoring my call name in here? What? Monitoring my call name. The points? Is that what you're talking about? 200 videos? That is awesome, 80s. Good job. I will tell you this. I ate every single jelly bean, and I swallowed it, and I kept it down. I kept all of them down. But my tummy was not happy after that one. Sandy Graham, member for 9 months, been lurking a while. Can't believe it's been 9 whole months. Sandy, thank you very much. Has been 9. Fire Girl, handmade by Wendy. Channel fully monetized. So proud of myself. Never thought to reach that. That is so cool. That is so, so cool. Kimar, how long to get more points? Kim, you're getting more points right now. Just being here is one way. Let's see. Let's see what Kim's at. There, 755, right there. Can I replay the judge's charge to the jury? Yes, I can. No, I'm not going to tonight just because I have of the systems I've got working. If you look here, I'm using my replay machine to bring us court right now because I was using the other 2 machines for other things. And stop the recording here. I don't need that. Maybe we'll go over it first thing tomorrow if that works. I'll just have to. The replay machine is what Mrs. RA is going to be editing the video on Thursday and Friday that we have to show on Saturday. And so I've got it configured right now. It's super cool actually. If I can nerd out for just a minute, I've got my phone linked up because I'm going to be shooting some stuff on my phone. Literally, I use an app on the phone called Blackmagic Camera, and as I film on that, as soon as I'm done filming, it just shows up on the computer here, anywhere in the world. As long as I've got an internet connection, it just puts it to the cloud and it brings it back down. Oh, looky, what is up here? What is up
Just
here?
about 4:45. Nearing the end of the day, so I'm going to go ahead and release the jurors for the evening. So I'll ask the jury to be brought in.
It's a good thing we waited. I'm going to stop the timer at 6 hours of deliberation. This is for points, Virginia. Thank you. And Bug Dugger, thanks for giving the membership.
Counsel, please stipulate to which one of our jurors.
State will stipulate, Your Honor. Defense stipulates, Your Honor.
Ladies and gentlemen, jury, it is a little bit after 5:45. At this point in time, I am going to send you home for the evening. I'm going to bring you back tomorrow morning for continued deliberations. All of the rules of juror conduct are in place. They're all important. However, before you go home for the evening, I want to remind you of a few things. You must continue to avoid all communications to and from anyone regarding this case, except communications with your fellow jurors only when all 12 of you are present here in our jury deliberations room. Avoid any media and social media platforms while you are not here, and obviously while you are here, where you may find information about this case. Do not visit any locations mentioned, look up any statutes mentioned, or conduct any experiment or research, either individually or as a group. We are going to reconvene tomorrow morning. I will bring you in first thing in the morning and provide you with additional instruction, and then we'll go on from there. Okay, so we'll see you back tomorrow for continued deliberations. Please take your role as jurors, which I know that you are doing. Please take that role responsibly. And there is a lot of media coverage relative to this particular case. Have a good evening. We'll see you back tomorrow. Thank you. Court stands adjourned.
There we go. So the court is adjourned. We are done. Judge is off the bench. Jury's going home. 6 hours today was not enough to reach a conclusion. 11 people were happy with the result, and one was not, at least not on the same page, just happy with maybe a different result. So they have now deliberated 3 times as long as they did they've deliberated 4 more hours since they were hung, or declared themselves hung, and nothing yet. So we'll be back at this again tomorrow to continue the verdict watch, or the verdict watch for Raul Valle, and maybe they can get it done. There's one holdout. Maybe that one holdout is convincing each one of the 11, just like in the movie 12 Angry Men. It could happen. It could happen. I see the points going up. You guys are doing it. I see a compromise verdict coming in. This case is going to end in a mistrial. If it's a mistrial with an 11-1, it's going to be retried for sure. That's for sure. All right, tonight when you go home, please hug the people you love, smile at someone, make their day just a little bit better. Please stay safe. We'll go live again tomorrow morning about 9:30, same time, 9:30, 9:45. As we pick up when the jury comes back in and begins deliberation. Maybe we get a note early in the morning. Fingers crossed. We're going to do a little court hopping during the day. Might be able to find something spicy to watch as well. Light blue suit tomorrow. I don't think I have a light blue suit. I've got a light blue shirt. I can do that. Light blue, dark blue. We'll figure it out. You guys have a good night. We'll see you in the morning. Bye-bye.
Thank you, sir. You're my new best friend.
Hear ye, hear ye, hear ye.
I don't like podiums, Your Honor.
There's nothing in the order that restrains you from talking to cats.
Thank you.